One day I mentioned this matter to you. That was the first day, after the summer. Lordship was of the view that went for a week, let me see how much I can count. My lord, my fishery has been reallocated to a person, my lord, having no eligibility since he is the sister of the Gormat. Absolutely, my lord, criteria was also not met. I have interacted to the secretary. See, I have made objection to that. Many man fix it.
Have each of you indicated the urgency in your slip?
Yes.
Hand over all the slips. I'll check the urgency and allot some time. All the slips. Take your time. Don't hurry. Hand over all the slips.
mentioning item number
My lord,
item number 42
As regards item number 42.
42.
42 of appellate side, please, Lord.
Yes.
Last Friday I mentioned before Your Lordship at the time of rising, Lord. Your Lordship told me to remind Your Lordship that if Your Lordship do not take this matter, Lord, at second half Your Lordship will
Mention at 3. If I can't take up the matter, mention at 3.
Lord,
3 p.m. 3
p.m.
Lord, may I
Deeply
mention
applied.
one matter from the circuit bench of Port Blair, Lord. Lord, I performed, Lord,
Yes.
a contract job in 2005. The contract was, Lord, I have to fix glue sign with bilingual written, English and Hindi. In 2021, they have, Lord, banned my business.
Port Blair, there is no other bench.
There is no circuit today, Lord.
No assigned bench.
No. The bench having jurisdiction will, Lord, hear it when the circuit is not.
Hand over.
Lord, kindly grant me leave. I will serve and come back on Lord, Thursday or Lord, tomorrow.
This is appellate side.
Appellate side.
Obviously, has to be appellate side. So please wait for some time, Mr. Chakraborty. When my appellate side officers are there, mention. I'll give you leave.
my lord,
Hand over everything. Yes.
number 2 of the
your lordship's kind leave to move and matter, my lord, extremely urgent, my lord. Indian Oil is the writ petitioner. The competent authority has passed an award, my lord, saying 6 crores and odd has to be, almost 7 crores, my lord, has to be paid despite, my lord, a previous, my lord, award saying tax has been paid. Now, my lord, 7 crores and odd has been directed to be deposited, my lord, within a month from 22nd May, I'm sorry, 22nd May, that is, my lord, 22nd of June. I mean, and they are writing reminder letters, my lord, the private respondent, whoever he is. I mean, there is some urgency. My lordship,
22nd June is far off.
Lord, may I file it with the number? Let it appear in its usual.
File it in normal course. It will appear in normal course as a motion. Definitely.
The motion, and my lord, if there is some urgency, I'll mention.
On 20th, I'll think about it.
Mine. Let it appear.
My lord, in due course it will appear. File it. You have given a number.
I'm
File it in due course.
Get the number.
No way. File it in due course. It will come automatically in.
The department will not unlock the.
Somewhere else, probably. No, Mr. Bhattacharya. File it in the normal course. Yes.
As your lordship.
Yes, my lord. This matter pertains to
All the inclusion matters. I am taking the slip. I'll decide when to give these matters.
My lord, this pertains to the arbitration application, my lord, in which my lord has appointed an arbitrator, my lord.
Whatever, just over. If it's a review application, then I'll have.
The learned arbitrator has declined to act as an arbitrator, my lord.
Before the regular day. This will go before the regular day. If he has declined, it will have to go before the regular. Please mention in the other code.
Grateful, my lord.
Your Lordship, serial number 2 of the e-mentioning, Your Lordship. This is the
Please hand over, nothing else. Please let me call. I'll give you 2 minutes.
appearing at 385 of the monthly list, Your Lordship. This is an order from a review of Honorable Justice Mosmi Bhattacharya, Your Lordship.
My lord, please, yes.
My lord, item serial number 2.
Upgradation. No upgradation.
My lord, maybe permitted. My lord, may be permitted. my lord, may be permitted.
Malika, Rajashri, come here.
Call on the list, please.
My lord,
Sufficient mention.
my lord, for release, my lord, I was under my lord, under most compelling circumstances, my lord.
Call on the list.
My lord, I am
State
praying.
matter item number 1.
One passing order.
Priya Dhot versus Bar Council of India.
Yes, in person.
My
is
lord,
appearing.
disconnection will be affected. My lord, the item number.
I've asked you to give handover all the slips. You don't understand plain English. I'm sorry, I am at a loss.
Upgradation, Mala, kindly take the matter seriously.
No upgradation, inclusion, please hand over. Item 1.
The matter has been fixed, my lord. This matter was not heard.
Item 1. Please leave the court. Leave the court.
My lord. My lord, kindly take the matter seriously.
Enough is enough.
That's the situation I am facing.
Yes, leave the matter. Enough of this. Yes.
My lord, for the bar council, my lord,
What is the matter?
You asked me to submit the letters to the Bar Council of West Bengal. I did that, my lord, and
You are for the West Bengal Bar Council?
lordship, lordship, no,
West Bengal or Central?
no, my lord, the central bar council, my lord, bar council of India, lordship.
Bar Council of India, no. You have given a good proper notice?
yes, my lord, I did. I told them verbally also and an email also.
Your grievance was, just remind me once, within limited time it was not heard. Within the stipulated time,
Within
it
the
was not heard.
stipulated time, it was not heard, and the Bar Council of India was not willing to take it up. And we are already going to enter the 17th month tomorrow, my lord.
Can you please give me a copy of the Advocates Act? Do you have it? Advocates Act ane din tak?
I don't have.
ये तो नहीं. Take it up after 3 or 4 matters. I'm bringing my Advocates Act and pass my order. Just I'm passing it over for a few matters.
Right.
Call on the next matter. Pass over thakbe.
Item number 2. Ashu Dhar versus the Assistant General Manager, UCO Bank and another.
Lordship, may I please your lordship, I'm for the rate petitioner. Lordship, I've been requested by the learned advocate representing the state, representing the concerned bank to seek for adjournment on his personal behalf. Kindly take it up tomorrow. I have
No,
notified.
not tomorrow then. An adjournment is sought on behalf of the respondent bank, full stop. None appears for the petitioner at the...
I'm for the petitioner.
Oh, you are for the petitioner?
Lordship, I'm ready with the matter.
You are for the petitioner?
Yes, Lordship.
Very well. Learned counsel for the petitioner, in his usual fairness, submits that his counterpart appearing for the respondent bank is inconvenienced today. So accordingly, let the matter stand adjourned till tomorrow.
I'm grateful, Lordship.
Item number 3. Uma Mitra
Yes.
versus the Directorate of Registration.
My lord, I will be for the private response.
Private respondent.
PK Roy. PK Roy.
Earlier on 2 occasions, my lord, matter appeared before the honorable coordinate bench.
None is appearing for the petition.
My lord, on the last occasion they didn't, but on the previous occasion they
Paid for adjournment.
prayed for an adjournment on the ground of the counsel for the.
It is seen from the records that the petitioner is. It is seen from the records that the petitioner is either seeking for adjournments or unrepresented when the matter is called on each of the earlier occasions. Full stop. Next para, even today when the matter is called on, none appears for the petitioner. Full stop. As a last chance to the petitioner to appear in the matter and move the same is adjourned till tomorrow.
I appear for the state, my lord.
Right.
Yes,
Vokalat na hua?
ma'am.
Why can't you file it in department? You can file it in the department.
Item number 4.
4, yes.
My lord,
Dipendra Kumar Sannal.
item number 4, my lord. I am appearing for the private, my lord, respondent number 3 and 4. My lord, it is page 2 of the cost title, my lord. It is evident that Monish Join, IAS, the principal secretary, has been made party respondent by name. My lord, before taking up the matter, most humbly, my lord, I am praying before your lordship, kindly direct that, my lord, his name should not be there, my lord.
Why?
Because, my lord, he is holding an office in the Vikas Bhavan. He is the principal secretary of the Higher Education Department. But by name, he has no role to play in this matter. Apart from that, my lord,
Has been implemented in the capacity of a principal secretary.
my lord, then, my lord, name
Would have been avoided, but why? Is he shy of his name?
my lord, my lord,
So what? Is he ashamed of his name?
my lord, I humbly pray before your lordship, my lord, petitioner is relying upon, my lord, on the decision in the year 2017. But, my lord, he has been appointed.
This person is not, he was not there.
Neither here nor there, my lord. He was appointed in the principal secretary in the Vikas Bhavan in the year 2019. So, my lord, he has no stake, my lord.
Yes, Mr. Bhattacharya, what do you say to that? You are for the petitioner.
Yes, yes.
If he was not there at the relevant time, why mention these people by name? Respondent number 4.
Respondent number 4, my lord. Page 2 of the cost title of the writ petition. My lord, he was appointed, my lord, on.
Mr. Chaudhary is right in that, in fact. The principal secretary of the government officer in that capacity has just to malign him. If I mean, why?
First,
I'll ask
principal secretary. Just principal secretary.
I'll do that and ask the name to be deleted.
That is
because he has not been made a party in his name. Then I'll direct his name to be deleted. I'll direct his name.
I'm grateful, my lord. And so far merit is concerned, my lord, why
there is nothing in there.
I will address, my lord.
There is nothing in there.
Nothing,
merit, there is nothing in there.
My lord, no merit is there.
Really, that will be a
against myself, my lord.
So you made a submission, let me hear.
Why it is
Achha, line first before proceeding further. At the outset, it is submitted by learned counsel for the respondent number 4 that the said respondent has been implemented by name, comma, although the person named as respondent number 4 was not in office at the relevant juncture. Full stop, next para. In such view of the matter, comma, let the name of the respondent number 4 be deleted, comma, retaining intact the designation as given therein in the cause title of the writ petition. Full stop, next para. The matter is taken up for hearing now.
When my turn will come, my lord, I will
yes, what is the matter?
I'm grateful, my
lord. Kindly looks into your lordship's previous order. Well, this is my, my lord, affidavits in terms of the previous orders, my lord. Affidavit of service. Oh, it's okay.
What happened?
Well, it is unaffirmed, but it has been served. I think Mr. Gupta is appearing.
Unaffirmed ki kono? 1. Finally, during the course of the day, have it affirmed? Yes, Mr. Bhattacharya. Yes, what was the that order? I mean, just indicate to me the. That matter. Yes, move your matter on merits.
Now, Lord, I had relied on the memorandum of association of this organization, IISWBM. This is that matter, where your lordship was of the view, prima facie. By your lordship's order, kindly see page 2.
Yes.
Relied on certain relevant provisions of the memorandum, including articles 38, 39, 44, and 46, to indicate that as the memorandum stood originally, the financial control was with the Board of Trustees, which has been sought to be taken away by the sweep of a single amendment by way of incorporating a clause as to dissolution of the Board of Trustees. Learned counsel for the respondent number 10 contends at the outset that it is not maintainable, etc. It is rightly pointed out on behalf of the petitioner that ex officio members of the Board of Governors, which is to be the beneficiary of the impugned amendment, is primarily comprised of members of the appointees of the state government and its different units. Hence, it cannot be ruled that the state has a vested interest in the outcome of the present challenge. Since the functions discharged by this IISWBM pertain to the field of education in the state as a whole, which is also one of the functions of the state, the objection as to maintainability cannot but be turned down in view of the challenge in the writ petition involving purely questions of law and an interpretation of the effect of the impugned amendment vis-a-vis the original memorandum of association, no further affidavits are required to be directed as effective service exception. Now, my lord, your lordship desired that I once again reserve, and in view of the appearance through counsel of the respondent of further services, the petitioner shall serve a fresh notice on the other absentee respondents, indicating that the matter shall be listed for further hearing on June 12, a further affidavit of service, etc. Now, my lord, this is the position.
Mr. Bhattacharya, please, 71 is the impugned clause.
My lord.
71 is the impugned
Yes,
clause. And your memorandum of association?
My lord, my memorandum of association, it begins
page 47.
at page 34.
Page 47 onwards, the relevant
My lord,
clauses. Right.
My lord, your lordship is absolutely correct.
No, you pointed out on the last occasion. That's
Yes,
why
my
these
lord,
have been
kindly
marked.
see-
Very well. Yes.
Kindly sees the trustees part is page 47,
Right, right.
paragraph 32 of the memorandum.
What did you
My
discover?
principal challenge
Why was the RTI Act? What did the RTI Act
RTI Act,
reveal?
through the RTI, I wanted to know
Yes.
as to whether this amendment, which was effected in 2017-2018, whether it has in fact been given effect to by the organization. The authorities in the state informs that the memorandum, there is no amendment carried out formally to the memorandum. There, my lord, I invited your lordship's kind attention to 32. Then, my lord, paragraph 44 at page 48, right side. 46. This was the and 48.
Yes.
Page 48.
These are
Now-
the empowering
yes.
the
The-
empowering provisions.
Yes. Now, my lord, one interesting thing is clause 44 would
Right.
show that the treasurer of this organization has to be from the trustees. And 47 presupposes, my lord, that the budget and everything has to be routed through the trustees. The final, my lord, decision insofar as the budget is concerned, my lord, is to be made by the trustees, subject to correction.
What was this 44? Please come to 44 once.
My lord.
Trustee shall appoint one of the members as treasurer. The treasurer for the time being shall be an ex-officio member
Of the Board of Governors. My lord,
He
that
is
is for the
continuing
time
still.
being.
He was still continuing.
No.
Not continuing. Very well. Yes.
My lord, prior to this, my lord,
Very well.
endeavor, my lord, the trustees, one of the trustees was the treasurer.
Very well. Yes. So anything we want to cite? Mr.
Now,
Bhattacharya? These are the clauses. Yes.
these are the clauses. Now, my lord, what prompts, my lord, us to, my lord, knock the doors of justice is page 60.
Knock the door off.
My lord, your lordship's court, my lord, page 66.
66. Yes.
My lord, this is
Depending on how loud you knock, Mr. Page 66. What is there?
my lord, it's a dissenting opinion of my client. My lord, before giving effect to the amendment, the dissenting opinion was also sent. Now the dissenting opinion was not considered.
And your client was the president.
My client was one of the trustees.
Trustees.
In fact, he was, my lord, please see page 73. Held on 5th August 2016, a meeting of the minutes of the Board of Governors meeting. My lord, kindly see item number 3.
Yes. So legal opinion was sought and given.
Before that,
Yes.
page 75, I invited also your lordship's kind attention. My lord, this is the resolution. There was a committee which was created, which included me also to go into this issue. And apart from me, my lord, all other committee members, my lord, considering for whatever reasons, my lord, I do not say. Maybe, my lord, the helm of the affairs was one person, my lord, and therefore no one wanted to, my lord, go against him. And therefore, my lord, this decision was given shape to 73. Opinions were sought for, and ultimately, my lord, the opinions gave shape to the ultimate decision, which is impugned. Now, my lord, this decision which was adopted or arrived at apropos the opinions, my lord, is not in accordance with the memorandum of association. My lord, in the opinions which were sought for, with deepest of respect, my lord, the opinions were given by very esteemed persons, my lord, but their brief, if I may say so, my lord, was a tailor-made one. The
Opinion is win. Let us not criticize opinion. It was the opinion. What is bound by
opinion, but my lord, presumably the brief was as to whether this can coexist, my lord, without
it was a legal opinion, Mr. Bhattacharya. Everybody is
I'm
entitled.
not saying anything.
Yes.
Now, my lord, the fact remains that in the form by this endeavor to, my lord, do away with this board of trustees, what has happened is, my lord, the basic structure of this organization has been, my lord, set at naught. My lord, the basic structure presupposed, my lord, existence of the board of trustees and the board of governors together. And my lord, the budget, everything had to be routed through the trustees. My lord, trustees had some not wheeled role, an active role, if I may say so, my lord, with respect to play in the, my lord, scheme of things, insofar as budget particularly, insofar as finance particularly, insofar as entering into agreements particularly. My lord, all these things wanted to be, my lord, these persons apparently were not ex officio members, the trustees. They were there because of their, my lord, academic excellence or, my lord, any other vision, my lord, that they had to share with the organization. Be that as it may, my lord, by giving effect to this opinion, my lord, a unilateral decision was arrived at by the board of governors, completely, my lord, doing away with, my lord, seeking to amend the relevant clauses of the memorandum of association. In the process, my lord, do away with the board of trustees altogether. Now, my lord, I write to, my lord, the government seeking opinions, my lord, at page 92. And the opinion, my lord, this is the answer of the government. The government says, my lord, the additional registrar of firms and societies writes to us apropos my application or our application made under the Right to Information Act, my lord, made by me. As per available record, there is no alteration of memorandum of association and regulations of the society named such and such. Please read, etc. My lord, the query your lordship will be pleased to find at page 89. This being the factual position, my lord, I respectfully submitted before your lordship through my senior, my lord, I'm like being led by Mr. Bose. What? My lord, that insofar as financial aspect is concerned, your lordship was, my lord, it fell from your lordship on last Monday when the matter was taken up, that your lordship will clarify the position. That was the oral observation made by the court regarding that this board of trustees, it cannot be done away with, my lord, and it's a pure question of law. Now, my lord, I only respectfully submit that, my lord, our position should not be disturbed. Let us function as we were functioning for the last 52 to 2017, 55 years.
You as in the trustees.
The trustees. The trustees, let them function as contemplated by the memorandum, as contemplated by the rules and regulations. And, my lord, let us function in tandem together so that the institution, my lord, shows its excellence in the field of education, management education in particular. My lord, Mr. Bose,
yes, just a few points. I want to show you some of the clauses of the memorandum. Some of them have been shown. I just want to show you the objects and reasons. My lord, I have noted it down. Will you just take the page numbers one by one, my lord? My lord, the first is the object, my lord, clause at page 34, III. My lord, it is small one. It has acquired the assets of All India Institute of Social Science. Has your lordship found that at page, my lord, 34? How the society was formed. My lord, it is by acquiring it is
page 34.
Yes, my lord, 36, sorry. II at 1, small 1. It acquired, take over existing institution. All yes. This is how, my lord. Then kindly come, my lord, to small e, next page. It is to organize specialized teaching in different branches of business management and giving diploma courses. Institute, the Calcutta University is also involved. Now, my lord, kindly come to IV. my lord, which is, my lord, my lord, IV. Yes, my lord, IV is at page 38. Yes, kindly see, my lord, the income of the institute, however derived, shall be applied only for the purpose objects of the institute as set out, and the profits of the members claiming, provided nothing herein shall prevent payment in good faith any remuneration. My lord, as is commonly known, my lord, in the Societies Registration Act, if a society is dissolved, the profit does not go to the members. It is, my lord, I will show you the object where the profit will go. That is what my intention is, my lord, to show. Suppose you do away with me, you do away with the governors, dissolve the institute, where will the profits go? My lord, the income, the assets, where will it go? Now, my lord, kindly, my lord, see page 39, my lord. This is the name of the executive committee at the time of registration, and you will find Dr. B.C. Rai was there, Biren Mukherjee, my lord, and the last name is important. My lord, it is the father of the petitioner, who is now 87 years old. He is 87 years old. Then his father was there.
Petitioner is 87. Petitioner's father is expired.
No, petitioner, I said, petitioner is 87 years old. He has come in subsequently, become the head trustee. But, my lord, he was, the K. Shannal was director of this business management, my lord, at that point of time. Now, my lord, kindly come to page 40. Page 40, who are the founder members, will find, my lord, the same, Lakshmipad Singhania, Biren Mukherjee, my lord, and all these names are there. And D.K. Shannal is also there, the father of the petitioner. Now, my lord, then, my lord, kindly come to page 41. This is important. The Board of Governors, may elect such persons as may think to be life members. And who will be the life members? My lord, your lordship will find, at least from I to, most of them are government, from the government. My lord, at least from VIII. My lord, from the government. And, my lord, kindly come to page 42. My lord, page 42, the administrative and management. This is important because of the dichotomy between who owns the assets, my lord, of the site. And you will find there is not a whisper that the ownership of the assets rests with the governor. The clause which says, in this particular thing, they can dispose of the assets. But, my lord, a subsequent clause says they must take consent of the trustees. Now, my lord, you will find that in 3 small a, 3 small b. My lord, kindly see, my lord, subject to the management institute, the regulation shall be vested, the management should be vested in the institute. And, my lord, just, my lord, in case your lordship, the dichotomy is B small I, that they can sell off the assets. So, in presumption, my lord, they own the assets, my lord, they own the assets. No, that your lordship kindly is clarified in, my lord, rule 4. I'll just place the subsequent rules. My lord, in page 443, the number of governors shall not exceed 24, including the president. And you will, lordship will find in rule 6, who is the president. The former president, my lord, was Dr. B.C. Rai himself at that point of time. And, my lord, the director of institute, my lord, I-11, which was the father of the present petitioner, my lord, was there, over there. And then, my lord, comes, my lord, 7. There was an amendment in 1966. And, my lord, the members of the Board of Governors will constitute of 3. P.C. Sen became president. My lord, P.C. Sen, my lord, at that point, 66. My lord, and you see again, my lord, who are the, all, my lord, government. Most of them, my lord, are government officials. My lord, is the Board of Governors. Now, my lord, kindly come, my lord, kindly come to rule next page, internal page 17, my lord, 22, 23, 24. That, my lord, is page 44 itself. My lord, who will also be part of the members of the Board of Governors? My lord, one is the director of the institute, come secretary, ex officio, treasurer of the institute. My lord, they are the two members who will have to be there, my lord.
But treasurer also has to be from the board of trustees.
Yes, my lord, that is exactly what I intend to show your lordship. Now, my lord, kindly come to my lord, small 8. How election of board of governors is done. The members of the board of governors representative other than Dr. B.C. Rai will be, my lord, will retire. So B.C. Rai, as long as you are alive, this is the report. We had our faith in our first Chief Minister of Bengal, my lord. My lord, kindly see page 47. After all this, the trustees. And it is very important. There was this is the amendment, my lord, up to 93, the board of trustees are being constantly amended. Constantly amended. And you will find the name of Dipen Shannal, the father having expired, now 87 years old, petitioner, is there, my lord, in the board of trustees. And these were the names, because the last amendment I find, my lord, is of 93. Is of 93. My lord, in the bottom, my lord. Then, my lord, rule 34, you will find the trustees shall appoint one of the members as president, but so long as Dr. B.C. Rai is alive, he will be the president. Peculiar. Then, my lord, 38. The trustees shall spend, my lord, this is important. Please have a note to this. Who will spend? The trustees shall spend money or transfer or deal with properties. My lord, keywords. Where are the properties vested? Vested in them. And execute document or documents as the board may determine. The concurrence of trustees shall be necessary to sell, encumber, lease. Concurrence.
So how do you reconcile this clause with the other one you placed at the...
Not vested. Not vested. They will sell. They are in the management of...
Shall have power to sell and dispose of the property
Correct.
of the institute.
Correct.
How do you reconcile the two?
My lord, it is the
they can sell,
but with my consent.
Good.
That's it. That's only that.
Good.
My lord put it. That is the only thing I want.
Right.
And therefore I said vested. I said vested. My lord, 39. My lord, that's why I showed you the clause which is against me.
No, absolutely.
Yes.
Why not?
39. The trustees shall invest. My lord, who will invest? The trustees will invest and realize all income, rents, properties, also realization, pay all outgoings. My lord, my lord, this is clear. This is the then, my lord, kindly come to 42. Kindly see 42. Clear, my lord, the properties of the institute movable shall be vested in the board of trustees. Nothing can be clearer. My lord, kindly come to 43. The trustees shall meet together, occasion transact, and my lord, yes, 44 is it was introduced by way of amendment in 66. Trustees shall appoint one as treasurer. The treasurer shall be ex officio. My lord, I showed you that clause, my lord? Yes. Then, my lord, kindly come to 46. This is the most important. My lord, the director of the institute shall prepare the annual budget of the institute, shall place it before the board of governors. The board of governors shall consider the budget and indicate their views on it. The budget with the views of the shall be placed before whom? The board of trustees. And my lord, kindly see, my lord, at the last 4-5 lines, board of trustees shall finally prepare budget along with their views of the members of the institute. And my lord, a peculiar section, clause 50. Basically, no power, but some powers. My lord, in case, this is important, 50, just look at this, my lord. In case budget is rejected in the preceding clause, governor shall be competent in spite of to spend money, such sum, but may not for the institute. For the institute. My lord, then, my lord, yes, rule 51, my lord, page 4.
Salary payment.
Yes, salary. My lord, page 51. My lord, kindly see, this is the, rule 51. This is important, page 49. My lord, rule 51. The director shall be principal executive. The board of governors may determine function. First director will be D.K. Shannal, which is, my lord, petitioner's father. My lord, has your lordship found?
Yes.
Yes. And my lord, what happens upon dissolution? Very important. Clause 58.
Mr. Bose, his father was a director. How is that relevant? I mean,
My lord, I have
what to mean it's a hegemony?
no, not hegemony. My lord, it is from,
So,
he was the, it
He
is
is from an
he is
illustrious
from that institute.
from an illustrious family, maybe, but
No. It was from the old institute which was taken over, where he was the, it is his brainchild.
his father's.
His father's.
True.
Fathers. Thereafter, I have stepped in.
Brainchild versus child.
No,
So how
no,
can we
child,
equate the
man, brain and child. You are right. My lord, if the pun in the word.
There's a brain in brain,
My lord,
which is not there in
my lord,
child.
this reminds me of my university days, special presidency. All these puns used to go on. Brain, child, my lord, like your lordship is
No, but even then, that
no,
pun
nothing,
applies here. also.
nothing. My lord, it's just to show at the age of 87, I am only interested to protect the institute and the funds of the institute. That thing more, nothing less.
Fair enough. Yes.
My lord, someone has to come in. That's what I told you the previous day.
Get your point. Yes.
Now, my lord, kindly see if it is dissolved. This is what is happening. And then, my lord, kindly see page 69 at 71. At 71.
I think we should look into 58 also once, Mr. Bose, before we proceed. Page 50, that article 58 or clause 58. This society is the
Clause 58. Yes, I showed your lordship.
Yes.
Achha,
this also.
My lord.
So this will go to the University of Canada naturally.
University. My lord, if you look up the Societies Registration Act, whether Society Registration Act 1860 or the 1961, because as you know, my lord, under the West Bengal Societies Registration Act, under section 36, probably, my lord, everything which was registered under the Societies Registration Act is deemed to be, my lord, under this 1961. There's a clause, I think, section. I have got it. If you want to,
page 71, Mr.
Yes. Place 71 at 69 at 71.
Right.
My lord, I am challenging this particular resolution. My lord, all I want is that this item, the president opined that legal expert that BOT does not have legal justice, so should be dissolved. My lord, this should be dissolved. Now, my lord, this has not been given effect to, my lord, that your lordship will find at page 92
Mr.
and 86. My lord, I am getting funds from the government. 86, just to show that, my lord, whether RIT is maintainable and all these things. I've showed you half of the clauses. Now, page 86, to show your lordship, my lord, page 86. Just, my lord, have a look at this. Yes. My lord, kindly see the funds are granting aid, etc. is coming from the government. Because no one can exist, my lord, in the state of West Bengal without the funds of the government. My lord, because that is how an institute will, at the end of the day, survive. My lord, one more clause. My lord, kindly see page 97. This is the balance sheet of the institute prepared on 31st March 2021. You will find at my lord 98, the Board of Trustees fund is still being recognized. My lord, has your lordship is still being recognized. I'm still there. My lord, all I want is the status quo be maintained. We have existed for 60 years, side by side. Don't throw me aside.
Mr. Bose, one last question. Why isn't this premature, this petition?
This is not, it is, my lord, I am coming at a stage, I am, my lord, I have said.
Not given effect to
my lord, paragraph 24.
Yes.
My lord, so long I would have protested and challenged all this, but I'm mesmerized, my lord, by the influence of 24, of respondent number 2. My lord, he is calling the shots. He was. And probably now, nothing will happen. Probably, but we're scared if something happens.
And the 24 of your
petition. Yes, I think 24.
Oh, that's it.
No, I think 24.
Yes, 24.
Probably now nothing will happen.
You're using this for everything, Mr. Bose.
Oh, what can be done? It is, no, it's not that.
Re-challenge.
I said whoever comes, but don't dissolve it And you have to one more thing. Trust is need not be created by any legal document. Trust can be oral trust. Who is in possession? I have a document which is registered under the Societies Registration Act. Members, where my constitution, my vesting of property is recognized. That is enough for for creation of a
Mr.
trust.
Post trust, that portion may be a bit diluted because in this case,
of course,
because a board of trustees
for management,
right? Now that is not equivalent to formation of a trust. This is not a trust.
Board of governors
This is
not
society.
This is society.
Yes.
But there is a trust. There is existence of a trust recognized, by the society's this document. Unless you completely amend the rules which you are
Goes to the root of the.
This will exist. This will exist. Yeah.
Thank you, Mr. Yes. Mr. Chaudhary, you are for? Who is the contesting? Mr. Gupta or Mr.
My lord, my lord, I appear for the respondent number, my lord, 3-4. My lord, my contention is this, my lord. My lord,
you are not appearing for 2?
No, my lord, I am not appearing for 2. My lord.
Why?
My lord. My lord, I am not appearing for. No, my lord, I am not. I have not been instructed to appear on behalf of. My lord, I do not know, my lord, who will appear for respondent number 3. My lord, I appear for the respondent number 3 and 4.
3 and 4.
My lord, my contention is very small, my lord. My lord, I want to draw your lordship's kind attention that, my lord. My lord, it is a self-financing institute affiliated to the Calcutta University, constituted by a resolution of the Calcutta University without approval of the state government. This is my first point.
Right.
No approval of the higher education department is there. So, my lord, humbly, my lord, I submit, my lord, I am neither here nor there. So, my lord, I cannot be a party respondent in this matter. I mean, my lord, respondent number 3 and 4.
What about the finances?
My lord, finance, my lord,
you have no role to play?
I have no role to play. My lord, I never attended any meeting. My lord, most surprising thing, my lord, I will show. Then, my lord, point number 2 is this, my lord.
So why are 3 and 4 included, in fact? What is the logic of including them? According to
I don't know, my lord. No logic is there, my lord. It is absolutely, my lord, bogus, my lord, in my shortest submission. My lord, my lord, after receiving the copy of the application, my lord, respondent number 3 and 4 become surprised. They're neither here nor there. It is the matter between Mr. Gupta's client and Mr. Bose's client, my lord. My lord, I have no role to play. I never attended any meeting. No consent was taken from myself. My lord, if your lordship, my lord, kindly see, my lord, I have taken specific instruction that the gentleman, respondent number 3, Monish Kumar Jain, my lord, never attended any meeting of Board of Governors, my lord.
His name has been deleted, that's why.
Yes, my lord, but
by name he is not no longer.
Yes,
but even by office, you say he has no role.
I have no role to play, my lord.
Right.
My lord, unnecessary, my lord, my lord.
Get your point, Mr. Chaudhary. Why repeat it? Let Mr. Gupta submit now.
My lord, one more point, my lord. I am not, one more point.
Need to stress any point in my
case. If your lordship, my lord, kindly take your lordship knows much better than me, my lord.
Even then,
West Bengal Society Registration Act 1961. There is a clause, my lord, member. My lord.
No, read out for me, Mr.
My lord,
I don't know so much. As you
member means, my lord, when used in resolution to a society, means a person who has been admitted with his consent. My lord, I am just placing before your lordship 3 words. Admitted with his consent, 4 words. My lord, my humble submission is this, my lord, from 2 gentlemen or, my lord, the department which, my lord, I am representing, no consent was ever taken, my lord. So, my lord, my lord, cannot be a, my lord, party respondent in this matter. I mean, my lord, respondent number 3 and 4. By virtue of their post also, my lord, not by name.
Ex officio, they are not part of the team.
My lord, I am nobody. I never participated in any meeting. My lord, I never given any consent to be a member. My lord, I am nobody. And my lord, the resolution which was adopted in the year 2017. And my lord, I, the principal secretary, respondent number 3, joined the office, my lord, on 1st August 2019.
Joining office becomes irrelevant the moment I delete your name.
Yes, my lord. I am deeply obliged, my lord. My lord. Against my post also, my lord, these
post you have made your submissions. Yes.
There is no allegation against myself. Unnecessary, my lord. the department is appearing before your lordship. My lord, kindly expunge the name, the respondent number 3 and
I'll
4.
explain the name as well as the appearance there.
As per, my lord. My lord, as per your lordship, my lord.
Very good. Yes, I get your point, Mr. Chaudhary.
My lord,
Mr.
I'm grateful.
Gupta, you are the main culprit, in fact, quote unquote.
My appearance.
Amitabh Chaudhary. Who is appearing with you, Mr.
My lord, one more point I want to add, my lord. I have been instructed to submit
Very
to
well,
your lordship
submit.
most humbly, my lord. My lord, it is a, my lord, purely, my lord, private. But, my lord, in favor of private institutional education, government gives some aids, some from time to
Some?
time. Some aids, my lord. Grants.
Yes, aids, I understand.
That, my lord, the department provide. That does not mean, my lord, that this is a government institution.
It's one of the guarantees.
Very good.
He is one of the grantees. No nexus, my lord. I am nobody, my lord, in this matter.
What happens if you stop the grants?
My lord, if we, my lord, think.
If you think and do it,
My lord,
if
we
you
can
stop
do.
the grants tomorrow, what happens?
Nothing, my lord.
It will be able to function.
My lord.
What's his source of income? It's the institutes? Self-finance, I understand. What are the sources of income?
That I don't know, my lord. I have no role. From, my lord, from
Management
student fees,
institute, what is the
from
self-sourced finance?
Student fees and, my lord, others. Huge amounts of fees, my lord, they collect, my lord. Huge amounts of fees. My lord, there is a quarrel between, my lord, who will take the money, he or he, his client or his client.
That is one of the few factors responsible for everything.
Money is the, my lord,
It is not going to that.
main problem, my lord.
Very well. Mr. Gupta, yes, now Mr. Gupta.
My lord, I don't go by any financial aspects.
No, need not.
My lord, if your lordship kindly takes what is the subject matter of challenge. My lord, a resolution taken 6 years back at page 71. At page 71, this is a resolution, my lord, taken by the Board of Governors.
Right.
You kindly take page 69, your lordship will get the date. This is 30th of May, 2017. That is the date, my lord. It appears from page 69, and kindly take the relevant portion of the resolution at page 71 against agenda item number 9. Report of the legal expert and Board of Trustees. The President opined that as reported by the legal expert, that in the absence of a deed of trust, which is fundamental for the existence of such a body, Board of Trustees does not have a legally justifiable place, so Board of Trustees should be dissolved and Board of Governors will continue.
Mr. Gupta, since I know you are very thorough, have they given any explanation for the delay in the writ petition?
No.
Not what the name. Very well.
Now, my lord, this is, apart from the question of delay, my lord, it says, my lord, the President opined.
Yes, that's there.
My lord, this is not, my lord, because an amendment of a memorandum of association or the rules and regulations, that cannot be done by the Board of Governors itself. It has to be placed before the entire body of members.
Mr. Gupta, what is the relevant rule for effecting amendments? Is there anything in the memorandum?
Not, yes.
Clear, is there regarding amendment that it has to go through this process or any other?
But in the Society Registration Act, there is.
In the Act.
In the Act.
Yes.
Act and the
Right.
And we are, that requires that it has to be passed first by the 3/4 of the majority of the members. And thereafter, we are placed before the statutory authority who has to approve it, then only it becomes an amendment. Therefore, amendment has not taken place. 17, that was merely an opinion. It merely says, the resolution itself says President opined.
Yes.
That this be done. No follow-up action. And this was ratified also. In the second meeting, he said, yes, go through. Go along with this. But no step is taken. Your lordship will take it, my lord. I record my submission that after this, no step, my lord, for placing it before the total number of members in the annual general meeting, and thereafter placing before the statutory authority, no such step has been taken. And that will be apparent also, my lord, from page 92, placed by Mr. Bhattacharya. Page 92.
92, yes.
Page 92.
No alteration.
No alteration.
That they are relying on.
Therefore, my lord, I will humbly submit that possibly we need not go into the merits of the matter at all, because it's totally inchoate document. What is under challenge? My lord, this is totally premature writ petition. When no amendment has taken place, how do you challenge it? No amendment has taken place. My lord, possibly the institute did not think it necessary thereafter. Nothing has been done pursuant to this resolution. This is the first aspect. Secondly, your lordship will kindly note this. First of all, is my lord 6 years unexplained delay. Secondly, my lord, this resolution has not effected amendment. Therefore, no amendment has taken place. Therefore, it's premature. My lord, the third is, my learned friend is contending that the board of trustees have certain rights. The board of trustees are not before your lordship. This is not before your lordship. My lord, only one person who claims to be the chairman of the board of trustees has filed this petition. Now, kindly take, my lord, page 47. Is a part of the rules and regulations.
Yes.
Rule 40 at page 47, right hand side.
Yes.
Resignation or retirement of a trustee, procedure for filling up vacancy. Whenever a trustee or any person appointed a trustee resigns or retires with the consent of his co-trustees, or any trustee, either original or substituted, dies or is absent for a continuous period of such and such, etc., a new trustee may be appointed towards the end of this, just before the II, etc. A new trustee may be appointed in his place by who is to appoint? The trustee who has resigned or retired is not relevant here. My learned friend says Mr. D.K. Shanal, senior Mr. D.K. Shanal was there. He died, and his son became a trustee. And B, by the legal representative of the trustee, original or substituted, who has died. Therefore, in the case of a death, who among the legal representatives is to be the trustee? Whoever are his legal representatives, they will have to choose among themselves a person who is to be a trustee. Whereas a self-appointed trustee is not a trustee.
But these are disjunctive or.
Exactly. But under which clause he comes? He doesn't come under fit in.
From the submissions, it appears from clause A.
No, from the submission it appears that clause B.
Achha.
Dead, in case of death. He says, my lord, my father died, therefore I became a trustee.
Oh, not resigned or retired.
No, not retired.
Yes, right.
Therefore, my father died, therefore in his place I come.
Right.
But he cannot come that way, as per the rules and regulations. He has to be chosen by all the legal representatives of the deceased trustee. And this has not been done, this is not pleaded even. Therefore, what is his locus? You know, the board of trustees is constitution, whether it is properly constituted or not, that's a different matter altogether. That's not part of the present proceeding before your lordship. Regarding that, we can all apply our minds subsequently. But that's not the issue. The issue is whether the resolution of 30th May 2017 is proper, legal or not. I say, Miller, that resolution is not a legal, it does not create or destroy any legal right of any person.
Mr. Gupta, you have a strong point in the premature argument, but the other aspect is if it is still alive. I mean, if you say it has died a natural death, I can record that that's a different proposition altogether. But if you say it's alive, although not implemented as yet, then it remains a live wire.
Alive means?
Alive means it may be implemented even now. If it can be implemented even now, then it remains. The force remains.
Milord,
of the opinion, whatever it may be what.
Milord, when did the death take place?
If you say by natural course, if it did, If you don't say that, you have to satisfy me, in fact, how it died its natural death. Otherwise, Mr. Gupta, what happens, it remains, the resolution remains.
Resolution remains, the resolution.
But even then it's premature, you're saying. Nothing has been done on the
nothing.
basis.
And I do not say the Board of Trustees doesn't exist. I don't say that today.
No, you are rather admitting in the reply to the query
Yes.
that they are functioning till now.
They are there, but whether their constitution is legal or not, that's a different matter. We shall take it up later on.
Oh, that's a different.
That's a different matter, and we shall take it up later on. It has to be, because this has just now come up. In course of our conference, it came up that how can he be appointed? He doesn't fit in as per the provision of this rule.
Mr. Gupta, he was a legal representative of the trustee.
No, appointed by, not appointment of.
Right.
By.
So one cannot appoint himself on
exactly. He's a self-appointed trustee. And will not kindly also note that the Board of Trustees has not come up before your lordship.
Mr. Gupta, although it's irregular, why can't one appoint himself?
Because it says, my lord, by the legal representative, he cannot take away the rights of.
I am a legal representative. I am the sole legal representative.
But
I have to appoint somebody. If I appoint myself, what is the bar?
Bar is, my lord, that
at the best improper.
Other representatives may be interested.
If I am the sole representative only, legal representative only.
Only in that situation. But not if there are two or more.
Suppose if there are two, I appoint myself, then and nobody else objects within their knowledge.
They may not be aware of this.
But this is in the realm of maybe.
No, it's not the question.
But even then, he has to satisfy that he was appointed.
He was appointed, my lord, by somebody. He cannot be self-appointed. Appointed by the legal representatives.
Now, I'm going to the root of it. Why can't he be self-appointed? Despite it violates rules of ethics. We are not on ethics. We are legally speaking.
Yes, legally.
Yes.
My lord, legally, every legal representative has the right to be appointed.
Provided there were other legal representatives.
Provided there are. My lord, there is no pleading that there was no other representative. And he doesn't say, my lord, that I was the sole representative.
Has he pleaded, Mr. Gupta, in his writ petition that he was ever appointed under this?
No.
No pleading. That is vague in the writ petition. Very.
Therefore, my lord, I kindly take note. First of all, this is belated.
6 years. Second is no amendment, so premature, no cause of action as yet. Thirdly, locus standi.
Locus.
Board of Trustees itself has not challenged, and this person, he has not even been appointed as a member of the Board of Trustees.
He doesn't have a locus.
So he cannot represent the Board of Trustees also. These 3 points.
Yes.
Very good. And on merits, can you do anything regarding this? I mean, is there anything to argue at all? If I go to the
possibly, I should not.
Need not. Very good.
On merits, one thing I may submit. I just give a hint.
That will invite my findings on that also.
Exactly,
probably, which may be detrimental to either side.
I said no, I should not argue. Because it will then come up on the court, my lord, to make some findings with regard to that.
True. Very good. Very good. So let us reply on let them reply on this. Yes, Mr. Bhattacharya. First reply on Mr. Chaudhury's submission and then Mr. Gupta's. Why should 3 and 4 be parties at all?
They are not in terms of page 39.
May I take your lord's kind leave? May I take my lord's kind leave?
Oh, absolutely. Yes, Mr. Gupta. Yes, Mr. Does these people come in?
Yes. 8, serial number 8.
8.
Secretary to the Government of West Bengal Department of Education.
Department of Education. For that, the minister in charge of education.
Ex officio members kindly sees page 41.
Yes.
Mr. Chaudhury.
Secretary is one of them. Right.
Mr. Chaudhury perhaps has.
Mr. Chaudhury definitely is not one of them. His client is.
It escaped his notice. Page 41. Ex officio members include the secretary for the time being to the Department of Education, Government of West Bengal.
Right.
The Vice Chancellor of the.
What about the minister in charge of higher education?
He was the self-appointed president.
You wanted to rope him in to vitiate the
previous incumbent. The previous incumbent, my lord, he was he was the president of this organization. Page 69, kindly see. Page 69, kindly see.
69 years.
Who is in the chair at the top?
It is his own capacity. It is his own capacity. Our education department is nowhere related.
I did not disturb him. Let him know. He has made his submissions. And he is not even representing the minister, he said.
He's for 3 and 4, both.
He is representing the minister.
He's not representing 2, but representing 3.
3 and 4, my lord.
But you're not representing 2.
No, never. 3 and 4.
2 is no longer 3. 2 is no longer 3.
No,
my lord. He is. No.
But then it's all right. Yes. Yes, Mr. Bhattacharya, he is correct then.
Dr. Sujit Basu is presently the president of this organization. Dr. Sujit Basu.
3 is not a necessary party at all.
But he was an he's an ex officio member of
that person was. 2 was. 2 was. Undoubtedly 2 was. 3 wasn't. 2 was the person. 3 was the office.
Yes. But I'm talking about 4.
4 years. 4 we say yes. I find it from here.
An essential part of this.
Very. What about Mr. Gupta's arguments?
But no consent, my lord. 1 minute, my lord. No
There's
consent.
the question of consent. He's ex officio. What consent?
Take your seat.
Consent.
Whatever your client says, take your seat. You're in a court of law, not in a drawing room of your client or yourself. Please take your seat. Yes.
Now, my lord, a submission was made by Mr. Gupta first. My lord, I'm not.
Submission is delay 6 years. What is your answer to that?
My lord, I have explained it. Paragraph 44, 45. And Milan, in particular, 51 at page 19. Well, I am very much. I am very much.
You're taking advantage of this person's plight.
Well, I am saying this in a. It has been admitted.
This person may have been indicted and whatever.
He ignores whatever statement.
That is the premise of your.
It has been argued that the board of trustees has in effect not been dissolved.
No.
If it is so, then then I will request my learned friends to kindly apprise your lordship, regarding my averments at page 14, paragraphs 35, 36, and 37 in particular. I'm reading it for your lordship. Despite adopting an illegal resolution to dissolve the board, the approval of budget of the board of trustees was passed in the annual general meeting held on this. However, owing to the illegal decision to dissolve the board based on a stage managed legal opinion, the issue has not been referred to the board of trustees at all. This is one. Thereafter, the respondent wrongfully, illegally, and in a maleficent purporting to prevent the petitioner, who is members of the board of trustees, from functioning, dishonoring the provisions of the memorandum, etc., the same which has been operational and has been existing since 1958. Then 38. That the meeting of the Board of Governors was held on 10th December 2018 after almost 18 months, where they audited accounts for the financial year such and such, the budget for the financial year such and such.
Mr. Bhattacharya, these have no connection with that. Because if the board of trustees are not being permitted to function, that's a different cause of action that the board of trustees has to come up and say, I am not being permitted to function despite I continuing as a valid board of trustees, which you are continuing.
That is exactly what.
That does not entitle you to challenge a purported proposed amendment dissolving the board of trustees.
With respect, the amendment, though it has been, suggested and submitted before your lordship that the amendment at page 71 has not been given effect to, or is still not seen
He
the
says
light of
that
the
I
day.
have to record that. Yes.
But the fact remains, that may be so, that may be according to me also, that in pen and paper, this amendment has not yet been carried out.
No.
Because subsequent developments in the accounts and everything. But the fact remains, we are not being permitted to function.
They may have other objections regarding your constitution,
Now here,
which they are having.
here,
according- Yes.
my lord, our issue has also been raised, my lord, regarding my locus, regarding who I am. My lord, the fact remains, I have been recognized as a trustee and I am the chairman of the board of trustees. That is the first paragraph of the writ petition. Paragraph 1. I have
How
described.
were you appointed?
My lord, I was appointed in the, my lord, process, my lord, earmark. My lord, I have not indicated that. My appointment was never in question. My lord, how can my dissenting opinions even be considered if I am not there as a trustee? I am a part of all meetings. Page 69 will also show that I am a part of the meetings. 69 onward, my lord, page 66 kindly sees. If I have described myself as a trustee in a dissenting note, my lord, I put this question entirely to myself. Can it, my lord, now suddenly dawn on them that I am no longer a trustee and my trusteeship is in question? It cannot be so, my lord. They have recognized.
They are saying that when you file a writ petition, you have to establish your locus standi.
Undoubtedly, my lord, my locus.
Your paragraph number 1 is there. I can
Yes.
appreciate that.
My lord, my paragraph 1 says that I am the chairman of the board of trustees. Apart from that, my lord, on behalf of the trustees, I have written to them. My lord, I have written to them.
Have they recognized
52.
you? Have they recognized you?
But
Anywhere?
they-
Show me that only.
My lord, I just give me a moment.
Or replied to you in the capacity of
My
a.
lord,
Yes.
if your lordship, my lord, at page 75, a committee has been constituted where I am a part on this issue of BOG and BOT. Please see item number 3. If I am nowhere, then how can I be a part of this committee? And kindly see item number 3 at 73. I'm sorry, 75, my lord, kindly see. I'm
75,
sorry.
75, yes.
75,
And the-
just below that. The committee members, with the exception of Sri Shannal.
So they were there also.
Yes.
Well.
So, my lord, it is not that, my lord, I am a person, my lord, completely alien to this organization. And I have, my lord, my only endeavor is adhering to the rules. The memorandum, it's not the question of, my lord, as suggested, my lord, there's no question of financial, I have not even alleged financial defalcation or anything of that sort. What they are trying to do is, my lord, completely keep me in the dark and manage the finance in their own way. That was the endeavor in 2016, 2017, which gave shape, my lord, to the legal opinions which were sought for. And ultimately, my lord, at page 71.
Mr.
Lord-
Bhattacharya, when was this respondent number 2? When did he become the president or whatever? When?
My lord, he was the president, my lord, sometime in between 2014 and onwards. My lord, I have to take
2014 and
instructions on that.
2014 and onwards. So before this resolution,
Before
the
this
resolution was
yes,
taken
yes.
in during his tenure.
100%. My lord, the entire thing, my lord, if I may say so, please see 73. 73, it begins. 5th August 2016. My lord, item number 3 is the resolution. The board accepted the committee. Honorable President, however, suggested. My lord, this is how it, my lord, gave way. My lord, this was triggered, if I may say so, because, my lord, the board of trustees were not towing, my lord, every decision of the board of governors. Because, my lord, board of governors, my lord, kindly looks into who the persons are. I am not blaming any one of them. They are very, my lord, essentially, they are all academics, my lord, brilliant in their own field. But the fact remains, my lord, at certain points of time, my lord, some things, my lord, need not be said or cannot be said, my lord.
No, all of them, including the president, were brilliant in their own field.
Undoubtedly. Undoubtedly. Well, incidentally, I had the occasion to represent the president also at some point of time
Naturally.
in some other matter.
Good choice for him.
And at some point of time, in some other matter.
Yes.
And Mr. Chaudhary is not representing him because he wants to say that I do not know him, but I know him, and I have appeared for him.
Anyway, that does not castigate you. So I'll reserve judgment on this. Regarding the maintainability point also, that is also kept open. I mean, the locus standi and all.
Yes, yes. I'm sorry. I'm sorry, Milord. Just another page, Milord. I'm extremely grateful to Mrs. Bhatia. Milord, please see page 65 once, just once.
Absolutely, yes. 65, what do you want to?
Milord, report of the legal expert on Board of Trustees. Milord, just this. Mr. D.K. Shannal, Treasurer, submitted his note of dissent. So, Treasurer presupposes, Milord, a person of the Board of Trustees in terms of 44.
Right.
Milord, last sentence of that item number 9. Last sentence.
Right.
Has my lord very kindly got it. Grateful.
Just heard learned counsel for the parties.
And I have acted on the affidavits of the affirmed affidavit.
Affidavits of service filed today be kept on record. Full stop. Supplementary affidavit of service.
Yes, that was the
affidavits of service filed today be kept on record. Full stop. Judgment is reserved in the matter.
My lord, I am praying unconditional, unqualified apology, my lord, for repeating the same submission. My lord,
What submission?
My lord, that submission I repeatedly that no consent was there, my lord. My lord.
No, the notions differ between advocates regarding the acumen of the judge. Definitely, you are entitled to that.
Don't take me, Amish. I'm grateful, man.
Grateful.
ওটা থাকবে
I'm grateful, man.
I'm grateful, dear Lord.
Thank you.
Grateful, man.
Pass over to the getting.
Pass over matter item number 1.
Yes. Which section were you relying on, Mr. Dhar?
My lord, section 36B.
36B. Right.
36B, but the cause of action actually arose for involving section 35, which actually lays down the codes of conduct of practice for practicing lawyers and
the time limit. You are referring to the time limit. Where do I get it?
The time limit is within the 36B, the section 36B. I have annexed it, and within the judgments also, the 2 copies that I have given you.
Before judgment, let us see the provision.
So,
period of 1 year. Judgments.
So it's page number 29, annexure P4. So that lays down the section 35B.
Right. And that mandatory, it's mandatory, that has been held by the Supreme Court as well as the.
Absolutely.
Right.
Your Honor, sorry.
It's all right, yes.
My Lord, I know today you've set the date for order, but if I may kindly be permitted to make 2 quick points because they are pertinent, and the points actually refer to the first writ petition that I filed. I laid out everything in detail in that. I haven't laid out in detail in this particular writ.
You want a transfer of this to the Bar Council of India now?
Yes, exactly, because the Bar Council of West Bengal has failed to act within this.
I'll allow that.
Right.
I'll allow that right now.
Right. But would you like, because what I wanted to do is actually, because I've got one opportunity, I don't want to let it go actually. Because this is very, very pertinent in this matter. Although I have not, as I said, although I have not laid it down in detail in this particular writ petition, but the earlier one. Why I'm saying, because you will know what I'm going to say, because by that you will understand that both the organizations, Bar Council of West Bengal to start with, and then the Bar Council of India, both of them have miserably failed. I'm sorry to use this very strong word, but miserably failed. As I said,
What?
to act as per the statute. They are the statutory bodies, and they are supposed to act on.
So the difficulty is that I appreciate your concern, not that I don't appreciate your concern, but the difficulty is this is a personal dispute, as in a personal dispute between you and the respondents. This is not a public interest litigation. So I cannot lay down sermons here. I could have laid down sermons, I could have given sermons also if it was a public interest litigation, or if it was relevant, directly relevant to your matter. Your matter, it's relevant because it's pending for 17 months, which is much beyond 1 year. But only that, I cannot take note of the general conditions, what is happening outside, what the bar councils are guilty of or not guilty of. They have a right of defense also. Whether they are guilty or not, those are general allegations. I won't go into those in this writ petition. It's beyond the scope of this writ petition. That is the reason I don't want to entertain those in this writ petition. If it was a public interest litigation, I was the designate of the Chief Justice hearing it, definitely I would have. It would be my incumbent duty to hear it. But here, no, not in this matter.
I totally take that.
That is the difficulty. That we cannot go into those questions. Definitely, if I go into that question, they'll have a right of audience on that also. But even then, I don't want to go into that because that is unnecessarily diluting this.
I totally.
It will serve good as it will embellish my judgment, but not for any other purpose.
I totally take that, my lord. And
let us not do that. Let us go by.
I take that on board. I just wanted to let you know the harassment that has been caused.
No,
to a common man, where does he go if the statutory bodies fail to do their work? And I'm going one step further in alleging actually that Bar Council of West Bengal has tried its level best to save the respondent advocate. Why I'm saying that is that after I filed in January 13th, on January 13, 2022, 7 months after that, they sent me a letter saying that I have not filed it as per the format, as per a complaint petition, which the earlier order corrected it. I filed it with an affidavit. I did everything possible. And my lord, please also consider that, the kind of, the follow-up that I did. I went up to the Honorable Chief Justice of India, just to save me the uphill task of coming and facing the Honorable High Court. I'm a layman. I'm not a lawyer. So I took this. I know this is going to be a kind of a risk for me because I don't know what the outcome will be, but I still want to do this because I need justice in this. And it's not just me who's aggrieved in this. My deceased father was also brought in. The kind of
India or West Bengal?
India, my lord.
The kind of defamation that was thrown at my deceased father, who died 2 months prior to this incident, which happened on the 6th of January. I just cannot let it go. And there are other things also, and it happened inside a court, and in the corridors just outside the court. A person dragged out of the court, holding his collar and, calling explicit his name, and calling all street level abuses thrown at him and his father. He's assaulted in a group. Then, he's called all sorts of names. And the thing is that, one thing which stands out also is that, the person concerned, he has also not lived up to his advocate's repute, if I may say that, because he's also, denigrated a fellow junior advocate, a lady junior advocate, and saying that all sorts of, I don't want to go there because as you said, I'm just going to waste the time.
Not wastage of time, not at all a wastage. I appreciate you are ventilating your grievance, which I fully appreciate. And I appreciate your courage in coming up also, not on that, but on the issue at hand, because I'm sitting in a court of law, I cannot go into personal things.
I take that.
So I may have some opinion, I may have some reply to you, whatever you said. There may be some other reply also from somebody else, but let us not go into that because that's beyond the scope of this writ petition, which I am deciding and for which I am paid, in fact.
Sure.
So let us do that.
Sure.
Thank you. After order of good. The petitioner, appearing in person with leave of court, submits that despite the petitioner having lodged a complaint against a member of the bar practicing in the state of West Bengal, the State Bar Council has not taken any positive steps for decision adjudicating the same till date.
My apologies for intervening. They have not come for these hearings in the first during the first writ petition, the first hearing.
First hearing, this petition, I'll definitely record that. Let me pass my order, then if you have to add in it. Ki bollam? Full stop. It is submitted that already 17 months have elapsed after the lodging of the complaint. Full stop. However, comma, only upon getting notice of the filing of the writ petition, comma, the State Bar Council has fixed another date, comma, purportedly for hearing of the same. Full stop. Even otherwise, comma, it is argued, comma, Section 36, capital B of the Advocates Act 1961 clearly mandates that the disciplinary committee of the State Bar Council shall dispose of the complaint received by it under Section 35 expeditiously, and in each case the proceedings shall be concluded within a period of 1 year from the date of the receipt of the complaint or the date of initiation of the proceedings at the instance of the State Bar Council. Full stop. It is further provided in subsection 1 of Section 36 capital B of the 1961 Act that failing the above, comma, the proceedings shall stand transferred to the Bar Council of India, which may dispose of the same as if it were a proceeding withdrawn for inquiry under subsection 2 of Section 36 of the Act. Full stop. Next para. In the present case, comma, the petitioner contends that he has been running from pillar to post with his complaint. Full stop. However, comma, as of today, comma, neither the complaint has been disposed of by the State Bar Council, comma, nor has the Bar Council of India taken up the issue. Full stop. Next para. The petitioner cites a judgment of the Supreme Court reported at 2017 5 SCC 465, নামটা একটু দেখে দিয়ে দেবেন, for the proposition that the time limit stipulated in Section 36B within bracket 1 of the 1961 Act is mandatory in nature. Full stop. Next para. The petitioner also cites a division bench judgment of this court reported at 2001 Cal LT 77 within bracket HC, নামটা দিয়ে দেবে একটু দেখে এখানে, as well as another judgment of the Supreme Court in K Anjinappa versus K C Krishna Reddy, comma, in support of such contentions. Full stop. Next para. Despite several opportunities, comma, the Bar Council of West Bengal is not represented on any of the dates of hearing of this matter, comma, although the Bar Council of India is represented today through council. Full stop. Next para. The provisions of Section 36 capital B of the 1961 Act, comma, as rightly argued by the petitioner, comma, are specifically stipulative of a limited time for disposal of any complaint lodged before the State Bar Council. Full stop. Next para. That is all the more so, comma, since there ought to be a transparency in such proceedings being conducted by any statutory body, comma, which represents a particular association of members, comma, to prove that justice is also being done and appears to have been done and not only done. Full stop. Next para. Be that as it may, comma, even the judgments of the Supreme Court as cited by the petitioner are very categoric on the score that the bar councils are required to decide and dispose of the complaints received by it under Section 35 expeditiously within the mandated period as stipulated in section 36 capital B, footstep next para. In the present case, comma, much time has elapsed even after the expiry of the mandatory statutory period, comma, without any disposal of the petitioner's complaint. Footstep in such view of the matter, comma, WPO 1155 of 2023 is allowed, comma, thereby directing the respondent number 2, that is the Bar Council of India.
Respondent number 1.
1 is the Bar Council of India. Respondent number 1, the Bar Council of India, to take up the complaint lodged by the petitioner before the State Bar Council, comma, as referred to in the body of the present writ petition, comma, and upon giving adequate opportunity of hearing to all concerned, comma, including the petitioner and the person against whom the complaint was lodged, comma, to decide the said complaint in accordance with law as expeditiously as possible, comma, within the provisions of section 36 within bracket 2 of the Advocates Act, comma, 1961. Footstep, it is expected that such adjudication shall be concluded within an outer limit of 6 months from this date. Footstep next para. It is, comma, however, comma, made clear that this court has not gone into the merits of the allegations and counter allegations made by the petitioner
Everything.
and or the respondents. Footstep next para. The petitioner shall, what is he required to do, Mr. Kankani? Is he required
That is what
to?
I was telling him, my lord, in case whatever application or any document which is filed here, just send a copy there, my lord,
Copies.
because it will be fast.
The petitioner shall serve copies of all relevant pleadings and documents in connection with his complaint before the respondent number 1, the Bar Council of India, within a fortnight.
Yes, within a fortnight is fine.
Within 3 weeks.
Within 3 weeks.
Within 3 weeks from date. You can do it earlier also.
Right.
Within 3 weeks from date.
Can I just humbly?
Act line at Kudin. Parties shall act on the server copy of this order for the purpose of compliance without insisting upon prior production of a certified copy. Yes.
Just a humble prayer, Milord. You've said that, please, you've said that, they have to do it expeditiously.
Within 6 months outer limit.
Within 6 months, but don't you think 6 months is too long period? Because I have waited for 17 months, nothing has happened. So if some time bound,
I wanted to give something realistic actually, because Bar Council, there are several complaints pending before the Bar Council of India as well.
But isn't this a?
Because if they don't comply, you are entitled to file a contempt application. I want to give them that much time.
6 months.
Not because they are members of the bar, not for that, but it's reasonable, I suppose.
Would you kindly consider this as an exception? Because
My lord, I'm opposing this, my lord, only, my lord, we will try to conclude it before
That's
that,
an
but
outer
the-
limit, Mr. Dhot. They will try to do it after these averments and these findings. Probably they'll try to do it earlier.
Because we'll have to issue notice to him, them, my
Paraphernalia are there.
That's fine. That's okay.
So let us wait for 6 months. Let us see. If they don't, then we are there.
That's grateful.
Thank you. I'll come back and continue with the other matters. This matter is over.
Please do something. This is just gone after.
number 5.
Yes. All served? Yes, what is that? You are for which respondent?
I'm appearing on behalf of WBIDC Millet. But
Right.
probably I'm not the answering respondent.
To the Director of Industry.
Can you give a notice, come back day after tomorrow? Just give a notice, come back day after tomorrow. It was not taken up due to their absence. I'll put something in my order. None appears for the respondent numbers 1 and 2, although the petitioners and the respondent number 3 are represented through counsel. Full stop. Since the respondent numbers 1 and 2 are the principal answering respondents, comma, the learned advocate on record for the petitioners is requested to give another notice to the said respondents and or their advocates, indicating that the matter shall be taken up under the same heading on June 14, 2023. Full stop. It is made clear that in the event the absentee respondents do not appear on the next returnable date as well, comma, ex parte orders in their absence may be passed. Full stop. Please file a receipt on the next date.
Yes. Much obliged.
Affidavit of service filed today be kept on.
Item number 6. Vani Singh.
Yes.
I am appearing for the respondents.
Please use the microphone. I can't hear. Yes.
Yes, my lord, I am appearing for the writ petitioner, my lord. The respondents have all been served. The challenge in this writ petition, if I may say, my lord, is the action of the respondent number 1, my lord, in taking possession of my property under the provisions of the Securitization Act, my lord, without there being any valid security interest created. Why I tell, my lord, this problem, my lord, my lord, purchased a property in 2012. It was a developed property, the owners, developers, and I was a party. I purchased the property. In 2000, and the property was thereafter mutated in my name. I have paid tax, electricity bills, maintenance bills, I've annexed everything. Now, my lord, in 2021, I find a possession notice affixed on the outer door of my property, my lord, a flat, my lord, 800 square feet, saying that the property has been taken possession of by the respondent number 1 bank on the basis of a loan taken by the respondent number 9. I have implemented him as a party, my lord. And, my lord, the deed number, which was
your vendor.
Yes, my lord. No, what happened? Respondent number 9 is a complete stranger. I've never met him. I don't know who he is. Now, my lord, so is respondent number 1, my lord. I have not taken any loan from IDBI. They say that that security interest was created by way of a 2014 deed, which is admittedly after my deed, my lord. I was an owner in 2012. Now, thereafter, my lord, I wrote them representation saying, this is my deed, look at my deed, I am the owner, I have mutation, everything, whatever case I made out in the writ petition, I stated in the representation. Number 1, they did not deny that 2012 deed exists. Number 2, my lord, they said, we have done this, we have nothing to do with you. The respondent number 9 had taken a loan, your rights will not be prejudiced, so do not worry. I say you have taken possession. Thereafter, my lord, in 2022, again, formal physical possession was taken pursuant to an order passed under Section 14 under the Securitization Act, my lord. I went ahead, I had asked for the deed on the basis of which they are claiming that there is a security interest. They say this is a private confidential document, we will not disclose, but we can tell you that we have made searches through our impaneled lawyer that this is the proper document, my lord. I went ahead, my lord, because in the possession notice, the deed number is mentioned. I got a certified copy of the deed. My lord, identical owners, identical developer. I purchased in 2012 and the certified copy on the basis whereof, my lord, the bank is taking possession, my lord, is relying on the security interest being credited, my lord. That is of 2014.
So you didn't approach the tribunal?
My lord, that time has expired. I ought to have, my lord, that section begins any person, my lord. But if I may humbly submit, my lord, this is a complete violation of natural justice. And my lord,
what have you challenged here?
My lord, I have sought for, my lord, kindly comes to my prayer, my lord, at page 14, my lord, to remove the padlock and my lord to return
Cannot
possession.
bypass the act.
My lord.
We cannot bypass the act, Securitization Act.
Yes, my lord, but the time period has gone. Today, if I make a Section 17 application, it will not be entertained.
It's
my
a
lord.
time, but plea can it be allowed in the garb of
I
a
understand, my lord, but my lord, alternative remedy, my lord, it's not an absolute bar, my lord.
No, it's not an absolute bar, absolutely not an absolute bar. But the difficulty is to bypass a time bar, you cannot do that. That will be giving premium to some exercise which would open a floodgate and unnecessarily. How late are you? I mean, when did the period of challenge expire? Approximately, just approximately.
My lord, in sometimes in beginning of April, I think, because the last
April this year.
Physical, yes, my lord, the physical notice.
April this year.
Yes, my lord. They had pasted the note. No, I'm so sorry, my lord. Possession notice finally, my lord, 24th of February 2023. Somewhere there, 45 days, some first week of April, I'm guessing.
Yes, you have to do something regarding that. We'll have you for the bank.
I do not have any X to grind. I am corporation.
You are?
I am for Kolkata Municipal Corporation. I have no X.
How are you
to grind.
involved here?
I have served on all, my lord. I've filed the affidavit of service, my lord. My lord, will kindly see the letter, my lord. The
remove padlock is a final relief. We cannot do that.
No, of course not.
I can at best give you a liberty to approach before the appropriate forum. I can say something in the light of not section 14. 14 is not applicable here.
But another thing, my lord, because I'm not a borrower, I'm not a guarantor, I'm not getting any notices, any reply, nothing.
That's true.
So, my lord, I have to be constantly on the lookout. And this is not a property where I reside. I reside in Tollygunj, my lord. I come every now and then, my lord, reside there temporarily. But now I can't because the padlock has been put in by the bank. But bank has
very well. I'll direct affidavits, direct them to maintain status quo as regards the property.
My lord, I
learned counsel for the petitioner has made out a strong prima facie case as to the respondent number 1 bank having acted dehors the law in acting on a purported deed which was kept as security with the bank for a loan taken by the respondent number 9 in respect of a particular property, which was purchased by the petitioner by way of a valid registered instrument prior to the alleged purchase of the respondent number 9. Full stop. Learned counsel contends that in view of the prior purchase of the petitioner, neither the respondent number 9 had any locus standi at the relevant juncture to use the said deed as a security in respect of the petitioner's property, nor did the bank have any authority to issue a notice of possession within the contemplation of the Securitization Act, subsequently implemented notionally, constructively under section 14 of the said act. Full stop. Next para. It transpires that despite service, none appears for the respondents apart from the Kolkata Municipal Corporation, which is respondent number 5. Full stop. Affidavit
5,
of
6 and 7.
Acha, very well. Which is now apart from the respondent, apart from the KMC na kore, apart from বুঝতে অসুবিধা হবে না তো? Apart from respondent numbers 5, 6 and 7. Full stop. Next para. The affidavit of service filed today be kept on record. Full stop. It is prima facie clear from the materials annexed to the writ petition that although the petitioner is precluded under the provisions of the relevant statute by the bar of limitation from challenging the issue before the appropriate tribunal by certain months, since it is arguable as to whether such right for the petitioner would be illusory, as the petitioner was never served any copies of any relevant pleadings affidavits in opposition within 4 weeks from date. Full stop. Reply if any shall be filed within a week thereafter, full stop, the respondent authorities shall remain restrained by an order of status quo from dealing with and or transferring, alienating and or further encumbering the disputed property in any manner till September 30, 2023 or until further order, whichever is earlier. Full stop. The matter shall next be listed in the monthly list of August 2023.
Grateful to my lord.
Item number 7 for hearing, West Bengal Power Development
Yes, Mr.
Corporation.
Gupta, what is it?
Please, Your Lordship. This is, my lord, the writ petition by the West Bengal Power Development Corporation with regard to, my lord, an insurance claim which it had lodged with New India Assurance for a loss which had occurred at its, my lord, plant, and the machinery equipment has been damaged. Now, my lord, initially what had happened was, this is appearing after completion of affidavits. But initially what had happened was there was a repudiation of the claim. The insurance company had appointed a surveyor, which it is required to do as per the Insurance Act. The surveyor goes.
Please take your seats, both of you. Yes. Please carry on, Mr.
The surveyor goes, inspects, and returns a finding in its report that this loss, which has been in respect of which the claim has been made, was not a sudden incident, and it was a prolonged damage which had occurred to the machine. So as per the exclusion clause of the contract, that claim is not admissible. Insurance company, on the basis of that report of the surveyor, repudiates the claim in its entirety. The petitioner before Your Lordship writes a letter giving its justification as to why that finding may not be correct, and requests the insurance company to relook into the matter. The insurance company then appoints an expert to assess the cause of loss and return a finding on that. That expert carries out the inspection and, most importantly, carries out laboratory tests and metallurgical tests and returns a finding that this was sudden.
This was sudden?
Yes. Upon giving a detailed report, which we have annexed. The expert then shares the report with the surveyor, which was originally appointed. The surveyor then files one addendum admitting the claim, saying that I had returned XYZ findings, but after this, since these are the findings, so that portion of my report goes.
The expert was appointed by whom? The insurance company? Very well. Please continue from there.
And the insurance company's surveyor now.
Yes. Now he gives that.
Now he gives an addendum to the report which has been filed, admitting X amount, or to be very precise, 23 crores as the loss payable, because this rotor, that is the machinery, had to be completely replaced.
Achha.
After that, the same surveyor files another addendum, and the quantum of the loss is 30 crores. What the insurance company does is, after getting the two addendas, they issue an email to us. In the first email, they write that they copy paste basically the second addenda, where 30 crores is there. Subsequently, the insurance company issues a letter, issues an email saying that this is under consideration and this would be done. Thereafter, we write repeated emails and communications to the insurance company saying, this is
give us. Yes.
Now the insurance company suddenly, it's a one-liner saying that your claim, the repudiation of the previous repudiation.
Reiterate. On what ground? Any ground given?
Nothing.
Where
That is exactly where I am.
Where is that? The last
Finally
one?
comes to page 122. I'm sorry, 122.
Who is the competent authority? Their competent authority.
They are competent, which we say is not that competent enough to assess the loss.
But has the authority, no doubt.
They has the authority.
Yes.
They have the authority.
Very.
Your Lordship has seen that there is no reason as to how they
The
are.
rest, whatever you submitted, are borne by the annexures.
Yes.
The report and all
Yes,
this.
yes.
Right.
Now, three things, my lord, I shall indicate which would, in my humble submission, be germane. Firstly, is, my lord, the law is settled on this score, and I have judgments in support of that, that reports of a surveyor are not binding on the insurance company. So I would be the last person to argue that since the report is there, the insurance company should follow. That is not the law.
No consideration at all of that.
Yes.
They have not considered it at all.
Yes. Secondly, in all the judgments, it says that, my lord, the insurance company is not bound by the report, but if there is a report by a special body appointed by a statute or mandated by a statute to be appointed for each and every claim, that's a requirement under the statute, that an insurance company, whenever receives a claim from an insured, has to appoint a surveyor. I shall place that provision. Once that has been done, then without any reason to differ from that, the insurance company should not. And in several locations, the Honorable Supreme Court and other courts also have, my lord, set at naught where the insurance company sought to differ at their whims. So, my lord, in my humble submission, even the surveyor in this case would possibly not be an expert. And that is the reason why the insurance company thought it fit to appoint a specialized, my lord, body or a specialized entity to, my lord, find out the root cause of that, which after carrying out the metallurgical analysis and the laboratory tests found that this was not a prolonged defect which has led to the loss. And on the contrary, a sudden loss, accident, which has led to this loss. So there's a finding of a specialized entity engaged by the respondent, by the insurance company. That finding has been accepted by the surveyor, and a report has been given to the insurance company, the addendum or two addendas. After that, without any consideration of that or without any cogent reason, my lord, the initial report has been, my lord, upheld. My lord, in my humble submission, the initial report possibly merges into the two addendas, so that itself loses its existence.
Mr. Gupta, if you get a favorable order in this, I'm just asking you, the best thing then, as per your argument also could, because you say it could not have been binding, but they have to reconsider it and give some solid reason and reject or accept.
Which they have not done. Even in the affidavit also they have.
Even if you win this writ petition, then also that direction can be given. I cannot direct them directly to pay the amount.
To that effect,
yes, to that
effect, I am also carrying to on that score. May I, but this is judgment.
Cite the other judgments also, but these first. Yes.
2001, Volume 2, Supreme Court cases 160. But here it's a case of a writ petition where money has been directed to be paid by the insurance company. 2001, 2 SCC 160. But may I place this, my lord? This was an appeal preferred by the Life Insurance Corporation of India, being aggrieved by, my lord, an orders passed by the writ court allowing directing payment. But here, my lord, kindly comes to the first. Your lordship has seen the first paragraph, my lord. But may I place it?
Yes.
These appeals filed by Life Insurance Corporation India are directed against the judgment of a division bench of the Bombay High Court in writ appeal number such and such, allowing the appeal on the ground that the appellant should have had an opportunity of leading evidence relevant to their contention that the insurance policy was obtained by misrepresentation and therefore avoidable at the instance of the corporation, and remitting the writ petition to the writ court for fresh decision after allowing the corporation to lead evidence. The division bench did not accept the objection raised by the corporation against maintainability of the writ petition on the ground that the case involves enforcement of contractual rights for adjudication of which a proceeding under Article 226 of the Constitution is not the proper forum. The contention on behalf of the corporation was that the writ petition should be dismissed as not maintainable, leaving it to the writ petitioner, respondent number 1, to file a civil suit to enforce her claim. Then, I'm not troubling your lordship with the facts as of now. Kindly comes to paragraph 10, which is at page 166.
Yes.
Article 226 of the Constitution confers extraordinary jurisdiction on the High Court to issue high prerogative writs for enforcement of the fundamental rights or for any other purpose. It is wide and expansive. The Constitution does not place any fetter on exercise of the extraordinary jurisdiction. It is left to the discretion of the High Court. Therefore, it cannot be laid down as a general proposition of law that in no case High Court can entertain a writ petition under Article 226 of the Constitution to enforce a claim under a life insurance policy. It is neither possible nor proper to enumerate exhaustively the circumstances in which such a claim can or cannot be enforced by filing a writ petition. The determination of the question depends on consideration of several factors, like whether a writ petitioner is merely attempting to enforce his or her contractual rights, or the case raises important questions of law and constitutional issues, the nature of the dispute raised, the nature of inquiry necessary for determination of the dispute, etc. The matter is to be considered in the facts and circumstances of each case. While the jurisdiction of the High Court to entertain a writ petition under Article 226 of the Constitution cannot be denied altogether, courts must bear in mind the self-imposed restriction consistently followed by High Courts in all these years after the constitutional power came into existence in not entertaining writ petitions filed for enforcement of purely contractual rights and obligations which involve disputed question of facts. The courts have consistently taken the view that in a case where for determination of the dispute raised, it is necessary to inquire into the facts for determination of which it may become necessary to record oral evidence, a proceeding under Article 226 of the Constitution is not the appropriate forum. The position is also well settled that if a contract entered between the parties provide an alternate forum for resolution of disputes arising from the contract, then the parties should approach the forum agreed by them, and the High Court in writ jurisdiction should not permit them to bypass the agreed forum of dispute resolution. At the cost of repetition, it may be stated that the above discussions we have only indicated some of the circumstances in which the High Court have declined to entertain writ petitions filed under Article 226 of the Constitution for enforcement of contractual rights and obligations. The discussions are not intended to be exhaustive. This court from time to time disapproved of a High Court entertaining a writ petition under Article 226 of the Constitution of India in matters of enforcement of contractual rights and obligations, particularly when the claim by one party is contested by the other party and adjudication of the dispute requires inquiry into the facts. Then certain judgments have been quoted. Then the next paragraph. The position that emerges from the discussions in the decided cases is that ordinarily the High Court should not entertain a writ petition filed under Article 226 of the Constitution for mere enforcement of a claim under a contract of insurance. Where an insurer has repudiated the claim, in case such a writ petition is filed, the High Court has to consider the facts and circumstances of the case, the nature of dispute raised, and the nature of the inquiry necessary to be made for determination of the questions raised and other relevant factors before taking a decision whether it should entertain the writ petition or reject it as not maintainable. It has also to be kept in mind that in case an insured or nominee of the deceased insured is refused relief merely on the ground that claim relates to contractual rights and obligations, and he or she is driven to a long-drawn litigation in the civil court, it will cause serious prejudice to the claimant or other beneficiaries of the policy. The pros and cons of the matter in the context of the fact situation of the case should be carefully weighed, and the appropriate decision should be taken. In a case where claim by an insured or a nominee is repudiated raising a serious dispute, and the court finds the dispute to be a bona fide one which requires oral and documentary evidence for its determination, then the appropriate remedy is a civil suit and not a writ petition under Article 226 of the Constitution. Similarly, where a plea of fraud is pleaded by the insurer and on examination is found prima facie to have merit, and oral and documentary evidence may become necessary for determination of the issue raised, then a writ petition is not an appropriate remedy. Coming to the question of repudiation of the claim of the insured or nominee by the corporation, the provisions of Section 45 of the Insurance Act is of relevance in the matter. The section provides inter alia that no policy.
So the next portion is probably not inaccurate or false. This is not
Yes.
applicable. to you.
Finally,
16 also.
Yes.
Para 16 also.
Para
And here
16.
para 17 it has been allowed.
Yes, it has been allowed. Now, my lord, in light of this, my lord, as this judgment also states that there cannot be any straitjacket formula, my lord, that whether your lordship has to consider the facts. But in this case, my lord, may I only indicate that, my lord, the dispute.
They are appointed expert, they are surveyor.
That is the second
addendum.
limb. My lord, the first limb possibly,
Yes.
possibly would be that there is no dispute on the quantum. They have never raised any dispute on the quantum. The only issue was
sudden or not.
Whether that falls within the scope of the exclusion or not, because of whether it's sudden or whether it's prolonged. Once that has been adjudicated finally by the surveyor accepting the report of the expert, the insurance company possibly, which your lordship will of course test, possibly would not be in a position to deviate on the quantum. So far as disputed question on quantum is concerned, possibly they do not have the locus to agitate that. The only issue remains is admissibility of the claim, whether it falls within the exclusion or not. So, my lord, here in my humble submission, possibly there would not be a disputed question of fact. Only issue would be on the exclusion clause, the interpretation, and your lordship looking at the reports, my lord, and delivering and deciding the issue.
Show me the last report of the surveyor.
Yes.
Last
Yes.
report of
Kindly, my lord,
addendum.
comes to page 113. That is the first addenda, which I should place before the last report, my lord, kindly permits me. The second paragraph is very important.
113. Yes. Second
Kindly
paragraph.
sees the heading, addendum to report on such and such, that's the heading. The second paragraph. The insurers then decided to appoint Messrs. TRC Advanced Engineering to carry out a metallurgical analysis. Kindly marks this. Metallurgical analysis to identify the issues under debate. The said party, being experts in this field, had submitted their report dated such and such in the matter. Meanwhile, the insured have procured a new rotor, and kept it in their stocks as spare, and therefore is entitled to have the loss considered on new replacement cost basis. Then on that, kindly sees the bottom of that page, 23 crore 30.
Yes.
Kindly turns over to page 114. 114, I shall place only one paragraph at 114. In fact, two paragraphs. Under the heading admissibility, your lordship will find the second and the third and the fourth paragraph. The findings in the expert's report, however, categorically state that the cracks developed suddenly and then subsequently did not show any signs of growth. These findings satisfying the insuring clause description of sudden and accidental breakdown of property insured, and thus this loss becomes admissible. Now, my lord, thereafter, kindly takes a look at my supplementary affidavit. We had missed out annexing the second addendum, which has been filed by way of a supplementary affidavit. Kindly pardons us, my lord. Kindly takes a look at page 6 of the supplementary affidavit. This is the covering letter. And kindly turns to page 7. Again, I shall be placing, my lord, the second paragraph. Copious details already given in the previous reports are not necessary here, and so are not repeated. However, in a meeting of the insured, the brokers, the insurers, and the surveyors were held at the insurance office yesterday, where all issues were discussed in depth. The insured's contention has been, my lord, indicated. Now, kindly looks at the table which has been given. The loss assessed is 30 crore, and the recommendation, in our opinion, this loss remains admissible under the terms and conditions of the policy. But now this matter may be settled as above after due consideration. So these are the two addendas, and your lordship will take a note of the report of the, my lord, TCR Advanced that we have annexed at, my lord, page 79. Where there is a detailed metallurgical analysis with photographs, with test reports, and the facts and figures. that runs from page 79 till, my lord, 112.
Show me the conclusion, Mr. Gupta.
Yes. Kindly, my lord, turns to, my lord, page 9. I'm sorry, my lord, 92. Points 2 and 3. And the unnumbered paragraph after that. The metallurgical investigation is evident of sudden nature of cracking. Now, your lordship will kindly note one date, my lord, which is the date of the loss. The date of the loss, my lord, is, my lord, is of 2018. I shall give your lordship the exact date.
18th of August.
18th of August, 2018.
Page 118.
Yes. So, my lord, now we are more than 5 years away. So now new test of that thing, of that rotor or whatever.
Wouldn't yield anything.
Won't yield. So whatever reports are there, everything has to be based on that.
So no issue, no use of remanding.
No use of remanding
Right.
for any trial on that score. No, I'm led by Mr. Mithru. Kindly comments.
Facts he has covered fully. May I just come to the policy regulation on this? There is a insurance, though, and how that would be applied to the facts. This is the IRDI policyholders interest regulation. I will just relate that this regulation with the facts of the case. This is for policy, is in the interest of policyholders. I am on regulation 15, general insurance policy claim procedure.
15.
Yes, 15.
That is page 23.
This is running page 23 in the document handed up to me.
Yes.
Claim procedure in respect of a general insurance policy. You kindly come to 15.5. 15.5 to 8 are the things which may be of some relevance in this case, madam. 5.1. This. Yes. Surveyor, the surveyors shall, subject to sub-regulation 4, submit his final report to the insurer within 30 days of his appointment. A copy of the surveyor's report shall be furnished by the insurer to the insured claimant if he so desires, notwithstanding anything mentioned in case of claims made in respect of commercial and large risks. The surveyor shall submit the final report to the insurer within 90 days of his appointment. Now, Lordship, what is important is sub-regulation 6. This is an internal matter which has happened in this case. If an insurer on the receipt of a survey report finds that it is incomplete in any respect, he shall require the surveyor under intimation to the insured claimant to furnish an additional report on certain specific issues as may be required by the insurer. Such a request may be made by the insurer within 15 days, provided that the facility of calling for an additional report by the insurer shall not be resorted to more than once. Now, this is an internal matter, but in their affidavit also, they have admitted that they have engaged, at our request, engaged an expert, and it went to, now Lordship will see 15.7. The surveyor on receipt of the communication shall furnish an additional report within so and so time. Now, here in this case, the additional report Mr. John Gupta has shown. Now, 8. On receipt of the final survey report or the additional survey report, as the case may be, and on receipt of all required information, documents that are relevant and necessary for the claim, an insurer shall, within a period of 30 days, offer a settlement of the claim to the insured claimant. If the insurer, for any reasons to be recorded in writing and communicated to the insured claimant decides to reject a claim under the policy, it shall do so within a period of 30 days. Reasons recorded in writing. Now, Lordship, lastly,
2% interest.
yes.
Yes.
Now, what I want to show one thing, something else, 15.9. In case the amount admitted is less than the amount claimed, then the insurer shall inform the insured. That's not applicable. Yes. Yes. So now, here,
30 days have elapsed.
And reasons, Lordship.
No, they have rejected in writing.
In writing, but no reasons to differ from the final report of the surveyor. That's also another thing I want to point. Mr. Gupta has also said. Well, initially the surveyor's report was rejected by a letter.
70.
Well, there was no need to reject.
No, Mr. Mitra, page 122 is the only, communication.
Only communication.
Last communication, only communication. No
And I
reasons.
will also rely upon the affidavit. In the affidavit also, opposition, they have not even a sentence to dispute the final report.
If they did, then you would be citing Mohinder again. So anyway,
But
they have not done it.
They have not done it.
They have not.
They have not done it. That's the advantage. Even on affidavits, they're only parroting the first surveyor's report as they summarized why it was rejected.
Let us see the first surveyor's report was, which they rely on, which is reiterated now. Although that has become redundant, probably according to your submission also.
That's since now. I mean, that has become
academic sort of.
Page 15.9. And the insurance company is
the reason was not sudden. That was the reason.
Well,
the reason was not sudden. This is not
the only reason. Only reason.
Well, let us hear them then. If you want to cite anything.
Yes, well, I can show some judgments for the proposition that even in a disputed insurance claim,
yes,
one need not go to the civil court and come to the writ court for. I mean, there are precedents for that.
LIC versus Asha Goel has been cited.
Asha Goel has been given. There are two subsequent judgments, one by our High Court, one by the Gujarat High Court Division Bench, by the future Chief Justice of India, Justice Pardiwala's judgment. In fact, I found Justice Pardiwala's judgments while researching this. But it was a refreshing change to find in contractual matters when really there are no disputes. Then his lordship has been very freely in writ matter. I want to show Justice Pardiwala's judgment in this case. Not insurance, but non-insurance, but then following Asha Goel and applying the principles. Lordship kindly takes a look at this judgment in Cube Constructions. Really, paragraph 45 onwards. Here there was a pure contractual dispute asking for money due under non-statutory contract. This is what ABL was. This is what.
Yes.
Paragraph 45 onwards, really after. Moreover, when a writ court finds that the refusal to extend constitutional remedy of Article 226 to enforce a contractual right or obligation would drive a person knocking at the doors of a writ court to a long-drawn litigation in the civil court, causing serious prejudice to the person seeking relief against the state, the writ court may not, according to Asha Goel, decline to interfere in such a matter, and hence reminds the Supreme Court Asha Goel thus. The pros and cons in the matter in the context of the facts of the case should be carefully weighed and appropriate. From the law so laid down in Asha Goel, it becomes transparent that when non-interference by a writ court would drive a person to long-drawn civil litigation, causing serious prejudice to him, the writ court's interference is not only desirable, but even necessary. As a corollary to this proposition of law, one can safely say that when a contractor's dues are admitted or unfairly and unreasonably disputed, this is what has appealed to me personally as a lawyer, by the state, and the fact situation of a given case satisfies the writ court that asking the contractor to take recourse to the civil court would cause serious prejudice, the writ court would step in. Lordship, this goes on, para 47 also, para 48, then ABL, para 51, ABL has been reiterated that in a money claim, if there are really no disputes or disputes are sham, and Lordship, paragraph 52, I will stop at paragraph 52. From the above observations made in ABL International, it becomes abundantly clear that there is no absolute bar in entertaining a writ application under Article 26 if the writ applicant aims at enforcing contractual obligation of the state to make payment of its unpaid dues to the writ application. Though it will depend, we must hasten to point out on the cumulative effect of the facts of a given case as to whether High Court will or will not entertain it. In this case, the division, in case it was allowed and the
Yes.
payment directed. Our High Court also in 13.4 CHN in insurance, in life insurance matter,
And dealing with an exclusion.
and dealing with an exclusion clause has a paragraph nahi na? Or ship them.
In any event, yes, the page you can.
No, the first paragraph, third last paragraph. First was the availability of an alternate remedy. He submitted that there were disputed issues involved which had to stand trial. Now, Lordship kindly come to the last paragraph. But more recent cases were cited by Mr. Ray for the petitioner being LIC as Asha Goel and Bhiman Krishna was so. From the above judgments of the Supreme Court, I can say that where there is no dispute in facts, where the action of the government or government agencies arbitrary or malafide or most unreasonable in resisting a bona fide claim of insurance, and the court has the power under Article 26 to provide proper remedy. Facts cannot be simpler than this case. We find a total absence of dispute. In an identical surgical procedure, the claim of the petitioner was paid in full. And the claim for the operation, which is identical to the other one, has been withheld. Therefore, in my opinion, Article 26 was a proper remedy. The next point taken as the Mukherjee was that it's not relevant here, territorial jurisdiction. And the third last paragraph from bottom. Secondly, it was argued by Mukherjee the parent policy of 1970 and the exclusion of hypertension also covered the instant policy. However, I do not find any mention of the exclusion in the policy. And says pointed out, Mr. Roy, even taking Mukherjee's submission to be correct, rejecting a claim for an angioplasty procedure on the ground that the claim arises out of hypertension is preposterous.
Those are on the facts of the case and his lordship directed. Yes.
But on this, of course, here this is a Supreme Court judgment which came from Consumer Court. But that Rule 5, that it was earlier Rule 12.5, I think. This now Regulation 5.8, that reasons are to be given. That is also, Lordship, has been discussed here. And paragraph 17 may be of some relevance. Earlier it was 9, Regulation 9 of the previous policy regulation of the. It was 9, no? Yes. Or should kindly see paragraph 17, second last paragraph. In the instant case, the appellant insurance company had failed to discharge its burden of bringing the case within the exclusionary clause on 5D of the policies in question. The surveyor in the final survey report had also opined that the loss had occurred due to the insured peril and the claim was admissible. Though it is true that the surveyor's report is not the last and final one, nor is so sacrosanct as to be incapable of being departed from. However, there has to be some cogent and satisfactory reasons or grounds made out by insurer for not accepting the report. We are afraid the instant case appellant has failed to make out any such cogent.
Unless they find a more reliable evidence, defy korte parbe. The last paragraph 12.
Another judgment of the paragraph 12. There has to be some other evidence to reject it. You just can't reject it outright because paragraph 12, in the said decision, it is no doubt held that though the assessment of loss by an approved surveyor is a prerequisite for payment or settlement of the claim, the surveyor's report is not the last and final word. It is not that sacrosanct that it cannot be departed from, and it is not conclusive. The approved surveyor's report may be the basis or foundation for settlement of a claim by the insurer in respect of loss suffered by insured, but such report is neither binding upon the insured or insured. On the said proposition, we are certain there can be no quarrel. The surveyor's report certainly can be taken note as a piece of evidence until more reliable evidence is brought on record to rebut the contents of the SABYAS report. I am on that. Well, that is all. I'm with you. Yes.
Lord, I have received affidavit in reply, but the additional thing, I think that document has not come up to me. However, I will start with my arguments today. Supplementary affidavit?
This is a supplementary affidavit.
No, that was before the opposition was also filed. This was with the writ petition. This was filed, supplementary affidavit.
Oh, then it's all right. Then it is with.
This is not subsequent to the affidavit.
My lord, I will firstly come to my affidavit in opposition, my lord. If your lordships kindly take up this.
Yes, please. Which page?
Yes, my lord, I will go
First
straight to the annexures, my lord. Kindly seize running page 25, my lord. It starts from page 21. This is the policy, relevant policy. Page 21 থেকে শুরু হয়েছে 25. If your lordships kindly sees to the page 25, insured interest. This is the policy, this is the contract between the insured and the insurer. My lord, the property damage section. All real and personal property other than what is excluded under the policy belonging to the insured or property held in trust, care, custody, consignment, and or control of the insured whilst in operation or repairs or maintenance or in storage or during movement within outside the premises or while carrying out minor works whilst contained in the premises insured, comprising or consisting of but not limited to the building, plant, machinery, railway, infrastructure, stocks in process, finished goods, raw materials, stores and supplies, and any other material pertaining to the trade. This was the insured interest, everything. Now thereafter, my lord, if your lordships kindly come to page 28, running page 28.
Yes.
My lord, it's necessary to make it that it is a comprehensive mega risk policy as it is written over there. The insuring clause. In consideration of the payment by the insured named in the schedule hereto of the premium mentioned therein, the insurer agrees, subject to the conditions, provisos, and exclusions contained herein, or endorsed or otherwise expressed hereon, which shall be deemed to be condition precedent to the right of the insured to recover hereunder, to indemnify the insured in respect of, well, now I put emphasis on these points, sudden and accidental physical loss, destruction or damage to the property described in the schedule hereon, directly and wholly attributable to any cause except as hereinafter provided, occurring during the currency of the policy referred to herein as damage. So, my lord, two things has been necessarily been mentioned here. One is the accidental physical loss that has been there, and what is the meaning of the term damage. These two things are stated here. My lord, the next line is sudden shall mean accidental and not reasonably foreseen and not a gradual occurrence. This is, my lord, this is the point of this. In no case shall the liability of the insurer exceed the limit of the liability sum insured as mentioned in the schedule or as may be provided herein. Now, my lord, thereafter it comes 1.1 accepted clause should have been anyway. If your lordships kindly come to Roman 5. It is also understood and aggregate that subject to the proviso below, this insurance does not cover A, wear and tear, gradual deterioration, rusting, corrosion, metal fatigue, oxidation, auto-oxidation, dampness, change in the temperature or humidity, action of air or light, or natural heating or drying. My lord, this particular clause is important for purpose of the respondent. Now, if your lordships kindly sees page 29, the next page. At the bottom, basis of indemnification. All property other than stock, refractories and consumables. In the event of destruction of or loss of or damage to property insured hereunder, excluding stock, by a contingency insured against, the basis upon which the amount payable under the policy is to be calculated shall be current reinstatement value as on the date of reinstatement of the property destroyed or damaged or lost, subject to the following provisions. Reinstatement or replacement shall mean, my lord, this is a reinstatement policy. Reinstatement, it is that the property damage had to be reinstated. And thereafter, when there is a reinstatement, then the value, it should be
current.
Yes, it has to be supplied to the insurance company, and it would be disbursed as per the terms and conditions. My lord, if the reinstatement is not made, it would be paid on the market value basis. That is the theory. My lord, the next page again. Why I am mentioning all this? Because my lord will find all this in the survey report, the first survey report, which is important here, and why we have ignored the final survey report, that I will indicate. Why? What was the reason? Special provisions, my lord, 30, page 30.
30, yes.
A, at the bottom, at the top, my lord. The work of replacement or reinstatement which may be carried out upon the same or another site and in any manner suitable to the requirements of the insured, subject to the liability of the insurer not being thereby increased. Not being thereby increased. My lord, it cannot enhance, it must not enhance the value of the property. Must be commenced within 12 months from the date of the destruction or damage or such further period as the insurer shall in writing allow, otherwise no payment beyond the amount which would have been payable under this section of the policy if the clause had not been incorporated herein shall be made. My lord, why I am telling all this, why I am submitting all this? Because a period of 12 months from the date of the damage, that is necessary. And it is also necessary to inform the insurance company immediately with the happening of the particular occurrence of damage. This has to be, because immediately the surveyor will go and then surveyor will see. My lord has to, being a writ court, even has to go with this inquiry that whether the surveyor was or the insurance company was immediately intimated or not. That has to also look into. If your lordships kindly come to page 31, insuring clause.
Yes.
This is a machinery breakdown. This is a rotor motor which has been destroyed in this. I mean, destroyed is damaged, not destroyed. I will not use the word destroyed, but it was damaged. My lord, this is the machinery breakdown. So this is the relevant provision. This is section 1B. Insuring clause here. There, it was previously the general insuring clause. Now it is a specific insurance clause, since the rotor motor was the matter of damage in this particular case. In consideration of the payment by the insured named in the schedule hereto of the premium mentioned therein, the insurer agrees that subject to the terms, conditions, limits, conditions contained herein and endorsed hereon, which shall be deemed to be the condition precedent to the right of the insured to recover hereunder to indemnify the insured against sudden and accidental breakdown of property insured, including physical explosion, implosion, collapse or rupture of boiler and or other pressure vessel directly and wholly attributable to any cause except as hereafter provided occurring during the currency of the policy. Sudden shall mean, my lord, is the same. Yes. In no case shall the liability of the insurer, again, that is also the same, sum insured amount that will not cross. Provided that due observance and fulfillment of the terms, condition, and endorsement so far as they relate to anything to be done or complied with by the insured shall be condition precedent to the liability of the insurer to make any payment under this policy. Breakdown shall mean sudden and accidental physical loss or damage necessitating repair or replacement before operation can be resumed, resulting from. There are 1, 2, 3, 4, 5, 6, 7. There are areas when it can be construed as that. My lord, if your lordships kindly turn to page 32 thereafter, that is the exceptions applicable to section 1B. That is the machinery breakdown. MB indicates the machinery breakdown. My lord, if your lordships kindly come to 2.1 Roman 2B, it starts with the insurer shall not be liable for, and then B, slowly developing deformations, distortion, cracks, fractures, blisters, laminations, flaws, or grooving, or the making good of defective tube joints or other defective joints or seams unless such defect result in damage otherwise insured under this policy. Well, therefore, slowly developing deformation, distortion, cracks, fracture. My lord will file the cracks here. My lord will file slowly developing deformation here. That's why I'm referring this particular clause. Now, my lord, I will place the first surveyor's report. Since this is important for the purpose of the respondent, why this has not been has been deviated from. As to the respondent, this particular survey report was found to be more with reasons than it was lastly put out. Because I will show in the letter report, surveyor simply said in one paragraph consisting of 3 or 4 lines that since an expert has given this opinion, so therefore I consider this. But
that was confined to the sudden aspect of the matter, probably.
So, yes, because that is the case. Sudden cracks developed. That is the case. And the sudden thing is accidental. Because what was happening during a course of period, that cannot be construed as sudden. Sudden is unforeseen. Sudden is that
accidental.
Yes, because that is not to your prudence. Even that is not to your prudence. If you know something has already developed and that you have not give a proper care to that, and that goes further, gets deteriorated, and for which there was a crack, even that cannot be considered as an accident. Because if you know something is happening, then you ought to have taken care of it earlier. And when there was an AMC with that particular rotor, because AMC is that annual maintenance contract, and those engineers has given some statement to this surveyor, which I will show, that it will show that there was a knowledge and there was certain incidents which was happening not at August 2018, but much prior to that. And it was within the knowledge of the petitioner. But they consider it, since VL has not told anything, so it is better to go on this matter. Suppose a smaller crack has developed, a smaller tearing of the skin has developed, so it is better to keep it in that way, and then suddenly when it goes worse, then it was taken care of, considering it as sudden. Our point is, it was not sudden at all. My lord, I have to place this surveyor's report, and I will continue with the survey report. I mean, as to the areas which I find...
Release the other matters then, before recess. We have 7 minutes.
Other matters are released.
Yes.
Original said all matters are released because after 2 p.m. I'll be
Yes,
taking
yes,
up.
yes. If your lordships kindly come to page 55.
Of the writ petition.
No, this is of my opposition. I'm all relying on my opposition. Although this report, survey report, is a part of the petition also, original writ petition. My lord, it's dated 6/4/2019. Further to the instruction from the Kolkata Large Corporate and Brokers Office of the Insurers, New India Assurance Company Limited, we visited the insured above mentioned plant on 24/9/2018. We carried out our inspection of the affected rotor. My lord, why I am telling all this, why I am submitting all this? Because this is necessary to know what is the rotor, how it functions. Because now the Honorable Court is in the function of inquiry. Yes, now, so Lordship has to know all this. But what I have taken the plea in my opposition is that there requires a recording of evidence of the engineers of the well. The very evidence, it might go in their favor also, in the favor of my learned friends in the adversaries, that surveyor has to come, surveyor has to also justify, because we have taken note of this. We have certain meetings, and then we have, as Lordship, several catena of judgments has been placed before your Lordships also to that effect, that it is that the survey report is not sacrosanct. We might take, respondent might take, insurance company might take, if it is found that it is reasonable. Why?
Did not give any reason for not disbelieving the second survey report.
Yes, not second survey report. Survey report, my lord, I have to gone down with this particular aspect also. Survey report is a final survey report. There was one addendum that was put. Addendum was put, and thereafter
It was additional report, not final report, additional report as per
it
your
was the
policy.
addendum to the final survey report.
Yes.
But that was, it has got a time limit to give. However, since it was our surveyor, we are not questioning that thing also.
So it has to be taken in the light of the main report also.
Yes. So I'm placing the first report because that is the addendum. So this is in addition to this.
Right.
My lord, if your lordships kindly come to page 56. The insured background information. The insured, lordship kindly sees it.
Just give me half a minute.
It's page 56.
Yes.
Background information.
Right.
Under heading A. The insured, the West Bengal Power Development Corporation Limited, WBPDCL, is a company owned by the government of West Bengal, which operates 5 thermal power stations at Kolaghat, Sagardihi, Bandel, Santaldi, and the affected Bokreshwar plant. So therefore, this is a Bokreshwar plant. The last mentioned plant has 5 steam turbine generating sets of 210 megawatts each. So the total capacity is 1050 megawatts. The commercial operation dates for these units were 29/11/2000, 1/4/2001, 11/10/2001, 8/3/2009, 27/6/2009 respectively. As stated, the insured unit number 2 first synchronized on 25/2000 in the affected unit in this matter. The STG set has a Fuji Electric Japan make steam turbine, while the remaining plant and machinery such as boiler, turbo generator, and ancillary equipments was apparently all from Vale. With the said last mentioned partly apparently also the EPC contractors. The affected generator is a 3-phase 50 hertz 2-pole 3000 RPM machines rated at 210 megawatts, 1.75 kV and 9056 amperes, hydrogen gas at 2 kg per cm square.
You can read the relevant portions. Why
My lord, these I'm reading. I'm reading.
2 kg by cm square won't help me.
Yes, no description. My lord, if my lord has
The
to
relevant portion definitely.
that I mean, one has to visualize
the magnitude of the.
Yes, no, just not that. What is the machine itself consisting of what? These also not my area of specialization, but yet, my lord, the generator is coupled. My lord has to see the affected generator. So the generator that has been affected, my lord, I'm reading from page 56.
I'm there. Yes. No, I was looking for a photograph.
I will come to it.
Thank you.
The affected generator is a three-phase 50 hertz, what I have just stated. The next para, the generator is coupled to the steam turbine at one end and to the main exciter at the other, which in turn is coupled to the pilot exciter. But the last is not of any consequence here. It is the rotor of the generator that has been claimed as destroyed in the loss. Now, my lord, kindly come to page 58. My lord, I am also skipping the areas.
Yes, yes. The relevant areas definitely, please.
Yes. Occurrence at the bottom.
Occurrence. Yes. Should we continue with on the next date?
Yes, my lord. My lord, tomorrow then?
Yes, yes. Place of occurrence will be the same, but we'll continue tomorrow.
Before my lord rises, my lord, matter was mentioned by Mr. Shijiv Chakraborty for leave to file the matter and move the matter on Thursday. My lord, at that point in time, my lord, appellate side court officers were not there, my lord. I'm sorry for bothering, my lord, but matter is of extreme urgency, my lord.
Thursday for moving on.
My lord, if
what was the leave given? Liberty.
My lord has not given a leave. My lord has asked me to.
What is the leave you are seeking?
I'm seeking the leave to file the matter and move the matter on Thursday, my lord.
Leave the other minute.
My lord is pertain to port player bench, my lord.
Yes, yes, port player bench.
Lordship, forgives my impertinence for
mentioning
out of turn.
No, mentioning now because I
not-
this was mentioned in this morning.
It was, my lord. I was under the wrong impression that your lordship takes up the appellate side mentionings at the sitting of the appellate side.
Hand over your slips. If it's inclusion, hand over.
Only for inclusion.
You also.
Lordship, my point.
You also hand over.
Lordship, it is supposed to appear before Lordship on 7th of this month, as per the order. And we have mentioned before the Honorable Vacancy Bench also. It is not appearing, Lordship. I'm restraining the order.
Appellate side.
Appellate side, Lordship.
Regular officer is not there. That's the difficult.
Yes.
Anyway, we'll check up.
Lordship. Deep Lordship.
My lord, I am for the petitioner, my lord.
I am for the respondents, my lord, in this matter.
My lord, on the last occasion, my lord.
I file my affidavit in opposition, your lordship.
Yes, reply. What about reply?
My lord, reply, my lord. Because it has been complied with, my lord.
Oh, complied with.
Only thing, my lord, though your lordship was for back in on 15th of July 2021, they published the response sheet. There were some anomalies, my lord, on 24th September 2021. By a notification, they cleared the anomalies. It can be disposed of with this. I have got
taken care of by
yes. I wanted the answer key, my lord. They have given the response sheet on those dates, my lord. Why it is important to mention those dates, my lord? I need to challenge the answer sheet. There is a limitation, so that those dates are to be important, my lord.
Dates are to be mentioned in our order.
No, my lord. Your lordship
No,
directed.
you have got those already.
Yes.
So we can dispose of them.
Yes.
Why did you comply? We could have a long hearing on this.
Yes.
Wait. The thing is that the question.
No, very. We'll record that and just dispose.
In 2012, there was no such provision. Only the thing is that provision has been amended later on. So the key answer was not there for distribution. It was only provided with the rules afterwards. And that is why then we have mentioned that we have also given the attached the key answer sheets as also their answer sheets both in the.
We'll record our satisfaction and that's. Learned counsel for the
SABYASACHI.
Learned counsel for the alleged contemners filed an affidavit in opposition. Affidavit in opposition corner files a compliance report in the form of an affidavit. Full stop. Learned counsel for the petitioners also submits that the alleged contemners have complied with the order of this court and as such the contempt application may be disposed of on such observation. Full stop. Next para. Learned counsel for the alleged contemners submits that in view of an amendment having been effected in the meantime, the alleged contemners had no impediment in complying with the order duly. Full stop. Be that as it may, since the order in question has been complied with, there is no use of keeping the contempt application pending. Full stop. Accordingly, WPCT 116 of 2017 is disposed of as
WPCT content number is CPAN 503 of 2000.
WPCT. Oh, I'm sorry. Extremely sorry. CPAN 503 of 2018 is disposed of as infructuous without an orders to cost.
May your lordship be kind enough to record that submission? They have given that on 15th of July 2021 and clarifications to that were made on 24th.
Why is it relevant? I mean,
Look, the affidavit is
in the website.
That is kept on record, yes.
Of which date?
Does it affect you in any manner?
Yes, my lord. There are some wrong questions in the answer key. I have challenged that. So for need to challenge that, since the examination was of
no, if you want to challenge any, if you have a further cause of action, you have a further cause of action.
Subject to correction before the tribunal, my lord, there is a 1 year. The examination was of 2012, but if I have got in 2021, I could not have challenged in within that 1 year period. So it's my submission.
In contempt, what can we do?
That my submission we recorded that got that in 2021. So that I can.
The thing is, we have already filed the affidavit in, affirmed the affidavit on 15th November 2019. Your lordship,
What is the date when you got it?
It was published.
When did you get it?
On 15th of July 2021. It is the official date. Kindly see the response sheet, my lord.
They're disputing that. Let us see.
No, this is my submission that I want. Then,
you know, "22 elements, 2017. That is the date when we have given the copy.
No. Then we cannot record those things.
My lord, my submission, your lordship may be kind enough to record my submission.
Compliance.
Record your submission. Why should you record your submission in this? I mean,
my lord, only difficulty is, my lord, the order was passed in 2017. If I have got it in 2020,
you can take it in your further challenge.
No,
you have to take it in a further challenge that he got it on such and such. If that's a disputed question, why should you record it in contempt? We cannot give a handle of preference to you or them
No, that's
on it. If you record your submission, that will go on record. Why should you do that? You can satisfy the court where you prefer the challenge. If you prefer a challenge, they will also have an opportunity to do.
Pending itself.
Yes, in that. Bas, যা বলেছি তাই. This much. Thank you.
I'm obliged.
May I permit to mention? My lord, may I permit to mention
We have
listed
taken up several mentionings. Hundreds of matters have been mentioned in the morning, Mr. Haldar, no further.
My lord.
Call. Number 1.
Item number 1.
Accordingly, WPA 1641 of 2023 is dismissed on contest without, however, any order as to cost. Urgent certificate copy. It upload for the dismissed. Yes. এবার 2 PM কি ফিক্স আছে ওটা?
ওই আইজি কে দেখুন না একটু। ওনারা বসে থাকবে কেন ওরা তো
হ্যাঁ বলুন 2 PM ফিক্স বলে 6 answer.
Item number 69 and 70.
এটাই তো।
My lord, I am for the applicant, my lord.
My lord, I am for the contemners.
Oh.
My lord, in terms of your lordship's order, my lord, the IG is here, my lord.
Yes. What was the contempt committed according to you?
My lord, contempt is that to the effect that, my lord, your lordship had been pleased to pass a direction upon them. My lord, since my lord, they have failed to follow the Indian Railway Medical Manual particular paragraph, my lord, your lordship had been pleased to direct them, my lord, for my lord, grant of alternative job and my lord, issuance of decategorization certificate. With the my lord, further direction to pay the arrears, my lord, from the date I was placed in under the sick list till date, as well as my lord, they said they have been directed to my lord, making the continued payment of my salary with effect from the date of this judgment. My lord. May I take your lordship to page 24 of the petition?
So not yet complied with.
No, my lord, I am telling you, after your lordship had been pleased to issue the rule, my lord, I have been issued with the decategorization certificate. And I have joined the post, my lord, I am working. Although, my lord, I am working, no post has been granted to me, a particular post, but I have been, my lord, allowed to join. And, my lord, the arrears, my lord, with effect from the date of the order that has been paid on me on the list last Friday. But the, my lord, particular arrears, which is a lump sum one, my lord, for the period, my lord, from the period, my lord, I was placed on the sick list, that has not been paid till date.
Show me my direction once again.
My lord, page 24. May I take your lordship to paragraph number 31, my lord, particular paragraph?
Yes.
But hence, in view of the aforesaid findings, WPA number such and such is allowed, thereby setting aside the decision of the respondent authorities to reassign the petitioner to his original post and directing the respondent authorities to immediately issue a decategorization certificate to the petitioner in compliance with the previous order of this court. In the alternative, to issue a certificate of change of occupation to the petitioner and to assign the petitioner either to a lighter category of service in the railways or with lighter duties in similar category.
They have given a decategorization.
This has been.
Now,
my lord,
32, yes.
32, my lord. Till such new assignment is given to the petitioner, the respondent authority shall disburse all arrears of current salary to the petitioner. Such arrears till December 2021 shall be disbursed latest within 2 months from date.
This was not. This has
not complied, my lord. Thereafter, my lord,
The latter portion.
latter portion, my lord, they have complied on last Friday, my lord. That is, my lord, on 9th.
Yes, Mr. Bajpayee, what about the previous?
My lord, the major part has been complied with.
What about the minor part?
Minor part is this, my lord, that the last part of the thing, half the arrear salary has already been paid, but only the half portion because of lack of fund, my lord, we need some time to only on the question of arrear salary.
Union of India also has lack of funds.
No, my lord, they have paid and the supernumerary post has been created.
Mr. Bajpayee, I'll record the Union of India does not have funds to pay.
No,
comply
my
with
lord,
the court.
we will pay within
I'll
a
record
very,
that in my
no,
order.
my lord, we will pay within a very short time, my lord. That was
No, you were directed to pay within 2 months from that date. 2 months from
only that part is left, my lord.
January 22, you are directed.
Yes.
Within 2 months means March 2022.
My lord.
So why shouldn't your client be in jail, Mr. Bajpayee?
That is true, my lord.
Give
But
me one reason why he shouldn't be.
My lord, we have complied with your lordship.
You have not. You have not.
Only the area part of the thing is.
Every order has to be on the sword. It has to be done, Mr. Bajpayee. This is not proper.
In its totality, we should have complied, my lord, but.
Should have, I also know, but why didn't you comply with? A rule has been issued.
Yes.
I have to either discharge the rule. Why should I discharge the rule? He should be behind the bars then for at least a month.
So, my lord, the IG is here, my lord. Let him pay within the date fixed, my lord, within a day.
What is the area due? Does he know even?
Yes, yes.
Yes. It is for 700 some days.
Yes, Mr. Bajpayee.
He is saying it in number of days, 700 days.
700 days, I mean 2 years, my lord.
2 years.
What will be that quantum?
Around 15 lakhs possibly.
15 lakh. What is his monthly salary? Please ask him.
33,000.
Take home salary. What is the take home salary? Please ask him.
Take home salary.
31,000.
31,000.
31,000.
My lord.
So 15 lakh, how many months salary that does it come to?
2 years salary.
His salary. Your client's salary, that is 31,000. The person who is standing in front of me, the container, his salary.
Apnar salary.
His salary 2,24,000 per month.
2,24,000. That means about how many days salary? I'll attach that amount, Mr. Bajpayee. Either jail or he has to pay that amount by within a week. Why not? 15 lakh within a week. Let him pay it.
No, 15, half the payment has already been done.
No, that is with respect to the another part, my lord. He is saying that
What has not been paid up to date?
My lord, the
Till
arrears,
2 years salaries.
yes, arrears till December 2021, my lord.
Arrears till 2021, but from when?
From my lord, from the date, my lord, I was placed on the sick list. That
Give
is
me
what
the
I'm
date.
telling.
Give me the date. Give me the exact quantum. The container will pay that. Otherwise, they'll attach his salary.
Half to deal diye.
No, just give me a minute, my lord.
Take your time, Mr. Bajpayee. You are not ready with it. Naturally, you won't know. How would we knowing how much your employees get? Why should you know even?
No, my lord.
Shouldn't know. But now you will know, definitely. I'll ensure that you know before you leave the courtroom. Take your time, Mr. Just find it out for me and tell me the exact quantum. Take your time.
My lord, my lord.
Right now.
My lord, my lord.
Find out from somewhere what is the date.
Around 15 lakhs.
15?
15.
It's from 2019, exact month, my lord, I am saying, my lord.
About?
My lord, it is from 2019, exact month, my lord, I am saying, my lord.
Calculate the amount, come back tomorrow.
My lord.
The 15 lakh, how soon can you pay that? Day after tomorrow? 1 week, I'll give you 1 week. I'll keep it 1 week after. Pay 15 lakh.
15 days.
My lord,
Learned counsel for
he is praying for 15 days time.
Acha, the contemner is present in court today and submits that a decategorization certificate has already been issued in terms of the court's order dated January 25, 2022 to the petitioner. Next para. Learned counsel for the petitioner, on instruction, agrees with such contention and further submits that the current dues on and from January, 2022 has been released in favor of the petitioner only a few days back. Only day before yesterday. Only day before yesterday. The day before yesterday. Only a few days. Stop. Next para. However, comma, the arrear salary till December 2021.
It is from November 2019 till 24th of January 2022. Till the date of passing the order, Milord. I am about to get.
The arrear salary till jeta na bole. The arrear salary from 19th November.
Arrear salary from November 19.
From November 19, 2019.
Yes, Milord.
Till January 4.
Till January 24, 2020.
Till January 24, 2022 has not yet been disbursed in favor of the petitioner. For sub next para, upon specific query of court, comma, as to why the petitioner should not be penalized for patent contempt of court, comma, it is submitted by the contemner that he requires 15 days further time to clear all the due salaries of the petitioner for the relevant period. Full stop. Hence, comma, prior to penalizing the contemner for blatant violation of the court's order, comma, a last chance is being given to the contemner to clear all the arrear amounts in favor of the petitioner. Full stop. Accordingly, the contempt application shall next be listed on June 27, 2023 for being taken up at 2 p.m. Full stop. The contemner shall remain present personally on the said date as well, comma, for passing further orders on the rule. Full stop. It is expected that all dues of the petitioner in terms of the order dated January 25, 2022 shall be cleared off in the meantime by the contemner through the appropriate authorities. Full stop.
My lord, he has joined the post. He has been given, and we are trying to put a supernumerary post.
I'll pass the composite order on the next date.
My
First,
lord.
let this be cleared off.
My lord.
My lord. Grateful, Milord.
For it. And Mr. Bajpayee, he will be present on the next date also.
Definitely, definitely. My lord, it is your lordship's order.
At 2 p.m.
My lord, so on the next date, my lord, we will file compliance report.
Do that. I have not directed you anything. Do that. That will be better.
My lord.
Yes. If he says yes, he has received, I am satisfied.
My lord.
He is the petitioner. But don't force him to say.
No.
Grateful.
Sometimes your lordship sweet.
So, Mr. Bajpayee, thank you for cooperating with the court also. You are an officer of the court. Definitely, you are doing a job that I can appreciate.
My lord.
It's nothing personal. Absolutely. No. Thank you. Call on the next matter, please.
Number 2 and 3.
2 and 3. Yes. Yes. Yes, Mr. Ghosh.
I am for the response.
Right. Mr. Bhattacharya is there for it.
Yes. Well, a subject matter of the writ petition.
Yes.
Is a tender for extraction of coal.
Right.
The tender was floated sometimes in 2017. Notice inviting tender was given and the tender was activated or executed in 2018 by awarding the work in favor of the lowest bidder, that is the petitioner before your lordship. Now, my lord, the tender was in respect of 152 point odd acres of land, 52.70 acres of land. That tender period was 6 years. Well, out of that, 36.31 acre was actual position given, 29.44 acre is handling and 29.54 acres was for extraction. Now, my lord, the description of work is mentioned in our writ petition, page 22. What nature of work? There was a provision in the said tender process or the work order that they will be supplying the blasting permission in favor of the tenderer. We had to blast the coal mine for the purpose of extraction of the coal out of it. ECL is the company. Although tender work was given in sometimes in 2018, the position was given according to the paperwork. The blasting permission was given in the year 2022. Blasting permission was obtained by the ECL from the appropriate government T21, and they were sitting tight over it. For 7 long months, they sat tight with this and did not deliver the blasting permission in favor of the petitioner. That is mentioned in one clause is mentioned in page 117 of the writ petition. If your lordship kindly come to page 117.
Yes, Mr. Bhattacharya.
117. That method of mining, no blasting can be permissible within 100 meters.
Page 117.
Yes, lordship will get it at.
This is which writ petition? 5179.
I am reading.
Yes.
This is 5179.
Sorry, I was on the other one. Very well, got it.
5179.
Method of mining, yes.
Method of mining, gradient of seam in gel 10 feet to 18 feet is proposed.
Right.
Secondly, while working on coal seam wedge shape strip formed at end cut will have to be mined by, due to occurrence of the multiple coal seam, leave it for open cast operation. The topsoil will be removed. Will have to be removed. The topsoil shall be dumped separately along with the national bank needles to be used in the latter date for capping. The dumper, next is dumper. Mala, kindly come to page 177. I am very sorry. 177. Yes, that is there. Permission is 3.0. 177. That permission. No 3. No blasting for removal of overburden or for extraction of coal shall be done within 100 meters of any surface structure, building not belonging to Eastern Coalfields. The restricted zone room, the nearest dwelling structure not belonging to the management shall be clearly demarcated on the plan as well as on the ground by conducting actual survey. Now, this is a prohibition regarding the blasting, a condition precedent. Now, in the plot, my lord, is page 100. They have 131. Page 131, they mention that there are 2 villages inside the said lease area. Kindly come to 131 at the top.
Yes, 2 villages.
2 villages within the proposed zone of work.
Who is saying this?
Bala, kindly come to from page 130. It is it is work order. A project report. This is the project report. This project report is provided by the ECL, page 130. Kindly come, details, the description has been given about the land character, page 130. Out of total 100 at the middle, lots will get you. Out of 150.70 acres of required land, 110.98 acres of land is to be purchased, The 152 is not given at all. Is to be purchased, 95.64 acres tenancy and 15.33 acres of government. Government's khas land is there, not belonging to ECL, and 95.64 acres are tenancy. And balance 41.73 acres of land is under possession of ECL. It appears 47 employment is to be given against these lands. But this 41.73 even is not in the name of ECL. That appears to be in the name of others, other third parties. Kindly come to page 160. I have mentioned it, Lord Shubhil has seen at page 131. 2 villages are within the proposed work. Yes. Brief villages names are there. Lakhonpara Bosti, whatever, and Bila village. Right. These are the approximate population is 347,198. Number of families is 229,131. This is the encumbrance in the property, my lord, which has been handed over to the petitioners. Kindly come to page 160.
Yes.
But the letter is given. Lord Shubhil has seen the possession was handed over sometimes in 2018. In 2020, that this letter is given. Kindly, when we are on working, plots under court case. This is to bring to your kind information that some plots under Bila Mouja are in the court of the civil judge, Junior Division Court of Asansol, lodged by villagers. Those plots are within the working area of Itapur OCP. The details of plots are given below. The plots names, number and particulars are given. The land use plan showing the above mentioned plot is attached herewith for your ready reference. Now above mentioned plots are in untouched condition, in original shape and size during working to maintain the order of Honorable Court, not to change the nature and character of the suit property. So you must need to maintain the status of the plot remain unchanged as in original during working cutting of the land at Itapara OCP. 2 things are, my lord, coming out from this letter, that these lands they gave to us, my lord, for the purpose of mining operations as per the contract. And second phase, that they themselves say that these plots should not be allowed to be used. The 152.70 is absolutely a camouflage. Now kindly come to, my lord, page 175.
But this area is very minimal. I mean, out of the total thing, this court case area is not very much. Total area is 0.47 acre. I suppose.
Court case is one aspect of the matter, my lord, and
there are 2 other aspects also.
Government lands are there. Government lands are there.
Yes.
Next page, 175. Kindly, my lord, we were given a notice. A show cause was given to us. Page 161. A show cause was given 14/9/2020. They asked us not to work on 22nd of September 2020 at page 160. 6 days before that, a show cause was given to us. 14/9/2020. You have been awarded the contract to work for removal of 36.31 Elcom OB 29.44 Elcom rehandling and extraction 29.541. Total for 6 years at Itapara OCP patch in Salanpur area, white number so and so. Period is mentioned. Coal extraction parameters have been given. Year-wise performance has been given. From the above, it is evident that you are performing the work as scheduled. You are not performing the work as per the schedule. It is happening because you have not deployed the requisite fleet for the operation of the, as found during the various inspection done by the ECL management as per section so and so, that the company shall have the right to inspect the arrange inspection. Leave aside that, my lord. I further on different occasions, numerous letters have been given. Next, my lord, with respect to the above mentioned issue, you are asked to submit the explanation. But last paragraph, in view of your poor and unsatisfactory performance in the above mentioned contract work, you are advised to show cause within 7-day receipt of this letter as to why the partners in joint venture and their properties should not be proprietors should not be banned for doing business with the ECL in accordance with the CIL guideline for banning of business under clause number 2, which states failure to execute the work as per the mutually agreed work schedule continued, and repeats failure to meet the contractual obligation and willful suppression of fact or furnishing wrong information, so that the participation in future tender of ECL is completely banned. Kindly mark the word future tender, not in respect of this tender.
For 3 years.
For 3 years. Initially, it was done for 1 year. Thereafter, it was increased to 3 years.
So there are two limbs of the show cause, two limbs. One is that you are not performing properly, which is covered by your other argument. But the other aspect is in the bold letters, engagement of work persons, non-distribution of timely wages and all these things. Those are also there.
Also there.
Very well.
Now, my lord, kindly come to our reply at page 163. 163A is a typography.
Yes.
The land which I am going by the clauses, reply to show cause.
Hmm.
The land which had handed over to us for mining were not owned by ECL. Only 3.84 acres out of 32.49 acres having ECL land. A copy of the land schedule attached herewith. So off and on, the owners of the land stopped the mine. Thus, the production suffered very badly. Blasting permission of Itapara mines have not handed over to us till date. Till 16/9, my lord, we did not get it. We got it in 2022. Government gave them the permission to blasting in July 2021. The ECL has given us the blasting permission in 2022 only. Blasting permission, Itapara mines have not been handed over to us till date. So let us know whether we are doing blasting legally or illegally in the private land of the local villages. Copy of DJM permission for mining operation of Itapara mine also did not supply to us till date. Director General of Mines, well, he has not given us a permission. Ownership of the land document of the mining area did not hand over to us as per your order. We are doing mining operation in local private land, which is very risky to us. Hence, you have to give us the undertaking for any legal action or incident in the mine. You will be liable. You also should be liable to pay compensation to us for incident and damage for loss. Till we are in dark whether environment clearance has received or not from the concerned office of the government. Further, Bilabosti and Lakhonpara were not rehabilitated. Till date, no action has been taken for shifting of the villages. As per project report and NIT, the above two Bosti should have been rehabilitated before starting of the mining operation in the area. As per project report, quantity of the underground water has been calculated 500 square meter, but actually it is 1200 square meter, which is much more than the estimated amount, till management not taking proper decision. In view of above consideration, you cannot blame us for failing in execution of the work as per the mutually agreed work order as per NIT. Rather, we can say that due to so many shortcomings in your end, we have faced a heavy loss during operation of the mining. In the meantime, COVID also came. COVID came from March 2020, all lockdown, up to next year, November, September, it was normalized, 2021. We did not mention that even. Kindly come, the ECL's minutes of the meeting, on the basis of the representation reply given by us, page 165, the ECL's minute. On a personal hearing with our representative, number 1, this is dated 7th of October 2020. Number 1, what is the reason for non-achievement of the target in the year 1920 and 2021 till now? Answer, due to land constraint, our answer. Second, you have not deployed the required capacity and the number of equipments as per need. Why? I have deployed, but when there was a problem on working due to land, it was diverted to other location. Third, since you have restarted from 18/8/2020, have you faced any problem in mining operation? Stagnant water in the quarry to be pumped out before going downward. We are aware of the target that you are aware of the target. Are you aware of the target? This year, what is the strategy to achieve it? I am very much aware, and if there is no constraint in operation, then we will achieve it well within time. Your crusher is not working. How long it will take to put it in operation? It will be replaced within a new crusher by November 1, 2020. Have you paid the wages due to your workers? It has been paid for the day they work and no due are there. Are you maintaining all the statutory requirement? Yes. May I skip over the next page? A decision was taken at page 167. The banning order was passed. That will get at page 168, second paragraph. Further banning. Therefore, second paragraph, therefore, in the interest of ECL, there is no option but to ban your farm. Nothing has been dealt with the allegations, my lord, that has been, answer has been given by us. Ban your farm, the joint venture, from the participation in future tenders of ECL for a period of 2 years, keeping instant contract alive. This contract was kept in live ballot up to 6th of June 2023. Kindly, my lord, come to next page, page 169, the ECL's letter. But this letter is recommended to the appropriate authority. That is subject is revocation of banning order for doing business with ECL for Messrs. So-and-so, Messrs. So-and-so, joint venture. A work order for hiring of HEAM, come rehandling of the extraction of the so-and-so, Itapara for the period 6 years was awarded to so-and-so, the petitioners yet the company, due to continuous non-maintenance or non-achievement of giving target OB and coal production, Messrs. OTIF and its constituent partner, so and so India, Messrs. Upendra Prasad and brothers has been banned during doing business with ECL for a period for the period of second year, white letter dated so and so 10/11/2021. In this regard, the contractor has submitted a plea to revoke the banning order. Grounds for consideration of revocation of banning order: unavailability, that is ground number 1, improved performance of the contract since the proposal of banning was sent in June 2021. Despite various hindrances in the operation, the summary of performance is given below. That has been given by the technical terms. And next is unavailability of the adequate land for mining operation due to adequate number of mining equipments could not be deployed. The unavailability of adequate land for mining operation due to court cases relating to A3 lands. Next page, third ground, the contractor has engaged more number of machines than listed in NIT. Fourth, his contractor has also given an undertaking to the management that he will continue such performance in the future. Hence, based on the hindrance in operation and the improved performance of the contractor, the banning of the business order and his constituent partner, so and so, Upendra Prasad, brother, can reconsider for revocation so that the contractor can be motivated to continue its good performance. Proposal is being placed before the competent authority for kind consideration. Who is writing, my lord? Manager, Itapada OCP, General Manager, Salanpur area, Agent, Itapada OCP. Well, this is, we have not received any answer to this till now. Kindly come to next page also, a reminder has been given for revocation of the banning. 1st of December 2021. Kindly come to page 172 at the bottom, last paragraph. Therefore, considering the above mentioned factors, it is proposed to revoke the banning order imposed and its constituent partners from participation in future tenders of issue ECL for a period of 2 years, white so and so that the contractor remains motivated to continue its improved performance. The authorities, but here authorities are more joint here. Not only the Itapada OCP, but the finance Itapada, manager Itapada, Salanpur Itapada, area finance manager Salanpur area, GL manager Salanpur, and they all recommended may be considered.
What happened thereafter?
Nothing has been considered. Only, my lord, lordship will kindly come to page 176. This is dated 20th of February 2022. Blasting permission. This ultimately, my lord, finally came to be seen by us. This has been given in 2022. Enclosed, please find herewith the blasting permission obtained from DGM to conduct default blasting in respect of Itapada OCP for your perusal and necessary action, please. This is dated 22nd of February 2022, and next page, my lord, will show the permission was received by them on 30th of July 2021.
So who is initially for 2 years? 3 years.
Ban 3 years.
Initially for 3, then 2, extended for 2 years.
Extended for 2 years. Right. Total banning কত ছিল?
1 Miller, then 2, then 5.
1, 2, 5.
1, 2, 5. First banning order, Miller, not annexed. Second banning order, extension annexed. Third banning order, which is in July, not annexed. Not challenged.
Lastly, they have been further banned
for 5 years, Miller, because making a misstatement, because they were banned. They participated in the tender process.
In a tender process, the clause is there. If there is a ban, good, bad, indifferent, you have to disclose it. No, it's for the tendering.
When were they
authority
banned
side.
last time? For the last time?
Millard, I have it the last one. Millard.
Approximately which time?
Millard, I have it with me. Millard. It's Millard, last Millard, 7th of June 2023.
7th of June 2023.
2023.
That is during pendency of this.
Pendency. I have given show cause notice. He attended personally hearing, Millard. Not that I have not done anything, Millard.
Well, matter is before the court.
Matter may.
How can you change the texture of the entire case?
There are 3 notices.
Given you can you are.
Anyway, let Mr. Bhattacharya finish. Mr. Ghosh, I'll come. Yes, Mr. Bhattacharya, what else?
Now, my lord, because of this, my lord, because of this banning, we have made a letter at page 1.
Affidavits were not directed in this matter, as yet. Affidavits have not been directed.
No, no.
Anyway, then Mr. Bhattacharya, what happened?
Page 1821 is the letter of the lawyer's letter.
Then let them disclose these documents, Mr. Bhattacharya. If you have been banned again, if you don't challenge it, even if during pendency of the writ petition, how can we finally dispose of the writ petition?
Well, a question of banning, my lord, is absolutely unjust step taken by a public authority. Lordship has seen the conduct. First of all, position was not given. Secondly, you have imposed a condition that villages are there, don't go for blasting. Don't go for mining work.
But even if you win this writ petition, the last banning order remains on a different ground.
Last banning order during pendency, Lordship can take cognizance of the same.
So that is on a different cause of action. Not an extension
They
of
have not
this
been
case.
communicated.
You are present there, they say.
Who says? Where's the meeting? After the matter was started,
They have got it. If they're permitted to disclose.
It's not a question of disclose. Close this.
No, no, you should have disclosed this. My learned senior friend.
Kindly show it, court.
First, Millard,
I have
first
not
banning order,
disclosed.
he is challenging Millard. That's not annexed. So,
Banning
the first,
order recommendation was made, withdraw the banning order.
Bhattacharya, are you seriously saying you have not been banned within your knowledge in the meantime?
In the meantime, in the meantime,
I'll disclose it.
Banning order.
His expression is ample disclosure.
I have it everything, Millard, I'll disclose it.
কোর্ট মামলা চলাকালীন কোনো অর্ডার হয়েছে?
না, order হয়নি, এখনো order
2020 banning,
You are called before the litigation started in a meeting, but nothing was communicated to him during the pendency of the writ petition.
I have the mails with me, I'll disclose.
How soon can you file with the
Problem
opposition?
is, Millard, I was Millard.
Opposition, how soon can you file?
I can file. The problem is contract has come to an end. Kindly, Millard,
No, contract cannot come to an end.
Millard, he
During the
cannot say what will continue to end. He can't say that.
Kindly one thing. Banning order was effective for future contract. When the subsistence of the existing contract, how can you exercise your power by giving a contract to a third party?
Millard, the
Your
contract,
contract has expired. The present
expired
contract.
during the pendency.
Now your challenge to the ban remains then.
yes.
Contract, it is a
There are two components. One is that you're during your subsisting contract, you are debarred from doing it.
I pray for extension of the same.
Millard, it will be
How can it be extended?
can't be.
It is because of the
Your challenge remains to the further ban.
The force majeure clauses have come in the way. They have not given position even to
These are
admitted.
new grounds you're taking in there. That was never communicated to them also, force measure.
That is also another writ petition pending.
That Millard, Lordship,
petitions are-
I was not served with
Lordship.
I have the register. I was served with the writ petition at 4:45, 3:45 minutes.
No, we can keep alive your banning, which is already alive, but your contract has expired automatically
Expired.
by efflux of time. Not
Millard,
if there are,
contract means first contract expired 6th of June.
now you are only on the banning. The banning for the further period that remains against you.
No, last day your lordship directed that during the pendency of my subsistence, my lord, you cannot give a contract.
That
Lordship-
Millard, I did not
Lordship
have the
observe.
papers. Millard,
Lordship
that
observe,
order
lordship,
will,
and look at your lordship's
Millard,
first
that
order.
will be granting specific performance by
There are
way of
two
a
writ
mandamus.
petitions.
It can't be done.
What is the date of that order?
Kindly, last order.
Millard, I was not sir. Millard, I have an issue on that. If Lordship Millard is with me, Millard, I'll point out.
The 6th of June.
I did not have the papers.
Last order.
I have the register of Millard, ECL Millard, which says Millard, I was served
order.
at 3:45. Millard, the matter was
No,
moved
that
in
is
the
different
morning.
issue.
That's his main
The
issue.
court has
You said that
directed
he
you
was
not
served.
to go.
You said that he
Not
was
to
served.
venture for settling the
was of the
property
view, the
in
court
favor
was-
of any other.
The court was of the
The
view
matter is
that
decided by
even
the
if you don't appear, I can grant ex parte. But Millard, the fact of the matter is, Millard, the writ was served at 3:45. Millard, I was in the morning, I prayed for an accommodation. Today, Millard, extension is at the discretion of Millard, the company, Millard. He can't compel me to give him an extension, Millard. He can't.
There cannot be a mandamus by a writ court.
For withdrawal of
That
banning.
recommendation is subject to approval by the higher authority.
What is
There
the
are
decision taken?
there are 14 letters asking him to work. He has suppressed all letters. And third, Manning has been duly served by an electronic mail.
And we have given about 10 letters, for giving us the position of land. That has not been given.
I'll argue, on this whether this order
Further
can
contract, Mr. Bhattacharya, you would sustain because your contract has expired by efflux of time. They can go because this is coal extraction. This cannot wait for a particular.
We are working. Even today we are working. Even after that we are working. Continuous work.
After efflux of time, the contract period is over now.
The period is over.
Contract period is over.
They did not deliver our position, therefore they are supposed to give us the time.
The extension clause.
Position has not been given.
Kindly have a look at the extension clause.
What is your defense on the position?
And provision for extension is there.
Mr. Ghosh, please. Mr. Bhattacharya.
A. Millard.
No, you have to file an affidavit very soon, Mr. Bhattacharya.
18% land, I haven't given him. 18%.
When can you file your opposition? You'll have to
I can file very soon, but so far as this is gone, kindly hear me on this.
On what?
Contract has expired by efflux of time. There is a
taking
clause
note of that,
contract.
Mr. Ghosh, the previous order was passed.
Yes. No. Lordship did not hear me. I did not have the papers, Millard. Deepest of respect, Millard. I did not have the papers. Lordship said, Millard, that if you don't, you are served, but Millard, I can pass the order ex parte. Now, Millard, I have the register of ECL which says, Millard, the writ petition was served at 3:45. Lordship passed an order at 12 o'clock. So, Millard, there was no service.
Writ petition was served after the order was passed.
After the order was passed, I have the ECL register.
It was served.
No, I have the what he
previously,
said.
we
Senior
have
advocate
half of
should
the-
not make. Kindly have a look at this, Millard. This is the ECL register, Millard.
That day also we have
Kindly have
intimated.
Millard.
Only intimation was
I
given.
did not have a paper.
Petition was served.
Millard, the matter was kept on Monday. Kindly have the extension clause. Millard, can a mandamus? Lordship
During
is
the
granting
court
a
case,
nature.
the
Millard, in
petition
aid
was
of
handed over.
mandamus, granting specific performance.
He took the petition from us also in
Yes,
additional
I
copy.
asked for him.
Additional
Yes,
copy.
and then the order was passed. Did I read the petition?
Well, here is the evidence of service.
Millard, seeing the affidavit of service, I can see here and now, Millard, from the postal receipt when it was Millard served, when it went out of the dispatch.
Extension paragraph ta konta?
No, you file your affidavits within a week, Mr. Ghosh.
Kindly hear me on the extension part. Kindly look at.
Yes, I'll hear you on the extension.
Yes, kindly hear me on the extension.
Right.
Well, there is a provision for extension.
Millard, I cannot be compelled, Millard, by the court to grant an extension.
No.
Nobody is compelling you, Mr. Ghosh,
can't.
but I can compel you to argue if you want.
Yes, of course. For the
Do
whole
it. Extension. What is your argument on extension?
I'm very
5179, my lord. Read. The extension clause is there. I have
arguing against extension also.
No. Clause is there.
He's asking me to consider.
Yes.
Now, Millard, kindly take, Millard, the extension clause. Kindly have a look at it.
Extension clause I cannot compel you
No.
at interim stage.
No.
What is your defense to these grounds prima facie?
Yes, there is a Millard, land was given. There is Millard 18.38% land Millard not given. This
Right.
is his document he has given. Millard first banning in 2020, second banning in 2021. The extension is annexed. The first banning is not annexed. I have the
All
order.
three have not been giving him the 18% land.
18% land he is working. First, Millard, one has to tender for removal of overburden and extraction of coal. Overburden is the top part, the mud part one has to remove. Thereafter, Millard, we have the licenses,
Yes.
blasting license, Mohanpur and then the other Millard, mine Millard, Itanagar, that was Millard together.
Right.
So Millard, Mohanpur has a composite license from 2016 from DGMST, Millard. That is the mining authority. I am carrying it. Millard, thereafter the mining authority failed, there will be separate permission for the other mine, other than the Mohanpur. That was given. So I give it to him, Millard. Millard, he is getting explosive, Millard. I have the documents on record from 2021. Explosives. To blast the Millard.
No,
Millard,
having explosive does not mean permission to blast.
yes, I have the permission to blast.
You had.
I have.
They were not communicated, only in
I have
2022.
given Millard the first permission and the second permission. Millard, first.
Your only permission, your first permission came in the year 2022.
Yes. Millard,
He was
because-
started being banned from prior to that
Yes, because he was
for not doing the work completely.
overburden work. Removal of overburden. There are two parts. There's removal.
Have you specified that in your banning order?
Kindly take the banning order.
Let us see that.
Not before your lordship. I
There
will
are
now show the
two banning orders are annexed.
No, only one. There is only extension is annexed. Kindly have a look at the first banning order.
Yes,
Now,
give me a copy of that.
First banning order. First, 2020 2023 টা দিও না 2020 banning order কোথায় গেল দিও kindly Millard take Millard the first banning order. I give my learned friend a copy, Millard. This is Millard, 6th of November 2020. As late as that, Millard. We are today, Millard, in 2023. This does not find place in the writ petition.
Give him a copy also,
I
Mr.
have given up.
Yes.
Millard, this is the first banning order.
Right.
You are aware the work of hiring of HEM for removal of overburden, rehandling of such and such lump of overburden, and extraction of coal at Itapara OC, Salanpur area with a LO number such and such, with effect from for 6 years, with effect from 18th of June 2018. Whereas you have executed such and such coal against the target of such and such, against a target you have only upon 2720 an achievement of 16.99 in coal and 42% in the overburden. So, Millard, someone is extracting coal in 2020. He must have had the permission, Millard, or the explosives, Millard. No. Millard, that is the Millard. Millard, this is not Millard specific challenge. Further during the financial year up to September 2020, your performance is 2.98%.
No, Mr. Ghosh, please explain to me this concept of overburden.
Millard, overburden is the top part.
Right.
The clay part. That will
they have to remove that.
They have to remove the soft soil.
They have to dig up.
Remove, use Millard machineries, HEM Millard. That
second part is this blasting.
Blasting, then extraction of coal.
True.
So, Millard, first part, Millard, till the overburden is done, Millard, naturally the entire land need not be given to him. Millard, there is a tender clause, land will be given in parts.
Right.
So, Millard, he has been given the land in question. So, Millard, first there is a show cause notice, personal heading culminates in the first banning order, which is before your lordship. What is the banning order? It's a banning order that if you don't improve the performance, because all notice inviting tender provides that this is the other general conditions of tender, Millard, will apply. That is, Millard, page 37 of your lordship's brief, Millard. Now, Millard, that Millard, first it culminates into a banning order. The banning order doesn't say
your banning order continues after OB.
After OB now, in spite of you have given sufficient opportunities by ECL, I have Millard at least 31 letters to execute the agreed quantities as per the terms and condition of the agreement, and you issued several letters.
You mean by execute the agreed quantities has to pertain to the extraction?
Extraction, if there is a chart, Millard, I am showing those letters, Millard. Those are not on record, Millard.
Yes.
Into several to improve performance, to deploy sufficient requirements of the NIT. You did not deploy sufficient equipments as per NIT, resulting in poor performance of coal and overburden at Itapara, OCP, such and such. Whereas a show cause notice for banning of your farm and all the partners and joint ventures number such and such, your reply of the show cause was not found satisfactory to the management. So, lordship has to see the show cause order with the banning. Now, Millard, it has been categorically held for observing the principle of natural justice. A personal hearing was issued to you with a reference number such and such, and a personal hearing was conducted on 7th of October 2020. The Salanpur authority did not find the reply statement of the representative joint venture to be satisfactory. Whereas the ECL has incurred huge irreparable loss due to poor performance, your consistent poor performance shows that you are likely to severely impair production capacity of our company if allowed to do business with ECL in future. The Salanpur area has suffered a loss of such and such coal and overburden up to September 2020. Since the start of the work, despite repeated reminders, you have failed to deploy required machine, which have resulted in poor performance. There was no initiative on your part to meet the short or targeted production. Therefore, in interest of ECL, there is no option to ban you and your partners of your joint venture participating in the tender for a period of 1 year. In above, Messrs. Such and such and a constituted partners and Messrs. Such and such are banned for 1 year for participating in future tenders of Eastern coal fields. Ban will come into force from date of issue of the letter. This is approval of the authority. Now, Millard, this banning order is for 1 year. And what is agreed is schedule, Millard. This is second writ petition. It's page 81 of the second writ petition. The schedule. Per year, how much work he has to do. This is work schedule and forms part of the notice inviting tender.
Right.
So this is a incident in 2020. We are in 2023. So this banning order has not been stayed.
In September 20, may I interrupt? September 2020, COVID was very much in full, and there was a lockdown going on.
Milord, COVID is only 2 months categorically held.
Yes,
Thereafter,
please continue. Yes.
So, Milord, this is first part. Thereafter, the second part, which Lordship shows the extension of
How
the
could
banning.
the work schedule be completed without the blasting permission?
Yes, Milord, blasting permission, Milord, he is carrying on, Milord, overburden work. So, Milord, he is below the overburden and whatever coal can be extracted, open cast. That can also be extracted without
These have
blasting
to be
permission.
explained by you. Prima facie, they have made out a sufficient case. First of all, Mr. Ghosh, you did not give them, you did not consider their reply. You have taken minutes, but while extending the ban, you have not taken into consideration their replies. Those are not reflected even in your extension of ban.
Milord, I'll come to that, Milord. Lordship will
Because
give
they're challenging those primarily.
Milord, primary Milord challenge of 2020, he's making in 2023 by way of the writ petition.
2023, he's challenging the extension.
He's challenging Milord, he's asking Milord, his prayer is nature of a specific performance. You allow me to work, ban is not under challenge. You allow me to work and give me extension. Can the writ court do it, Milord? Nature of specific performance.
Let us see the challenge once.
Yes, kindly look at his
In none of the writ petitions, the banning has been challenged, Mr.
Milord, somewhere, Milord, it's a side issue. The main issue, Milord, what I say, Milord, kindly have a look
The
at
banning
Milord.
has been challenged. That is also a component of the challenge.
Yes, kindly take, Milord. Kindly have a look at it. Lordship will see
Yes,
page
yes,
18 of
yes.
the first writ petition, Milord. This is the, kindly have a look at the first writ petition, what he is challenging.
Right.
(2020) 611 Milord, challenge of 2020. And Milord, when he has filed this writ petition, Milord, kindly have a look at it. February 2023. So, Milord, after 3 years almost, the challenge is made. To Milord, what? Milord, 6th of November 2020. But unfortunately, Milord, this is not annexed to the writ petition. This is not, Milord, though impugn, not challenge. He has not disclosed it. So this is Milord, and Milord, his interim order, what he has prayed, Milord, kindly have a look at the interim order. Injunction, restraining, giving effect and or further effect to the order of 2020. And Milord, this is filed. My Milord is an affirmed copy. I have been given.
That was regarding the ban.
No, this is on ban on 28th of September, 20th of February 2023. So Milord, after Milord, to almost 2 years, Milord, 8 months, this challenge he has thrown. So he has accepted basically what? He's working. Milord, the contract provides that this type of banning are for what? Without termination. That you ban him. If he improves the performance, you give him one more opportunity. You shouldn't terminate.
Yeah,
This
twice
is
he was
called
given
banning of-
opportunity. He was given opportunities twice.
Twice. First banning, second banning. I still, Milord, did not. He continued for the entire tenure of the contract. There was no termination, unlike the other case. What is the banning? The banning is not that he cannot work with any other coal company or any other private government undertaking or a private sector or government, Milord. Banning is what? Till you improve your performance and the banning is removed, you cannot work with ECL. So I am an employer. If someone, according to me,
The banning, if you ban from working with you, the ECL,
yes,
then it may have a repercussion on his
that
goodwill
Lordship
in the
will
other.
clarify. It's only banning is only with me. So it's not an absolute restraint under section 27 of the Contract Act. It's a reasonable restraint. That is all ECL orders. I will not work with you. Milord, if I find Milord someone's work to be unsatisfactory, Milord, can I be compelled, Milord, to give him work again and again and face this consequence of Milord extraction of a natural resource? Delay is one of the ground. Delay, Milord, is a serious ground in this type of matters because a banning order which is not challenged and the order doesn't.
They have taken 3 points basically. One is that your the blasting permission. The other is the land. Part of it was litigated, which you informed later on.
Yes.
And
Milord,
part of it
tender
comprised of
says-
2 villages.
Tender says, before participating in the tender process, there is a clause.
Yes.
He will inspect, he will come, he will raise query. There is a tender committee, is a tender process. If he has any query, he can raise there and get his views. Only then, Milord, one puts forward the bid. visit site, everything is there, Millard, in the tender condition. I am Millard.
Possession you have to give.
I have possession given, no dispute.
Possession about
Millard,
portion.
two lands, and what he is saying, kindly have a letter, Millard. Kindly have his letter, Millard. Kindly have
Actual possession he says 33.61 acre.
No, he kindly look at my letter, Millard. His letter, Millard. Kindly have a look at my letter, which he has shown that please improve performance. Which he does. Kindly have a look at that letter.
Did you give him possession of the entire contracted land? No.
18% I have not given.
So have you, is there any reflection of that in your banning order?
No, banning order says, Millard, he's beyond schedule.
You have to take
Kindly
this
have a
into
look at
consideration,
page-
Mr. Ghosh.
Page 169.
If you did not give him the entire land, you are now saying from the bar it is being said that yes, the overburden work he could have done, but the extraction he could might not have.
Next order, look at the next banning order, which are all annexed. Nothing is annexed.
Let us come to that, where you have considered his representations, because he was heard. There is reflection in the minutes of his hearing.
Yes, he was.
But that is not reflected in your banning order, extension order.
Kindly take the extension of banning
Yes,
order.
yes.
Kindly have a look.
Right. What is the reflection of that?
The show cause notice of the banning order Lordship has seen is 161 of the
Show
first.
cause whatever, just let us come to your order of extension.
Yes, kindly have a look at the extension.
Yes.
Millard, it's page 167 of the first writ petition, Millard.
And Mr. Ghosh, probably you are somewhere confused, because you see the permission you received from the Ministry of Labour at page 177. Please come to that 30th of July 21.
I have the prior permission with me.
No blasting for removal of overburden.
Yes, I
Even
have.
for removal of overburden, some blasting is required.
Millard, I have the prior permission. Previously, Millard, Mohanpur and this plant was together. Now, Millard, there's a permission of 2016. I am holding the permission, Millard. I knew this query will. Millard, whatever he has disclosed in Millard Spits and Pieces, Millard.
Now, Mr. Ghosh, you are trying to distinguish between this overburden and extraction of coal. For the latter, you are saying permission for blasting is
I
required.
have the permission.
But
with
your
me.
permission regarding the permission accorded to you on 30th of July, that covers not only extraction but also overburden.
Correct.
So the blasting permission pertains both to overburden and the extraction. Your distinction is not valid.
Millard, kindly have a look at. This is the permission of Millard DGMS.
Disclose those on record. In the meantime, don't grant any further contract.
Millard, kindly.
His challenge will become infructuous.
Millard, kindly have a look, Millard. Kindly have a look. This is Millard, his banning order.
Maybe.
And Millard, kindly look at the extension. Whether Millard extension, he is entitled to get any extension. He's
At
under
this
a
stage,
ban.
definitely yes.
Millard, kindly look at the extension petition. Kindly have a look at it, Millard. Kindly have a look at the second writ petition. This is Millard, the 3 letters for extension he has asked for. Kindly have a look at the clause.
Yes.
Millard, court can Millard, of course, Millard, there can orders. Kindly have Millard, page Millard, 54 of the first writ petition, Millard. Kindly have a look. Or the second writ petition, anyone.
First or
anything.
second?
Millard, anything, Millard, the papers.
Tell me the page number of which one?
54 of the first one.
54 of the first.
Anyone will.
Yes, 54.
Extension of date of completion on happening of the events delay cause as stated
By
under
first you are meaning WPA 5179?
Yes,
Yes, page 54,
Yes,
right?
kindly take extension. Millard, 6.4 of the contract, Millard, speaks of extension.
Yes.
This is his main challenge now. You give me extension, I'll work under you.
Right.
Abnormally bad weather, etc., etc. Extension on happening of the events delay cause as stated under, the contractor shall intimate immediately in writing to the engineering chief. Abnormally bad weather, serious loss of damage by fire, civil commission, strike, etc., etc. On the work, delay on the contractor statements engaged by the company not forming part of the contract. He falls under E.
Mr. Ghosh, we are not on extension. We are not granting him extension at the interim stage. Definitely, how can we? What interim order has been passed is that whatever the expiry of the contract will abide by the result of the writ petitions. One. Secondly, in the meantime, you cannot grant a new contract to a third party.
So
if you grant a
I
contract to a
cannot
third
Millard, permit him to work.
Who told you to permit him to work? Your interim order is threefold. First is as per my previous order. First is whatever may be the expiry of the contract, will abide by the result of the writ petitions. One. Secondly, you won't grant a new contract to a third party in the meantime. And thirdly, there was some third aspect of the matter also, but that does not
If
got it.
Millard, Millard, may I pose a question?
Yes.
Millard, banning is Millard for participating in future contract.
Banning I have not stayed. Banning remains. Without hearing you, finally, I cannot stay the operation of the banning. That will permit him to work.
Yes.
You are not permitting him to work. I have not removed the ban right now. I cannot. What I have done is that I have said the expiry, because during pendency of the writ petitions, this contract expired. So that will abide by the result of the writ petition.
Millard.
First. Secondly, Mr. Ghosh, you will not be granting a new contract to a third party, thereby making their claim infructuous in the meantime.
Millard, Millard, if a contract expires, here Millard, may I put, if Lordship is not on the ban, Millard, my question becomes, to answer becomes easier. Millard, it's a contract for a specified period.
Yes.
6 months, 6 years. The contract has come to an end by efflux of time. Today, Millard, there is no compulsion of me to permit him to work. He cannot also claim as a right as a matter of extension. Because clause E says any other clause at the sole discretion of the contrary contract beyond the control of the contractor. That's the express clause. So, Millard, if a contract has come to an end by efflux of time, Millard, in respect of those, Millard, in aid of that, can an injunction be passed that he will not, Millard, I will not appoint anyone else to work, Millard? He will have a claim in damages. Because in effect, Millard, if the writ is successful, Lord, you will correct me if I'm wrong. Will be in effect, Millard, are giving a specific performance or asking me, Millard, to enforce, Millard, act as per clause 6.4E. In effect, Millard, Lordship will pass an order of mandamus in nature of clause 6.4E. That he was facing hindrance, this was beyond his control, and in all fairness, he is entitled to extension. Now kindly have look clause 55. In effect, Millard, it will be a specific purpose. Now kindly have a look at clause 6.6. Next page. When the period fixed for completion of the contract is bound to expire, the question of extension of the contract may be considered at the instance of the contractor or of the company or both. The extension will have to be by the parties express agreement, expressed or implied. So extension can be by way of an agreement only. If I had terminated it, Lordship could have stayed the term.
So even for the purpose of damages, Mr. Ghosh, how should we ascertain if you grant the contract to somebody else,
Millard,
and the coal is
Millard,
extracted in the meantime?
Millard, whatever work he has done, there is a provision for measurement under the contract. He will go and measure whatever work he has done. He will have a claim in damages.
That has to be done in the meantime. That takes some time also.
Yes.
So if you grant a new issue, a new contract in the
correct.
meantime, how can it be done?
Correct. And the courts are doing it also in ECL matters also. Appointing someone, Millard, for the purpose of making the survey of the work he has done. That is the fair order, Millard. I will not, Millard, come in the way something is a fair order.
So which authority can be doing that?
Millard,
according to you,
Justice Bhattacharya's order ta da.
Which authority is doing that? No, Mr. Bhattacharya, I'll come to you. I've not passed an order.
আগে ওই অর্ডারটা আছে যেটা করতে গেল শ্রীজীব আর আমি ছিলাম ওটা না.
Give me a neutral authority which will do it.
I'll Millard, take Millard, Mr. Justice Bhattacharya's bench, Millard, was.
Whom? Which authority did she write?
যেটা আমি জিতেছিলাম এটা না.
You wrote it?
Millard, no.
Oh.
যেটা আমি the order which was passed at the suggestion of the parties, the authority.
I thought you wrote the order.
Why should I write an order? I can't write an order. STS টা আছে? এটা না. যেটা
Give me the authority. Whatever you convinced Justice Bhattacharya, that order was passed. You convinced me also.
The other side gave some name, Millard. I came back with the instruction that is the authority. Justice Mr. Srijip Chakraborty was appearing. Same problem. Contract terminated.
Tell me an authority.
Yes, I'll Millard just
so that we can
DGMS.
discuss it with Mr. Bhattacharya.
DGMS, Millard. Director General of Mines, Millard. Is the
CMPDI.
Very good. Yes. Let us hear Mr. Bhattacharya. Yes, Mr. Bhattacharya. No. We are only on the extension.
Extension work order contained a clause for extension different from the NIT.
Mr. Bhattacharya, the difficulty is the work up to which you have done up to now. That can be ascertained. but your contract cannot be extended as Mr. Ghosh is
I
saying.
am not asking you, Lord Shriman.
If I can't do that,
condition is there for extension.
Mr. Bhattacharya, if I can't extend the contract, I cannot restrain them from giving the contract to somebody else after ascertaining what work you have done. So that portion I won't be extending. That is what Mr. Ghosh is saying.
Whether, my lord, your lordship will be considering that the work order contained a clause for extension, and that was supposed to be done.
No, that was within their sole discretion.
The discretion has not been exercised.
No,
kindly come to page
Mr.
92.
Bhattacharya, I cannot, by virtue of this order, cannot extend the contract. Definitely not. In any manner whatsoever.
I am not asking.
What I can do is this will abide by the result. Yes. And your claim license damages there also, Mr. Ghosh is correct.
Kindly one thing, page 12976 read being taken up. Second read. Second read for once.
Which page?
Second read, page 92.
Yes.
Page 76. Page 76.
কি দিচ্ছিস এটা কোথায় দিলাম
My learned friend is saying agreement and other things have to be entered into. There is no such provision.
Extension of time, yes.
Kindly, may I place it? 33.1.
এইটাই কত পাতা
31. 92 page. 92.
Yes.
Yes. Completion of work after scheduled completion period shall need grant extension of several stages. At several stages. To facilitate continuation of the work, provisional extension may be granted by engineer in charge.
No,
as per clause.
this is qualified by 32, Mr. Bhattacharya. What do you say?
Maximum extension in case of extension period should not be more than the original contract. 6 years.
This is Millard.
That is they can do up to 6 years. And that extension.
That 6 years is over now.
Now extension period can be done up to the original.
Discretion. Millard,
That is your discretion. You have not exercised your discretion, sir.
I am saying.
Mr. Ghosh, suggest an authority.
Yes, sir.
If there is an agreed authority, then I'll pass my orders tomorrow on this.
Page
Wait, till
76
when is the interim order subsisting? This order?
Millard till today. Oh, no.
Till today.
Till 15th.
Till 15th.
Page 76 টাকে দেখাও।
Page 76.
Which they have
Come back tomorrow with a suggested name.
Yes,
If you have an agreed name, suggest a name. I'll direct this, but extension of contract, further contract
Let them take a
issues,
decision whether they will be giving it or not by a bar.
they have said they will not be giving.
From bar it has been said.
I have the
They have
instruction.
not, my lord, said anything.
Because
No,
it's beyond schedule.
give it something, my lord, to a authority. The authorities are wanting me to
Madhava একটা order record করুন।
Page 76
Learned
Page
counsel for the petitioner seeks an extension. Learned counsel for the
extension to the authority, man. I am not praying your lordship.
for the ECL authorities content opposes such prayer and submits that that nothing prevented the petitioner from carrying out the overburden work above the land, prior to extraction, since the petitioner had sufficient land already at its disposal. So it is submitted that only 18% out of the contracted land was not handed over to the petitioner by the respondent authorities. So it is further contended that although effectively in one of the writ petitions, the petitioner has challenged the ban, challenged the first ban of 1 year, no copy of the same has been annexed to either of the writ petitions. Learned counsel for the petitioner vociferously places reliance on the annexures to the writ petitions to argue that not only were the blasting permissions given belatedly to the petitioner, that is only in the year 2022, despite the respondent authorities having obtained the same in July 2021, it was informed to the petitioner later that there were court cases pertaining to several portions of the land in question. That apart, it was also revealed subsequently that 2 villages fell within the land purportedly handed over to the petitioner. Next para, at this juncture, learned counsel for the ECL submits that, in any event, the writ court cannot grant an extension of the tenure of a contract between the parties, by placing reliance on certain provisions of the original contract, it is argued that the provisions stipulate that it was the discretion of the ECL authorities to give such extension. Full stop. In the teeth of the expiry of the contract in the meantime, comma, coupled with the fact that the ECL is not interested in extending the same in view of the challenge, comma, there is no scope of extending the period of the contract or restraining the ECL from issuing further contracts in favor of third parties. Full stop. Next para, however, comma, upon the suggestion of court, comma, learned counsel for the ECL submits fairly that there cannot be any objection on the part of the respondents if through an expert, comma, it is assessed as to the exact extent of work already done by the petitioner, comma, since the claim of the petitioner could at best lie in damages. Full stop. Next para. It is seen from the interim order granted earlier that the same was twofold. Full stop. First, comma, it was observed that the expiry of the contract in the meantime shall abide by the result of the writ petitions. Full stop. Secondly, comma, the respondent authorities were restrained from issuing a further contract for the work in question in favor of third parties. Full stop. Next para. Upon the suggestion of learned counsel, upon the submission of learned counsel for the ECL, comma, the matter is adjourned till tomorrow for the parties to ascertain as to an appropriate authority to assess the exact extent of the work done up to the present juncture by the petitioner. Full stop. Next para. For suggesting such names, comma, the matter shall be listed tomorrow under the heading to be mentioned. Full stop. Next para. In the event there is no agreement between the parties as to the suggested name, comma, the court will appoint an expert in terms of the submissions made by the parties. Full stop. Next para. Insofar as the interim order is concerned, comma, since the same is subsisting till June 15, 2023, comma, no order of extension and or vacating the same is passed at the present moment. Full stop. However, comma, it is made clear that in the event no suggested name comes up before the court tomorrow, insofar as the expert to be appointed is concerned, comma, further orders will be passed with regard to the interim order. Full stop.
Maybe day after tomorrow.
Very well. Day after tomorrow means tomorrow na kore shall appear as to be mentioned on June 14, 2023.
As well.
Day after tomorrow. Please come with suggested names. If possible, Mr. Ghosh, you are the ECL authorities, so suggest the names by today evening so that they can.
I'll again check.
Yes, Mr. Bhattacharya, please take instruction. I'll appoint somebody regarding the restraint order so that they cannot issue further contracts. Probably I'll rescind that portion. Probably. I'm just giving you indication because that cannot carry on forever. These are public projects. And Mr. Ghosh, please keep this with you. You will have to put this all in your opposition.
I did a short compilation. Copy to my letter.
Even overburden area also require blasting.
Yes, it does. It does.
It's also that is
no. We are not on the merits of the extent, the other portion. But the difficulty is, Mr. Bhattacharya, we cannot actually, Mr. Ghosh is correct on that. The clause of extension cannot be exercised by court.
No, they can exercise the power. Lordship are mandated.
They are not agreeable.
Exercise. They are not agreeable to court.
Court cannot direct.
Court can direct that.
No, this is not a fundamental right of yours to get a direction for them to use their discretion. How can
consider that? They can consider it.
Come back in 10 minutes and take up the next matter.
কত কিছু আমার এগুলো আমার নাকি
this matter, CPM.
I asked you to mention.
Yes, yes.
Have you
My other
given
side
notice
is
to the other
here.
side?
Yes, my other side is here.
Very well. 42 to the 42 I'll take up first before the next matter. No. Let me take up 42 first, then let us see. Before I rise, I'll consider. 42, yes. 42 call court. Court is not yet over, sir. Please take your seat. Yes. 42, who is appearing?
My lord,
Yes, Mr. Mohan.
my lord, page 27 is the my lord notification which is under challenge. Here, by this notification, my lord, the railway authority has decided to invite the applications from the intending persons to engage at halt collector. My lord, whereas at page 21, there is an agreement with me. Contract. My lord, so for page 21 is concerned, my lord, there is an agreement.
Agreement is valid till when, Mr. Mahathir?
My lord, there is no indication that it will be.
It has not been terminated.
And but there clause 18 is the, my lord, there are certain clause that if it violate that, in that event, this agreement will be. But on the last occasion in 2010 also they attempted, a writ petition was filed, where my lord, the interim order was granted. But subsequently, my lord, that writ petition has been dismissed for default. We have filed a restoration application that is pending. But my lord, kindly consider this issue, that in the absence of or cancelling.
No, they had previously terminated.
No, I have never terminated.
You had challenged what?
I have challenged that without
Previous writ petition, you had challenged what?
Same thing was happened without terminating me. They issued the.
Oh, achha.
Therefore, my lord, that issue was there. Same issue is here also here.
Achha.
My specific submission is that without terminating this agreement, my lord, they cannot ask for the.
Very well. Let me hear them. Yes. You have not terminated their agreement previously. Then clause 18 comes in. How can you issue this fresh tender?
Not only the clause 18, but the entire agreement should be considered. Yes. What happened during that?
Please take the microphone a bit towards you.
During that, the policy of the railway board has been changed. And the new policy has come in the year of 2009.
Your policy cannot change the contract between parties.
Yes, my lord.
Was there any scope under this contract?
Yes, my lord.
Show me that.
My lord, what happens in case of my lord, the railway board, according to the.
Can't hear you. Please use the microphone properly. Yes.
My lord, according to the Railway Board Act, my lord, the each and every guideline or policy framed by the Railway Board, that has been that statutory effect. And my lord, according to the 2019 policy, my lord, every contract, that is the in respect of halt contract, that should be, my lord, the maximum period is 10 years. And my lord, in the present contract, that was, my lord, originally, my lord, executed in the year of 1987. My lord, kindly consider not only that, my lord, in his favorable portion of 2019 policy, they have accepted. My lord, in the 87 agreement, the maximum commission of the halt contract was only 1,000 rupees.
Have you got a copy of the policy?
1,000 rupees maximum. And my lord, now.
Don't you have extra copies of this?
Yes, I'm giving my lord.
Just.
My lord, kindly see the clause 4. Of that
appointment of halt contract. Yes.
Appointment of halt contract. My lord, kindly, I am not entire clause, my lord, kindly come to the clause 4.1.5 and 4.1.6. The halt contract should produce the medical 4.1.6. The application for appointment of contracts shall be invited through the advertisement in the local newspaper. The initial period of contract should be 5 years, and thereafter fresh contract should be awarded after calling a fresh application. After the expiry of the initial contract period of 5 years, the existing halt contractors may be given an extension for 5 years. Maximum contract period should not exceed 5 + 5 is equal to 10 years. The extension should be in spell of 2.5 years at the time, subject to the halt contracts working being satisfactory and the railway dues being paid in time. those hall contractors who also nominated in the infrastructure of the station at their own cost, including provision of water, electricity, etc., may be given another extension of 5 years. Total period of contract may be 10 plus 5 years, that is 15 years. Action should be taken well in advance to call a fresh application before expiry of the contract. The existing hall contractors should also be eligible to apply. Then, my lord, kindly come to the clause 5. That is the commission, payment of commission.
This they have accepted.
They have accepted. And
in the contract, show me something, some reflection that the guidelines will be applicable or whatever. Because this is a personal contract you entered into with him.
my lord, I have not seen.
Huh?
My lord, in the present contract that I have not seen. But my lord, they have accepted.
Nothing is mentioned regarding some law shall be.
My lord, that is clause 18 only.
Regarding tenure, nothing has been stated.
Yes, my lord. But my lord, in every contract, my lord, the time is the essence of contract, my lord. Anyhow, that is, I have not seen at this. My lord, kindly see.
Time is essence principle. How does it apply here? Halt contractor, it's a continuing thing.
Continuing
have to
thing,
finish
but according to the present policy of 2000.
Time is essence is only important when something is to be done. Some work is to be done within.
But my lord, according to that present
continuing
policy of 2019, my lord, the maximum period in case of this type of halt contract, 10 years. And they have accepted that regarding the commission part. My lord, kindly come to the page 21 for a moment, my lord.
That your guideline has not been mentioned to have been accepted in
My
the
lord,
contract.
that
They
was-
might have in the contract, it might be reflected independently also.
Grateful, your lordship. But my lord, kindly consider that was executed in the year of 1987.
Yes.
There was, at that time, that policy was there. What was the prevailing policy at that time? Thereafter,
So that's why there was no scope of reflection there.
no, my lord. Thereafter, 99 policy was there. And that 99 policy was accepted by the Honorable Supreme Court also. And thereafter, my lord, the 2019 policy is there. My lord, kindly, for a moment, my lord, kindly consider page 21, paragraph 3.
3 years.
My lord, the railway administration will pay the local contractor a remuneration for rupees 200 per month as minimum. The other cases, however, the hall contract will get 15% of the sale proceed, but not exceeding 1,000 rupees. My lord, if they are willing to still accepting that, my lord, I think railway will have no problem. If, my lord, that this agreement, my lord, that is to be executed as a whole. Otherwise, my lord, that 2019 policy, they have to be accepted. They have accepted that. Kindly come to the paragraph, clause 5 of this 2019 policy.
That they have taken.
Yes, my lord. Now they are accepting when all, not only this contractor, all over the India, my lord, all contractors, they are accepting this commission, my lord, according to the clause 5. So, my lord, the some favorable portion they are accepting, which is not favorable, they are not accepting. That cannot be, my lord.
Yes, Mr. Mahato, what do you say to
And
this guideline?
whatever may be the interim order, I think if the writ petition was still in exist, my lord, in that case also the policy has been changed. And not only that, after dismissal of the writ petition, same has not yet been restored.
So that is a different. That
Yes,
was a
madam.
previous
Yes,
cause of action. Yes, Mr. Mahato, how do you deal with the guidelines?
These guidelines.
So I'll fix it that your remuneration will remain the same and they'll be restrained from
These
giving it.
guidelines, the remuneration, all are relating to my lord fresh appointment.
All are related to?
Fresh appointment. Fresh appointment.
So this is not applicable to you?
No.
This commission?
No.
So you are entitled to remuneration at this rate
I
only?
have never stated that I am getting remuneration as per this circular. They have not produced any document that as per this circular, they are giving me the remuneration.
You are saying that this circular.
Well, that may be enhanced. Subsequently, it is independent from this circular.
And my lord, this circulars is not under challenge. Kindly consider the prayer also.
No, that is not under challenge.
Therefore, this circular is applicable only to the fresh appointment.
Mr. Mahato, you have to answer something else also. Please see clause 1 of your agreement, page 21.
Yes. The railway administration does hereby appoint such and such and such
Yes.
as its local contractor for the purpose of shifting
Passengers entering such and such aforesaid in accordance with instructions embodied in Annexure A to this agreement
Yes.
or such other instructions as may be issued by the railway administration from time to time, which should be deemed to have been included and incorporated in this agreement as a part.
Where are those,
Why
those
shouldn't we
instructions?
take
It is
this?
not instruction to me. Well, this circular is not instruction issued to me. It is independent from my contract.
My lord, when the railway board issued the circular, that means that is applicable in respect of all cases.
If it is written, my lord, in the circular that earlier agreements which has been done, executed between the parties, that will go. In that event, I should not have anything. But here, my lord, that is not mentioned. Therefore, it is contract has not been covered by this new circular.
What about arbitration clause? There is an arbitration
If
clause.
any dispute arises relating to contract, in that event, it may be referred to. But there is no dispute. They have not issued any termination letter.
No.
They are
If any dispute, difference or question shall arise between railway and you as to
Relating to
respective rights, duties and obligations of the parties, whatever, as to construction or interpretation of any of the terms and condition, or as to its application. Now here you are relying on a clause, that is the clause of clause 18 in fact. You are relying on an
they
obligation
have
thereof.
not terminated me as per clause 18.
That is an obligation. Why shouldn't you go to the arbitration?
No, my lord,
Why are you
arbitration-
approaching the writ court?
If they issued any notice terminating my agreement, in that event, I shall go.
No, termination is not the only thing you have to go. Whatever
Any dispute. But regarding this agreement, there is.
you are saying, this is independent of the dispute.
Yes.
My lord, railway has not yet been terminated as because, my lord, unless and until new person is appointed. Otherwise, my lord, the passenger will suffer, my lord. They will not be able to purchase the railway tickets, my lord.
No, they have made out a privacy case. Ashwin, Ashwin. Sorry, Ashwin. Learned counsel for the petitioner has raised a prima facie question for hearing of the writ petition on merits. First up, it is argued that as per clause 18 of the existing contract between the parties, by virtue of which the petitioner has been appointed as a local contractor for the purpose of selling railway tickets to passengers in training at TP number 234/14, the agreement is terminable upon 1 month apostrophe notice in writing on either side, subject to the proviso that should there be any breach of any of the conditions by the local contractor, or if the local contractor shall become insolvent Sudepur halt is concerned.
Yes, that is.
I have never said it has been terminated. How can it be terminated?
This is, my lord, I think, my lord, it is recorded.
Call on the next one. No.
I'm getting.
Yes.
Item number 4.
My lord, I appear for the petitioners. I'm being led by Mr. Subir Sanyal. He's on legs in court number 1 for the Panchayat election matter.
The last occasion also this happened.
No, my lord.
No, my
Last
lord,
occasion he
it was my application. Lordship wanted me to address on behalf of ECL. Now, my lord, I believe.
So then I'll take it up. I'll take it up tomorrow then.
My lord, tomorrow he's in difficulties. Either Thursday.
My lord,
Friday,
only
my
thing
lord.
I told them
Yes, my
that my lord, the from 14th to 16th, 14, 15, 16, I am in difficulty, my lord. I won't be.
My lord,
So I'll keep it on 19th.
Wait, that is good.
You are for the?
Petitioners, my lord.
I am for my.
You are for the writ petitioner.
Yes,
I'll
and
specify that. You are for the applicant is here.
I am for the interim application.
On the prayer of learned counsel for the writ petitioner, comma, the matter is adjourned till June 19, 2023.
Grateful, my lord.
Item number 5.
Well, I'm for the W.
Well, I'm for the petitioner.
পরে ফাইলটা রেডি রাখুন হ্যাঁ
Lord, the
মাইকে
allegation,
অ্যাড্রেস করবেন তাহলে ওরা শুনতে পাবে আপনি মাইকটা আপনার দিকে নিন
Lord, the allegation is that I have committed theft of electricity. Now, my lord, there is also a petition by me that I have committed the theft of electricity, so but the assessment is not right. So final assessment must be made so that I can be exonerated.
Final assessment has not been made?
No, at that time not been made. Now, after the final assessment has been made, I have filed my supplementary affidavit.
Final assessment, you have to challenge that before the forum, appellate forum, under 127.
Well, I know, but I am on a different footing. For the time being, my lord, will kindly, my lord, see, even if supposing, my lord, I have committed the offense, but because that has my unequivocal writing with a condition, if your lordship kindly come to page 46 first, because I want to be short. অধীনের বিনীত আবেদন, may I read the Bengali, my lord?
Oh, yes. Page 46,
Yes. অধীনের বিনীত আবেদন এই যে আমার ফেব্রুয়ারিতে আমি ভুল করে অবৈধভাবে বিদ্যুৎ সংযোগ নিয়েছিলাম। অফিস থেকে রেড করার ফলে আমার নামে কেসটি একটি কপ বিল ধরানো হয়। এই বিলটি আমার পক্ষে দেওয়া খুবই কষ্টকর হয়ে দাঁড়াচ্ছে। মহাশয়, আমার এই ভুল কখনো হবে না, তার জন্য আপনার কাছে আমি করজোড়ে বিনীতভাবে ক্ষমা চাইছি। আমাকে এই একটিবারের জন্য ক্ষমা করে এই অতিরিক্ত বিলটি পুনর্বিবেচনা করে সংশোধন করে দিয়ে ফাইনাল বিল করে দেন তাহলে। So my lord, therefore I know my limitation in the writ petition. Possibly my lord cannot go against this letter, but my lord, there is, I want to say, my submission is very short, my lord. I took the electricity just in 2022 or 21 end. Well, 2 months or 3 months I could run, 6 months I could run, and thereafter, my lord, there is a meter burnt problem. Meter burnt problem. A new meter came in. My lord, will kindly look at page number 37 and 38. The meter burnt problem started in 13 June 2022, and then on 13 June 2022, I paid the meter. Admittedly, my lord, that meter was installed but not activated. My lord, will kindly get it at page 47. Only 47 I will show that why the meter was not activated, but that is for a different purpose. In page 47, there is a bill internet copy. 27 lakhs, etc. has been charged. Now, my lord, will kindly see the meter reading, meter numbers. TS Z02003N 0.00 previous writing, present writing 0.00. So, my lord, this meter was not activated. This is an admitted situation. Now, what happened?
My lord, will kindly look at page number 49. No, I'm sorry, my lord, page 39. This was not possible because search and seizure condition was not obeyed according to section 100 of the CRPC. Your lordship knows, my lord, so far the Electricity Act is concerned, there is a subsection in section 135, lastly, that search and seizure condition has to be obeyed. My lord, will kindly look at, my lord, I'm not going to too much press on this, but last lines, as the theft of electricity was detected during the inspection, at first the service cable disconnected and thereafter some portion of hooking cable, etc.
No, this is which page?
30? 39.
39, which portion?
Second paragraph.
Second paragraph.
So far, I have taken the electricity from, my lord, the dishonestly taken direct hooking from the LT site of the distribution transformer. But I am not reading that. I am reading only the second paragraph. As the theft of electricity was detected during the inspection, at first the service cable was disconnected and thereafter some portion of the hooking cable, etc. has been taken away, tender a memo of seizure list in presence of witnesses. Which witnesses, my lord, I do not know, because and obtain their signature. How? On the seizure list accordingly. Above seized articles were duly packed, labeled, and then the signature of the witnesses were also obtained on it. I also prepared an inspection report at site duly signed by the witnesses. The accused, representative of the accused, etc., refused to sign, etc. on the seizure list. I allegedly refused to sign. Now, my lord, I am asking to myself, am I not entitled to a copy of the seizure list? My lord, will kindly look at in this connection section 130.
How can that be German in the present context? That you can take in the 135 proceeding. The criminal proceeding must also be pending.
It was immediately lodged. And well, I have decided to get the matter compounded under section 152.
That is the best thing to do.
Yes, my lord, I have. Because of the fact, my lord, I will be showing to your lordship.
If you do that, then the entire thing is solved.
Yes, and that is the reason why I have come before your lordship. Kindly look at, my lord, section 152. That compounding of the offense is there.
Yes, it is.
And, my lord, 153. The civil liability under subsection 5 and section 6 will be decided by the magistrate. Sessions, that court. I am ready and willing for that.
Do that. That is happening.
The that is not happening today.
Criminal proceeding is not going on.
Yes, that is going on. I can go there. The only thing I am challenging here, the provisional assessment and the final assessment, because of the fact, my lord, with due respect, my lord, with due respect, because of section 126 is possibly not applicable in case of theft of electricity. Well, this I am guided by a 3-bench judgment. My lord, I know your lordship.
You must be knowing, no, not me. There are several Supreme Court judgments. You must be knowing that also. That which say
that not overruled the 3-bench judgment. My lord, can you look at
of our court?
No, Supreme Court judgment.
Achha.
That is the reason why I am just.
Achha, very well. Please cite that.
I will. Not only that, my lord. Apart from Sitaram Rice Mill, my lord, can you look at only paragraph, my lord, I will be showing to your lordship. My lord, this is my interest. Your lordship may pass whatever order your lordship think best.
No, why not? Yes, please.
Take, paragraph 26. My lord, I will be referring to this. In contradistinction to these provisions, section 126 of 2003 Act would be applicable to the cases where there is no theft of electricity. My lord, there are many other paragraphs. I'm not going to. What I'm only saying is this, my lord. So far, the unauthorized electricity consumption is concerned in section 126. That may not be, my lord, my impression. Section 126, if your lordship once look at 126.
Yes.
Unauthorized, my lord, look at the assessment under, I'm sorry, my lord, the subsection 6B. Unauthorized use of electricity means the usage of electricity by any artificial means, etc. 3. Through a tampered meter. Am I right, my lord? If your lordship now kindly come to, my lord, section 135.
Yes.
Whoever dishonestly tampers meter. My lord, I want to mean this way that dishonestly tempers meter and tempers meter are different, and that difference has been set out in this Sitaram case. And my lord will kindly look at, for that reason, my lord will kindly look at, my lord, paragraph 29, if I am not wrong, my lord, paragraph 29 of the judgment.
Yes, 29.
Thus, it would be clear that expression unauthorized use of electricity under section 126 of 2003 Act deals with the cases of unauthorized use even in the absence of intention. These cases would certainly be different from the cases where there is dishonest abstraction. Though, therefore, my lord, what I intended.
Tampering is common to both.
Tampering may be common, but
Your
there may be
dishonesty, the dishonesty part is-
dishonestly or non-dishonestly, because of the fact, my lord, civil tampering is possible. Supreme Court has guided that. Not the criminal with criminal intention. What I'm saying, my lord, is that if section 126 is not applicable, then the applicability will be, my lord, according to my respectful submission, will be, my lord,
Mr.
The West Bengal Electricity Regulatory Commission. Well, we'll kindly look at that. After that, your lordship passes whatever order your lordship think best.
You know the fate very well.
I know very well everything, my lord, but I have to get a.
No, this is an academic point. Why not argue it? Yes. No, absolutely. Please. Yes.
But we'll kindly look at
which regulation, which clause?
5.1.
5.1, yes.
Page 18.
Got it.
Provisional assessment under subsection 1 of section 126 of the Act shall be made as per following methods. Well, I will be coming under A. Where the unauthorized use is found due to abstraction or consumption of use of electricity, or attempt to consume, or attempt to abstract, or attempt to use of electricity by any artificial means or through a tempered meter, or any other method which is covered by clauses A, B, C, and D of subsection 1 of section 135. The applicable amount P under subsection 1 of section 126 of this shall be as follows. Now, my lord, will kindly, my lord, once allow me to bear in this way one judgment, which I will be showing to your lordship because of the things that it is very much necessary. Because if section 153 has been explained, my lord, kindly, this is the judgment.
154.3.
No, my lord, I'm sorry, my lord. May I, my lord, one day. The judgment, my lord, because of this, my lord, why the civil liability has to be decided by the magistrate. My lord, will kindly look at.
This is a special
section
code.
154, subsection 5 and 6 of that particular act.
Yes.
Civil liability will be decided by the magistrate. Now,
By the special code.
Now, my lord, will kindly look at the judgment, which I am now going to show to your lordship. Yes, my lord. I'm sorry, my lord, I have given the mistakenly marking. Paragraph 63 onwards.
Yes.
তোমাকে দিতে কি অসুবিধা?
This 2013 SCC online Madras.
Yes, my lord.
3520.
Yes, my lord. Paragraph 63 onwards, what says? Electricity Act 2003. May I read, my lord? This is very important, my lord. Confers powers on Tamil Nadu Electricity Regulatory Commission to frame regulations. Accordingly, Regulation 23AA has been framed by Tamil Nadu Electricity Regulatory Commission, Chennai, devising a procedure for passing a provisional assessment order, and after affording an opportunity of hearing to the consumer to pass a final assessment order, even in the case of theft. In the case of compounding of offense punishable under section 135(1)(a) to E of Electricity Act, the special court, in exercise of the power under section 153, is also empowered to determine the civil liability on the consumer. The terms on which the special court determines the civil liability on the consumer is almost the same as contained in Regulation 23AA of the code as per subclause, etc. Well, I'm not interested in that. 64. Insofar as the determination of civil liability by the special court is concerned, or for the matter imposition of appropriate fine or imprisonment, as the case may be, depending upon the repetition of the offense, the person aggrieved over the determination of the civil liability or fine or imposition of both, as the case may be, is given a right to challenge the same before the assessing officer of this or the special court, as the case may be commit an error in the matter of assessment or determination of civil liability. But we kindly look at, Lord, then evidence adduced on behalf of the consumer would not be considered in would not have been considered in proper perspective or overlooked. resulting in miscarriage of justice. In such an event, when the aggrieved consumer is at liberty to challenge the civil liability determined by the civil court before the High Court, then the consumer who has avoided prosecution by compounding the offense, paid the compounding fee, should be also permitted to test the correctness of the manner of computation of civil liability when such civil liability is fastened on the consumer by the assessing officer. As such, there is no provision in the Electricity Act 2003 or Supply Code framed by the regulatory authority to question the manner of computation of civil liability or otherwise the final assessment order. As observed earlier, assessment of the civil liability or loss caused to the licensee is made after considering the objections of the consumer and evidences, if any, adduced. The material evidence adduced by the department is also relevant for the time of the assessment. Writ jurisdiction does not ordinarily deal with the question of fact, and more particularly when a finding is recorded by the original authority. Judicial review is restricted to the decision-making process or the challenges to perversity, violation of the principles of natural justice, lack of jurisdiction. If there is any error or illegality committed by the authority in the method while arriving at the assessment or for any of the reasons stated supra, there should be a forum constituted under the Act or the Supply Code to challenge the aspect of his act of compounding. Apparently, there is no such forum constituted under the Act or in the regulations framed under Regulation 23AA of the Tamil Nadu Regulation Supply Code 2004. There is a casus omissus in the statute as well as in the Supply Code. Therefore, the court is inclined to suggest to the Court of Tamil Nadu, etc., or the Tamil Nadu Regulation Commission to make a provision, constitute, etc. In the light of the above discussion, as compounded under the protest is not acceptable, the respondents are at liberty to proceed, etc. My lord, what I am saying is this, my lord, in any event of the matter, they have to proceed possibly under the, my lord, the West Bengal Electricity Regulatory Commission. No matter whatever be the way, my lord will kindly, before passing the order, kindly look at once the, my lord, the supplementary affidavit. This supplementary affidavit. My lord, I have taken the consent of my client, my lord. Your lordship knows, my lord, if the special court, whenever it will be deciding the matter, if the special court finds that I have deposited extra, then the special court will be entitled to pass an order to make it a refund. Because I am going to compound the offense, I will be requesting the special court to exercise the jurisdiction under that particular provision. Well, we'll kindly look at once, my lord, the final assessment order at page 16. This is in terms and synchronizing the provisional assessment order at page 16, 17, and 18. My lord, I will kindly come to page 18. How that assessment has been made. That relief, my lord, I want, and I have asked my client, my lord, to deposit immediately a sum of rupees 10 lakhs. My lord, kindly look at, my lord. The date of commencement, etc., has been given. Page 18, my lord.
18, yes.
Page 18. Multiplication has been made. Calculated unit, L into PF into D means date, H means hours, into LF. They are saying, my lord, 1,29,000. That calculation is absurd. I have given in the supplementary affidavit. My calculation, I have taken the calculation, page 20. Kindly look at it. Even on simple basis of calculation, well, I have checked up, I may be wrong. My learned friend will clarify me, correct me. The error of calculation unit is, it not be 129576, but it should be, my lord, 68850. If that is so, it multiplies with 2,1377000. That should have been the calculation, my lord. My client is here, my lord. If your lordship, my lord, direct him, my lord, I can immediately deposit rupees 10 lakhs. I am praying, my lord, keeping in mind of all this. Your lordship passes an order, allow me to go to the magistrate and compounding the offense, and then the decision is coming, and if excess is to be paid, excess I will pay. If the refund is to be directed, refund is to be directed. These are my lord, I wanted to make this submission, my lord, in that.
What about the calculation, Dr. Shah?
Calculation is correct. If there is any wrong error in the calculation, he could have preferred an appeal before the statutory authority.
You have to deposit 50% of that then.
But that is to be done.
When I
but that is the law. But what happened, your lordship kindly appreciate the situation. But this is the basic law. My learned senior friend just said that it is not the unauthorized use of electricity. Your lordship knows that there is a plethora of decisions on this court, and under section 126B, unauthorized use of electricity means by an artificial means. There is a, first of all, may I submit, there is a direct hooking. It was found there is a direct hooking by.
So, Dr. Shara, just take instruction regarding the other points. All of us know the fate, but regarding the calculation, what is
calculation? Your lordship will
if there is a bona fide in their calculation, I mean, I'll direct them to deposit this amount and start the fishery.
Yes,
so far the consideration is concerned, they could have preferred on statute. These are different avenues.
Already appeal 50%, depositing 50%. If the calculation on your part is wrong, it's
calculation is not wrong.
Mathematical error they
But
say.
according to them, it is wrong.
Just check up. Why not check up?
According to them, it is wrong. If your lordship kindly see the calculation as
See
per
the units. See the units.
Yes. Then let me take the instruction on that.
And,
let me take the instruction on the calculations.
Only on the calculation, come back tomorrow.
Lordship. But tomorrow there will be
Day after tomorrow.
It is in
without electricity, that's why.
They are without electricity since 2022, and they have filed it. Your lordship knows that on July 2022, final order of assessment was passed.
And
in order to bypass that, and they have taken this writ petition in December, so that the 30 days is over. And now on this court, they are coming up for this court. Your lordship, this is not at all maintainable. This is my humble.
They could have filed the
but they could have
objection.
preferred an appeal under section 120.
Can you look at number 16?
No, the difficulty when they give you the provisional assessment.
Final assessment passed on
they give you a
27.
hearing on the provisional assessment?
Yes,
Hearing
opportunity was given, never appeared.
I attended, but he said only sign certain papers. I have stated in paragraph 20.
So the final order of assessment, Dr. Shara, please just final order of assessment was passed. The quantum is same as the provisional order.
Yes,
same.
Yes.
If that is so, then you had an opportunity.
Right.
I did not have.
Kindly
look at my petition.
Kindly see the final order of assessment.
Just a minute, madam.
You were heard.
You are hard.
I have not been. I have not been given the chance. They said you come to us.
You did not go.
Yes, I went. What happened? My lord will kindly see that.
What happened?
My lord, they gave the notice.
Kindly see the order of final assessment.
Page 48. My lord will kindly see page 48 first.
48 of the writ petition, yes.
48 of the writ petition.
Wait.
They said that they will hear me on 14th.
Hmm.
Now, my lord, will kindly look at ground number 22 at page 25. What happened on 14th? For that, on 14 July 2022 at 2 p.m. at the chamber of AEE and station manager Nandigram at Barthala regarding the alleged final bill assessment was attended by the petitioner, but nothing was heard by the petitioner that the provisional assessment order has to be applied and an assessment for which 27,21,153, which has to be paid. Your petitioner has to come out from the matter without any result. On 22nd of August 2022, your petitioner was constrained to write a letter to the authority concerned referring to the provisional assessment. My lord, will kindly look at my order, my letter, 22nd August.
No, that will not help.
I continue to challenge the
Never stated that.
That will not help this.
No, I have.
But
they are not denied.
It was wrong.
Kindly look at my lord, will kindly look at my
ample
letter.
opportunity.
Dr. Sharath, both of you cannot argue together. How can I hear both of you? Let him complete.
Yes. Kindly look at my 22nd August 2022.
You have not made out a sufficient case. You got an opportunity of hearing.
I got an opportunity, but that opportunity was not given. I have mentioned in my writ petition that final assessment order has not been passed. And my lord, whenever has been passed, my lord, I have challenged the provisional assessment order.
Did not appear. That is the finding of the.
That they says, but I appeared because I said in my writ petition why I would be coming then, my lord, with the case that I am ready and willing to deposit a sum of rupees 10 lakhs, and I want to compound, get it compounded.
Get it compounded.
Yes, Lord, I will. Your lord
get
should
it compounded
that way. But
why should I direct? You could have done it in the meantime also.
Lord,
instead of preferring this challenge, you could have done that.
Something has been mistakenly
but
done.
this appeal is without an appeal, you cannot take out a writ petition against this.
My lord, I will be saying.
Got an opportunity.
My lord, I will be saying in this way. My lord will decide kindly whether section 126 has an applicability. In the case of admitted theft, in this case,
I'll decide that right now.
Yes, my lord. And my lord will kindly give certain opportunities, whatever real
What opportunity?
Because my lord, the final assessment order has been given after the writ petition. At the time of the writ petition, I did not get the chance.
No.
Yes,
Kindly see
yes.
when it has been passed. It has been passed on.
When you have supplied to me.
This is not
No,
correct.
it was passed previous to your writ
Yes,
petition.
previous to the writ petition. What my learned friend is saying is not correct.
Assessment order has
এখানে- এখানে চলে আসুন। The petitioner has challenged a final order of assessment.
after with the my lord.
First up, it is argued that a copy of the final order of assessment passed under section 126 of the Electricity Act 2003 was handed what was obtained by the petitioner only after filing of the writ petition, comma, whereas the initial challenge had been preferred against a provisional order of assessment. First up, next para, learned counsel appearing for the petitioner places reliance on the corresponding provisions of the Act in sections 126 and section 135 and argues that the definition of unauthorized use of electricity in explanation small b within bracket of subsection 6 of section 126 insofar as the same pertains to usage of electricity through a tampered meter is mutually exclusive with the definition of theft, comma, which involves a dishonest intention on the part of the perpetrator in committing such tampering. Full stop, next para, in the present case, comma, it is argued, comma, a proceeding under section 135 of the 2003 Act has been taken out and the petitioner is agreeable to have this offense compounded therein before the special court. Full stop, it is, comma, however, comma, argued that the provision of section 126 of the 2003 Act is not maintainable in the same breath, comma, if the licensee alleges that the tampering with a dishonest intention. For sub next para, learned counsel places reliance on the judgment rendered by the Supreme Court in Sitaram Rice Mills case reported at 2012 2 SCC 108. First up, placing particular reliance on paragraph 29 thereof, comma, learned counsel seeks to stress upon the observations made by the Supreme Court therein to the effect that unauthorized use of electricity under section 126 deals with cases of unauthorized use, comma, even in the absence of intention, comma, which would be different from cases where there is dishonest abstraction of electricity by any of the methods enlisted under section 135 of the 2003 Act. First up, next para, it was further observed by the Supreme Court that where a consumer, comma, by any of the means and methods as specified under section 135 small a to small e, comma, has abstracted energy with dishonest intention and without authorization, comma, the case would fall under section 135 of the Act. First up, next para. It is further contended that a learned single judge in the judgment of FLEM Industries Limited reported at 2013 SCC Online Madras 3520, comma, distinguished between the applicability of section 126 and 135 of the Electricity Act, comma, 2003 and considered the scope of interference in the writ jurisdiction in case of civil assessments made under the provisions of section 135, comma, read with section 154 and 153 of the 2003 Act. First up, next para, it is argued that clause 5.1 of the regulation number 55 of the WBERC dated August 7, 2013 clearly stipulates the provisional assessment under section 126(1) to be made as per the method given therein. Full stop. By highlighting the said methodology, comma, it is sought to be argued that there is a patent distinction between tampering within the contemplation of section 135 and 126 of the 2003 Act. Full stop. Next para. Learned Counsel further contends that in the supplementary affidavit filed by the petitioner, comma, the petitioner has pointed out the discrepancies in calculation committed by the respondent authorities while making the provisional and final orders of assessment. Full stop. It is contended that the petitioner was not given a proper hearing on the provisional assessment for the purpose of permitting the petitioner to point out the calculation errors. Full stop. Next para. Learned Counsel appearing for the distribution licensee controverts the submissions made by the petitioner and argues that it is a well settled position that sections 126 and 135 operate parallelly insofar as proceedings for provisional assessment and final assessment, as well as theft of electricity are concerned. Full stop. However, comma, the act of tampering is a common adjunct of both the two provisions, and comma, as such, comma, it may very well be that parallel proceedings under the two provisions mentioned above are maintained by the licensee on the score of the same offense. Full stop. Next para. A perusal of the respective provisions of sections 126 and 135 clearly indicate that that usage of electricity through a tampered meter is a common factor between both. Full stop. The same may be termed merely as unauthorized use of electricity in the event there is no dishonest intention alleged. Full stop. Next para. However, comma, the same act, comma, upon attributing the color of dishonest intention, comma, acquires the nature of an offense of theft under section 135 of the 2003 Act. Full stop. Next para. In the present case, comma, the provisional and final orders of assessment for the petitioner were made by the assessing officer on the premise of the allegation of tampering, comma, which has been virtually admitted by the petitioner before the authorities. Full stop. Next para. On the other hand, comma, the proceeding under section 135 has been undertaken for the same act of tampering, comma, where it is the incumbent duty of the authorities to establish beyond reasonable doubt, comma, as befitting criminal trials, comma, to the effect that there was dishonest intention on the part of the petitioner in committing such act of tampering. Full stop. Next para. The yardsticks and standards of proof in criminal and civil assessments, comma, respectively under section 135 and section 126 of the 2003 Act, comma, it is well settled, comma, are on different footings and are maintainable parallelly. In Sitaram Rice Mills case, comma, which has been cited by learned counsel for the petitioner, comma, the Supreme Court, while distinguishing the features of sections 126 and 135, comma, cited certain examples in paragraph 29 thereof. Full stop. Next para. What was highlighted in the context of the entire judgment was that the two proceedings differed in the context, in the light of the allegation of dishonesty on the part of the perpetrator while tampering the meter in question. Full stop. Next para. However, comma, on an ultimate analysis, comma, the said observations observation did not culminate to hold that two proceedings under the provisions of sections 126 and 135 are not maintainable on a parallel footing. Full stop. Next para. That apart, the learned single judge of Madras High Court, while passing the cited judgment, took into consideration a perceived lacuna in the Tamil Nadu regulations framed by the state electricity regulatory authority of the said state, with regard to there being no forum of challenge against the civil assessment of liability under section 153 and 154 of the 2003 Act. Full stop. However, the civil assessment made under section 154 of the 2003 Act is attracted only when there is an allegation of theft under section 135. Full stop. In fact, the opening sentence of section 154 specifies that only in cases where there are allegations of offences under sections 135 to 140 of the 2003 Act, the said section, that is section 154, comes into operation. Full stop. Next para. The said provision, thus, operates on the exclusive footing of an offence under section 135 to 140, which is in contradistinction with the civil liability assessed under section 126 of the 2003 Act. Full stop. Next para. That apart, since the petitioner has not yet preferred a challenge under section 127 of the 2003 Act before the appellate authority designated under the statute for taking up challenges against final orders of assessment, the present challenge in the garb of a writ petition, on whatever ground, ought not to be entertained to bypass the statutory provision of prior deposit of 50% of the assessed dues before the appellate authority by entertaining the present writ petition. Full stop. Next para. In any event, it will be open to the authorities, it will be open to the petitioner to approach the special court for having the offence compounded before the said court and get the reliefs as stipulated in section 154 and its subsections. Full stop. Nothing in this order shall prevent the petitioner from taking recourse to such remedy and or preferring an independent appeal, if the petitioner so chooses, under section 127 of the 2003 Act against the final order of assessment. Full stop. Be that as it may, in view of the above discussions, there is no scope of interference in the present writ petition. Full stop. It was open for the writ petitioner to challenge the alleged discrepancy of calculation before the assessing officer at the relevant juncture. Full stop. However, such point can only be agitated now before the appellate authority, if such a challenge is preferred in terms of the liberty given above. Full stop. No orders to cause certain certificate.
Well, can you mention the liberty time, at least 15 days or so?
No,
Well, that is already, it is already subject to limitation, Lordship.
Well, that limitation,
subject to
lordship,
limitation.
Cannot extend the limitation. here.
Subject to
But that is
limitation.
the reason why, 10 days or whatever days.
No.
Very well. Liberty.
Oh,
I'm getting.
my lord,
Mr. Sahani, you were saying something. Mr. Sahani was there. He's not there. Yes.
My lord, before your lordship rises,
Yes.
my lord, item number 68 is a tender matter. Tomorrow, the date of final submission of bidding. Your lordship on 8th of June granted leave to file this matter to appear on 9th of June. It is appearing since then, my lord. If your lordship kindly give some priority to the matter, otherwise.
68.
68, my lord.
Who's for the other side?
Mr. Lane's senior advocate, Mr. Shomrat Sen is appearing. I'll be informing him.
Give notice. I'll take it up at 10:30 tomorrow. 2 p.m. tomorrow.
2 p.m. tomorrow. My lord, I'm serving.
Acha, item 68 take to
68, my lord.
68 kal 2 p.m.
2 p.m. I'm serving.
Lordship.
I'm Shunmu.
relates to the disconnection. Disconnection will be effective on 15th. But I've given the list, it is appearing in the list.
Disconnection is effective on 17th, my lord. The notice is,
No,
the
Mr. Chakraborty.
notice is,
No, Mr. Chakraborty.
Kindly,
No, no, I've refused others also on same.
disconnection when the matters.
Several matters, disconnection matters are pending. Apni ki bol- yes. No, Mr. Chakraborty.
Lordship, my item is listed in today, item number 123, requesting you to listen it my matter tomorrow because petitioner is unable to take admission in college due to cancellation of a scheduled caste certificate.
When is the admission closing?
Sir, admission has already closed, but as per stay order, institute has reserved a seat.
Till when is the seat reserved?
16th of June, this week, by Friday.
This week, up to this.
Yes, this will be the second matter at 2 p.m. after the other matter.
Okay, 2 p.m. Sir,
2 p.m. second matter.
Okay,
I
sir.
take up appellate side matters. 2 p.m. This will be the second matter after the other matter.
may I have to inform to respondent?
Please do.
Sir, do I do it via email?
Do that by email. If you can, also send a letter or whatever, or serve personally.
Sir,
Email definitely, and personal service. Are they represented through counsel?
No, sir, we are appearing in person.
Not you, the others, the respondent.
Yes, sir, they are appearing.
Then try to serve on their clients, on their advocates.
Okay, okay, sir.
Do it during the course of the day, both email as well as personal service on the advocates.
Okay, sir. Okay, thank you.
Item number. If the matter-
Naraki.
if the matters.
Item number 123. Today, item number
123.
Yes, sir.
If the matters are not taken up, it is appearing in the list. My difficulty, if the matters kindly, because my lord 15th is possibly, my lord is having a.
the
division
notice-
bench. My lord doesn't.
the notice is effective from 16th.
I have a division bench tomorrow.
No, my lord, 15th, my lord,
No, you can
the
fix-
matter will be taken up. That's.
Then
the
can you fix
difficulty.
on
My lord,
14th in that
If it is not taken up tomorrow, my lord.
Tomorrow is 13th. We have 14th also.
That is what I'm praying. If it is not taken up, liberty to mention tomorrow so that it will maybe taken up on 14th. So that is what I was praying. Because
Mr. Chakraborty, I cannot make an exception for a particular.
disconnection.
In every matter, nobody is leaving an inch. So everybody is arguing to the hilt, even in extension matters. Mr. Chakraborty, I have to give hearing. If I don't give hearing, you will say I'm not giving hearing. If I give hearing, your matters are not taken up. This is residuary bench.
My lord,
I can fix the hearings to 10 minutes each. I mean, each of the council 5 minutes. That would suffice in a residuary matter. But then you wouldn't be satisfied. The senior council wouldn't be satisfied. The junior council wouldn't be satisfied.
my lord, if it
No, it's not a question of apology. You have a right of hearing. I cannot curtail the right of hearing for the people who.
If it is once it is disconnected.
Mr. Chakraborty, poorer people than you are being refused the same permission. This urgency, why this urgency? Why are you special? Others are being refused on the same ground.
Second, well, this matters.
No.
I think 5. Well, 6. Well,
I cannot convince you, Mr. Chakraborty, but that is my decision.
The only thing I was praying, well,
No.
it will be on 14th. If it is not taken up.
No special provision for you.
What else, my lord, knows when it will become infructuous. That is my difficulty. If
Many of these matters have already become infructuous because of these long hearings. Already become infructuous. Today also many matters have become infructuous.
a lot of workers will face. But I can, my lord, I can understand the pressure.
Lot of
The
workers, lot of cultivators. Let me take up the matters. Be short in your arguments. Let me see if I can dispose of all the matters. But be short in your arguments. You have to be short in your arguments. You have to leave. Once you get the opportunity of argument, none of you are leaving that opportunity. You are arguing to the hilt, each of you. So I'll have to give you hearing. No, your problem is your problem, Mr. Chakraborty. I cannot be confused with that. There are others with similar problems, same problems, other cultivators who are poorer than you, cannot afford counsel even. No. No special privilege for a company.
Come back tomorrow, my lord.
No, you cannot come back.
Taken up tomorrow.
No.
That is what I was.
Let me take up matters, I'll take up matters. If you say I can sit up to 5 also every day for taking up these residuary matters, I have no qualms on that. But if you agree, if the bar agrees, I'll do that. But you cannot go on arguing at your whims and fancies. Every matter is being argued, each and every matter. Advocates have some duty, Mr. Chakraborty. In a civilized court, in a civilized society, each of one has some duty. You have to be short in your arguments. You have to be precise. Argue on the points, I'll adjudicate. But you never leave unless an order is passed in your favor. None of you, from the morning I've seen, senior to junior, everybody, nobody is giving an inch. So if you do that, you'll have to suffer. No special privilege for a particular litigant, Mr. Chakraborty. Everybody has to suffer. If the court cannot take up humanly whatever possible, I'm doing no.
I'm not asking for special, my lord.
Definitely no special privilege for a particular client.
Disconnection matters, my lord knows.
Disconnection matters, there are at least a few hundred disconnection matters in my list. Let me dispose of those first, the ones before you, pending before you. Then I should take up those matters first, Mr. Chakraborty. Why your matter? Give me one reason why your matter should be taken up. You're an industry. These people are individuals. Only that reason.
No, my lord, that is not the reason, my lord. My lord, we had filed.
Workers will suffer. They will suffer. What can be done? If you're not paying for electricity, workers will suffer. Your workers will suffer. No.
Security issue, my lord. My lord, security.
No, Mr. Chakraborty. I'm sorry.
I was only
I made myself very clear. Thank you.
Tender apology. Sir,